fast. The threshold inquiry is the document testimony.
There we go. So what came out?
Key audio USB that controls.
Did it look damaged?
No, this is like it was pulled out a little bit. I might have to restart the computer though.
But it's signaling on my participant screen.
Okay.
It's pulsing. So why don't we find out? Ms. Hall, if you're watching this on the YouTube feed, or can you hear us now, Ms. Hall?
I can hear you. Good morning, Judge. Yes, I can hear you.
And is that a change, or could you always hear us?
That's a change. I could hear you when you first came out and then you went away.
Okay, that's because Mr. Corn moved the monitor. All right. Thank you so much. Have a wonderful day, Ms. Hall. You all can be seated. Welcome to July. You better tell everyone when you can talk about the trial, that you were in a 2-month trial. Ms. Patillo, 2 days in a row late. What's going on? Yeah, well, that would be all of us. Don't be late on Tuesday, okay? We can't start. Everyone else was sitting around waiting for you. It's Friday. We are going to get through as much as we can today. Our lunch break will be starting a little before 12:30. Hopefully it'll just be an hour. But between now and then, let's hear some more of the state's evidence. Who is the state's next witness?
They called Lonnie Mills.
Should I remove my mask?
If you don't mind, that's very helpful for us. If you're comfortable with it, we'll be able to hear you a lot better. Thank you.
Thank you, Judge.
You're welcome.
All right, Mr. Mills, can you just please introduce yourself to the jury?
Hi, my name is Lonnie Mills. I work for Bank of America National Association.
Okay. And how long have you worked for Bank of America?
For 7 years.
And what do you do? What's your title there?
My title is I'm Assistant Vice President and I'm a Case Resolutions Associate.
What does that mean?
Well, I work in the litigation department for Bank of America. I work on a team where we manage cases that are in litigation, and we bring those cases to resolution.
Are you an attorney?
I am.
Okay. All right. But in the capacity that you work for Bank of America, do you are you a Bank of America attorney?
No. For my position at Bank of America, I don't work as a capacity of a lawyer, but I am licensed.
And where are you from?
I'm from Tampa, Florida.
Okay. And is that where you traveled from to get here today?
Yes, ma'am.
Okay. All right. And you have to go back to Tampa, Florida today?
Yes, ma'am.
Okay. Your flight's later on this afternoon?
Yeah, my flight is this afternoon.
Okay. All right. Just wanted to make sure that was clear while we're taking you now. So as a vice president, and in your capacity with Bank of America, did you happen to review any records for any type of litigation in this matter, again, the state versus Rooks?
Yes, I have.
Okay. And can you explain what you were able to review in your capacity?
I reviewed records involving the account of the defendant, a checking and savings account. I have viewed statements, signature card, and canceled checks.
Let the record reflect I have showed defense counsel has been marked as State's Exhibit 144. May I approach?
That's a big exhibit.
It's a big exhibit, Judge.
We're going through every page.
No, we are not. May I approach the witness?
You may.
Let the record reflect I'm showing the witness what has been marked as State's Exhibit 144. Mr. Mills, do you recognize State's Exhibit 144?
I do.
And how do you recognize State's Exhibit 144?
Well, I remember the size of it. I can see here clearly that this is the account records for the defendant, which is consistent with what I've reviewed prior to.
So let me ask you this question. Do you know what a certified record or certified business record is?
Yes, ma'am.
Okay. And for these records, have these records been certified?
Yes, they have, as certified as business records.
Okay.
I'll clarify.
For Bank of America?
Yes, ma'am.
Okay. And for the account of Mr. Hilius Rooks?
Yes, ma'am.
And I should say accounts, right?
Yes, ma'am.
All right. And do you mind just telling, did you certify these records?
I did not.
Okay. Did one of your colleagues at Bank of America certify the records?
Yes, ma'am.
All right. And when did they certify those records?
The certification was completed on March 15th, 2017.
Okay. And from your experience and knowledge, are records that are certified with Bank of America kept in the regular course of business?
Yes, our records that we produce as business records are records that are kept in our ordinary course of business. The information contained in those records is made at or near the time of an event that have occurred. And the information is input by a person who has personal knowledge of that event. And this is our regular business practice of how we keep records.
All right. The state would like to tender in State's Exhibit 144 into evidence.
No objection.
States 144 is admitted.
Thank you, Judge. All right. I'm going to ask you to just open up State's Exhibit 144 and to the first page. And can you, actually to the certification section, excuse me. Can you just explain which accounts were certified or which accounts are in these records, excuse me?
So the records that we produced under this certification involves two accounts of the defendant, and one is a checking account and the other is a savings account.
Do you mind letting the jury know what the last four digits are of that checking account?
For the checking account, the last four digits are 1265.
And the last four digits of the savings account?
For the savings account, the last four digits are 0908.
And I heard you say earlier that the records also include what we call a signature card.
Yes, ma'am.
What is that? What is a signature card? Or
when you open up an account with Bank of America, let's say a checking account, we have you sign a piece of paper so that we can identify what your signature looks like. You know, if we ever have to compare it to any other things that you've allegedly signed, that's what we have on file.
And do you know if this particular account had any other people besides the defendant, Mr. Hilius Rooks, associated with the account?
As far as association, I do know that when he set the account up, there was a power of attorney for a Cameron Rooks, but as far as anyone else being an account holder or anyone else on the account, no, it was just Mr. Hilius Rooks.
Okay. All right. If you don't mind going to the first statement in the first checking statement in the record, please.
Yes, ma'am.
All right. And what is that first statement date?
The first statement date is from June 19th, 2014 through July 21st, 2014.
Okay. And you may or may not know this. Do you know why Bank of America has only sent or started the record at this June 19th, 2014 date to July 21st, 2014? You know why that was started at that time period?
See something. No, I don't know why it started. I believe that the records that were requested were within that time frame. So that's what we produced.
All right. And can you just that first page there, and is that for the checking account?
This is correct.
Okay. Can you just explain and how much money was the ending balance for the July 21st, 2014 statement date?
Okay, so on these statements, we have a beginning balance and we have an ending balance. So the beginning balance on this statement was 1705.80. The ending balance at the end of this statement period was 1557.54.
And that's for June 19th, 2014 through July 21st, 2014.
That is correct.
What makes the balance go up and down?
Well, it depends. And with accounts, you have deposits that can be made. So, if you deposit money into an account, then the balance is going to increase. If you make if you have any debits or subtractions, or, you pull money out, withdrawals, then the balance decreases.
Did you see any deposits on this particular statement from June 19th, 2014 to July 21st, 2014?
Yes, ma'am.
All right. And can you let the jurors know what was deposited in the month of July?
Okay, so on the front of the statement, you have just the sum amount of deposits, which is 1694.74. But if you turn to the back, then you have a more detailed description of what deposits were made. And you can clearly see that there were 3 deposits made during that statement period in 2014, and they all appear to be direct deposits into the account.
Okay. Does the description tell you who made the direct deposit?
Yes.
Okay. And who made the direct deposit?
We see a description of Georgia Tech, which leads me to believe that the account holder was working for a company, Georgia Tech, and was getting their paychecks directly deposited into the account.
And then how much was that? How much were those individually were the direct deposit?
They ran in an amount of about in between 550 and 570. But specifically, I have 3 direct deposits here for various amounts.
And were you able to review most of the statements in this record?
Yes.
Okay. And did you see a pattern of direct deposits from Georgia Tech into the account?
Yes.
Okay. Was there a time period on when they were direct?
It appears
deposited into the account. Excuse me.
Yes, it appears that the direct deposits were twice a month or semi-monthly. So maybe like the 15th and the last day of the month, you see clearly throughout all of the statements that there was a direct deposit each time, which appears to be payday.
I'm going to ask that we go to the last statement in the record, please. And if Your Honor, I could publish, I have exhibit number 144A, which is, and I'll ask him the question.
Okay. Is what you want to publish part of 144?
It is, Judge.
Okay, so you can call it what you want while it's on the screen, but if it's within 144, I don't want us to give it a sub number or anything. I appreciate that the pages may not be numbered consecutively because it's a series of bank statements, but it's an excerpt from 144, which you're free to publish.
Yes, Your Honor.
Okay, so I have 2 statements. Are you referring to the checking account or the savings account?
Let's start with this checking account here.
Okay.
And it's also on your screen as well, so we can. You see right here. And just for if I ask you to circle something, you can actually tap the screen. There's a little pin at the bottom. It looks like a little pin.
Tap in the low, but first hit, what is it?
Mute, it says unmuted or stay muted.
Stay mute, because we can hear you just fine. And got it?
Got it.
All right, now press in the lower left-hand corner, tap in the lower left-hand corner, tap that little pencil.
All right.
All right, now your finger is that pencil.
Okay. Do you mind just explaining to the jury this last statement? What were the dates for this last statement and where can you find that here?
Okay, the dates on the.
Just make it big. Yeah, that's what
Yeah.
Big.
So the dates on the last statement are right here. Oh, uh-oh.
So it won't be big if you do full screen. So keep it,
There it is.
there you
Yeah.
go. Okay.
Perfect. Okay. And so where's that account number that we see?
Okay, so over here, you see the 1265, which is what I indicated earlier as being the checking account. You can also see the word checking right here to identify. That's the checking account, and then you have the dates.
All right. Can you just show the jury what the beginning and ending balance for this particular statement period was as well?
Okay, so when you look a little bit further down under the dates, you see account summary. Under account summary, here is the beginning balance, which is right there. And then when you look all the way down at the bottom, you see ending balance, which is right there.
And how much was the ending balance?
$9,256.86.
Okay. So were there any deposits and any other additions into this particular account for the period of January 20th, 2017 to February 15th, 2017?
Yes.
Okay. And you described earlier, if you go to the back page, which if you go to another page, you can actually see it broken down.
Yes, when you're talking about the deposits, as you can see under beginning balance, there are deposits right there. This amount, the 1969.31, is all of the deposits that were made on the account during the statement period. When you go to the back page, you can see the detailed record of what was actually deposited.
Okay, clear out. So we're going to clear out that for you. And I'll ask you, so at the top of the page where it says deposits and other additions, is this where you can see a breakdown of the deposits into the account?
Yes, ma'am.
And can you just explain to the jury what deposits were made into this particular account during this time period?
Okay, well, as I testified earlier, you have these Georgia Tech direct deposits. Looks like they come from work paychecks. So we have one here, looks like it was at the end of the month. And then we have another one like around mid-month. So those are two direct deposits from Georgia Tech, but then there's one in the middle. And the one in the middle states Bank of America ATM on 2/6/2017. This is a deposit, not a direct deposit, but a deposit of some money that went into the ATM by way of the ATM for an amount of $648.95.
Okay. Does it have a address there of which ATM that was deposited into?
It's not a full address, but it does state that it was a deposit made at Bankhead Highway in Atlanta, Georgia.
Okay. And can you tell, was it a cash deposit? Was it a check deposit? Do you know?
From this transaction, it appears to have been a check deposit. And the reason why I say that is because they have an identifying number on it. I believe that if it were cash, that it would say it was a cash transaction.
Okay. All right. And were there as a part of this record copies of checks that were that you also reviewed?
In the State's Exhibit 144, there is a tab for checks, and we have copies of checks.
Okay. Can we go to 144? Wait one second. All right. And were you able to review those copies of checks that were deposited into the account?
Yes, ma'am.
Okay. And how long was the was the time period for the checks that you reviewed? Does that make sense?
I reviewed checks. It's the same period for which you are requested records. So from 2014 to 2017, I reviewed checks within that full 3 years.
Okay. All right. And were you able to, once you reviewed the checks that were along or a part of this record, were you able to figure out which check was deposited, or look at which check was deposited on February 6th of 2017?
Yes.
Okay. And how were you able to do that?
Well, first of all, I look at the date. You see the deposit date was February 6th, 2017. So I look at all of the checks we have in States Exhibit 144, and I go back to February of 2017. And what I find here is a check dated February 1st, 2017 in the amount of $648.95.
And can you was this the check on the screen that you found that matched up with the check that was deposited into Mr. Rooks' checking account?
Yes.
Okay. Do you know, and who is that check made out to?
The check is made out to Madatha Rooks.
Okay. And what company is that? Was it from?
The check was created by Mass Mutual Financial Corp.
Okay. Do you know what kind of check this is?
Being that Mass Mutual is a life insurance company, this appears to be some type of maybe retirement or pension check.
Okay. Question. This check is made out to Miss Madatha Rooks. How is this check able to be deposited into Mr. Hilius Rooks' account if he's the only one on the account, if you know?
Interesting question. But I do have a record of the back of the check as well. And on the back of the check, there is an endorsement. And it appears to read Madatha Rooks in print, and then there's a signature above that.
And what date did you say that this check was deposited into the account?
From the records and what I can see, that even though the check was dated February 1st, the deposit shows clearly on the statement that it was deposited on February 6th.
Okay. All right. Did you have a chance to review were there any other Mass Mutual checks paid to the order of Ms. Madatha Rooks deposited into this Bank of America account?
Oh, yes.
Okay. Were you able to gather a number or amount of checks deposited into the account?
Yes, I counted them.
Okay. I'm sure it was a tedious task. How many checks were deposited into Mr. Hilius? How many Mass Mutual checks paid to the order of Ms. Madatha Rooks were deposited into this Bank of America account owned by Mr. Hilius Rooks?
Between that time period of 2014 and 2017, I counted 28 checks.
Okay. And were they all the same amount?
Yes.
Okay. And did they all come, or what was the time period in which the checks were written, or the date on which they were written? Was it the first of the month?
Yes, it was the at the beginning of every month. These checks were deposited.
Okay. And were you able to do a calculation of how much those 28 checks added up to that were deposited into Mr. Hilius Rooks' account?
Yes, it's an amount over $18,000.
Okay. All right, nothing further.
Mr. Korn, do you have questions for Mr. Mills? all the way from
Very
Tampa.
briefly, Your Honor. Bring up, 144C. We're back up. Good morning, sir.
Good morning.
Looking at Exhibit 144C again, the back of the check that you were just shown, you have two signatures on there, correct?
No, what I see is a printed name and a signature.
Really?
Can you rotate it, please?
It could be two signatures. It could be, because I can't read the other.
But Mr. Mills,
I
what
didn't-
you're referring to as the signature would be the one on the top, and then the one below is what you're saying is the printed name.
Correct.
Okay.
But I will represent to the court that the printed name could be evidence of someone's signature,
Right.
because that's how some people sign.
Is it possible that a different person signed below than signed
Objection.
above?
Objection, Spec.
Sustained.
It's possible.
Okay, good to know. Don't ask questions that start with, is it possible, if you don't have an expert on the stand.
So,
I assume you're not a handwriting expert, if there is such a thing.
no,
Okay. Thank you. No further questions.
thank you.
You good?
I'm good. Thank you, Judge.
Jurors, questions for Mr. Mills? Yes? Okay. It's good. It makes Deputy Gordon get up. No? Or a future witness? No. Okay. Counsel? All right, can you, Mr. Korn, the Elmo, I just found the instructions for it. We got a couple more questions for you. Should be on the side there, gently. All right, is there an Elmo in there?
There is, I believe.
It should be like a whole platform should slide out. There you go. Okay. Don't pull too hard. Some cords are moving. All right. Can you please, Mr. Mills, look in your binder for other examples of signed checks?
Beyond that, I'm not sure I am.
Oh, is there like an on button or anything?
Here. But I don't know what it's connected to.
It's on. That's good. I'll work on the rest of that. I'm going to see if I can figure that out. So, Mr. Mills, the question is, were there other checks from Mass Mutual? Is that Mass Mutual that were endorsed and the jurors would like to see the backs of those? So if you can find other, you mentioned there were a host of Mass Mutual checks. So we're looking for Mass Mutual checks. And if the back side of the check is available, the jurors were interested in seeing what those looked like. And if we can, you should be looking for them as well, or that's the only binder.
I do have another binder, Judge. I mean, but I didn't know if you want.
However we're going to do it, they need to end up on the Elmo if we can get the Elmo working.
You can take them out.
Yeah, I can
Okay.
help. Let's keep it out. So we can
With
see
one
it.
on top.
Mass Mutual.
Yeah, that's it. That's Mass Mutual. Side.
All right, what do I do? Green button. All right. If you find one, it should work now. I think that's the L is on your big screen. Is it kind of white and glary?
Yeah.
All right. Put your hand under there.
Not yet.
It's your head. You got it reversed. Ah! Get out of there.
That's not right.
So there's probably a reverse, a button. There you go. Excellent. Yep. Good team effort, huh?
I don't think I want to see my hand again.
Korn McBurney. All right, we don't need to do 100. Let's do whatever you got,
Whatever I have, or,
whatever's in your hand.
okay.
So what we're doing now, Mr. Mills, you have extracted from 144, the certified records from Bank of America for the bank account we discussed, other Mass Mutual checks. And you shared with us that the one that you were asked about had 2 signature lines, and there was a discussion about it, one a printed name and one a signature. The question from the jurors is, were all of the checks, and we don't need to go through all of them, but were at least some of the other ones, because the jurors will be able to go through this binder if they want to, similarly dual endorsed like that. So why don't you put a few other exemplars up? And you're going to need to move, you can move the camera piece moves as well.
Oh, it's back.
It also has, it's on
Is
a
that-
swivel up top. Well, it is backwards.
It's back, there's probably a
Reverse.
reverse.
The controls are going to be on the device in front of you and not with me.
Not backwards.
It's not backwards there.
Okay.
Don't mess with it. So that's a different check.
Yes, and so I'll clarify my testimony for the jury. Now that I've looked at the back of several checks, I see that there are 2 names, and as the judge described, dual endorsement. So it appears to be a signature from one person on the first line, and on the second line, it appears to be another signature, that of Miss Madota Rooks. Of course, that's the name I read anyway. But on all of the checks, except for one of them, you see the dual signatures like that on the back.
And the one where there's only one signature, is it what looks to you to be Madotha Rooks, or is it that other signature?
Actually, that one check there's no signatures on it that I see.
It was unendorsed yet still deposited.
Unendorsed.
Okay.
Yes, Judge.
All right. So for the ones you reviewed, they're all dual endorsement except for one, which was non-endorsed.
That is correct.
Okay. Do you have any follow-up based on those questions, Ms. Russell?
Can I check my notes?
Sure.
Want me to keep this down here?
Nope. Can we just observe how impressive it was that on the fly, I got the Elmo thing working? Yeah, it's from an email that was archived. It was from March of this year, but there it was. Boom, Elmo.
Mr. Mills, do you know, or can you tell by looking at the back of the checks on Mass Mutual, if the same person signed these checks or not?
Judge, I think that's the same speculation.
It is. So I will, that sustained.
Were all of the checks that were deposited into Mr. Rooks' account, the Mass Mutual checks, excuse me, were they deposited at an ATM?
When I look at several of the statements for the checking account, I see a consistency in ATM deposits for the amount of the $648.95. Just checking a few more here. I can't say that all 28. I mean, I'm sure.
Well, and you don't need to look at all 28, but of the few you found, how do you respond to Ms. Russell's question?
Of the few I found, it is consistent in the records that $648.95 was deposited at an ATM, and a lot of them are at the Bankhead Highway.
Great. Mr. Korn, do you have any follow-up for Mr. Mills?
Quick question, do you have the date of the check that wasn't endorsed by either party?
Yes.
Can I turn the Elmo off?
Sure.
Great. No, touch nothing. Thank you.
The date of that check was October 1st, 2016.
Okay, thank you. No further questions.
Thank you.
Mr. Mills, you can leave that binder there. I'll let the state manage that. We appreciate your time and safe travels.
Thank you. Happy 4th, everyone.
You too. Welcome to July. Next witness.
State Tom O'Grady.
Thank you, Ms. Hilton.
No. Mass Mutual.
Good morning, sir.
Thomas O'Grady.
Mr. O'Grady, if you're comfortable testifying without your mask on, it'll make it easier for us to hear you.
Thank you.
Thank you.
Okay, Mr. O'Grady, will you please just introduce yourself to the jury?
My name is Thomas O'Grady. I'm an investigative attorney for Massachusetts Mutual Life Insurance Company in Springfield, Massachusetts.
And can you just speak up just a little bit so the court reporter can hear you? Thank you. And you said that you're an investigative attorney
Yes,
for Mass Mutual.
Massachusetts Mutual Life Insurance Company is also called Mass Mutual.
Okay. What does an investigative attorney do for Mass Mutual?
I've worked for the company for about 10 years. I started out as just an investigative consultant. For the last, I think, 3 years, I've taken on the role of attorney advising our disability income folks on contestable claims, rescissions. I manage outside counsel in litigation. I direct investigators in their investigations involving the line of business that I deal with. And then for about 15% of the time, I conduct investigations for the company.
And just explain to the jury, what is Mass Mutual?
Mass Mutual is a life insurance company. It's been around 160 years or so. It sells life insurance, disability insurance. It sells annuities. It used to have a retirement services division, which is sold last year, I believe, to Empower. And as I work in the special investigations unit of the company, there's about 13 investigators, and we investigate any indications of fraud or red flags regarding incidents in the company.
Okay. What were you contacted by investigators here in Fulton County about a Medotha Rooks?
Yes, I was.
Okay, and can you just please explain to the jury what was that? Did you do an investigation on the Medotha Rooks?
Yes, we received an inquiry from the Atlanta Police Department, Detective Leon, and I can never pronounce his last name, so I apologize. He asked for information regarding the pension plan. He had found a Mass Mutual document in an apartment he was conducting an investigation in. I informed him we needed a written request, so he sent a written request to the company with some questions that they wanted answered, and I researched the file and responded to his questions.
And can you just please explain to the jury, was Miss Medotha Rooks receiving some sort of payments from Mass Mutual?
Yes, she was married to Jimmy Rooks, who worked for I believe, the Atlanta Housing Authority. He retired in 1993. At the time of his retirement, he elected to take a pension where if something happened to him, his wife would then get the same amount of pension. It's a one-time selection you can make where, and you can, the pensioner can determine whether they want their beneficiary to get the full amount, a half amount, percentage, or whatever. And he elected to take the full amount and she would get the full amount. So they reduce it a little bit for the actuaries deal with that to make sure the value comes out to be the same. So then Jimmy collected until Mass Mutual received notice of his death from Medotha Rooks in, I believe, 2012. And as the beneficiary, she was then entitled and started to receive the pension payments that he was receiving while he was alive.
And how much were those pension payments that Ms. Madota Rooks received starting in 2012?
I believe they were $648.95 or thereabouts.
And can you explain to the jury how Mass Mutual sent those pension payments to Ms. Madota Rooks?
Sure. The pension payments are sent to the address of record in the form of a check.
I'm going to show you an excerpt from State's Exhibit 144. Do you recognize State's Exhibit, that excerpt from State's Exhibit 144?
Yes, it looks like our standard checks that we use for this purpose.
Okay. And you said that those checks were mailed to Ms. Madota Rooks? Okay. Where were those checks mailed to?
The address on the check is 1251 North Avenue Northwest, Atlanta, Georgia, 30318-6505.
Okay. Are the Mass Mutual benefits transferable?
No, not based on, not this pension plan, not based on the election that Jimmy Rooks made back when he took out the retirement in 1993. He only named one beneficiary, and that was Madota Rooks. After that, the benefit terminated.
Can I have one second, Your Honor?
You sure can.
Oh. So when did, you said that the payments, those pension or benefits started in 2012 after Mr. Rooks, Jimmy Lee Rooks passed?
Yes.
Okay. When did the Mass Mutual payments or pension benefits to Ms. Madota Rooks, did those end?
They would have ended on the first of the month after her death.
Okay. And do you know when Ms. Madota Rooks passed?
I believe she passed away in February of 2017, so it would have stopped as of, the next payment would not have been issued, or if it was issued, it would stop payment on it.
Okay. Thank you.
Mr. Korn, do you have questions for Mr. O'Grady?
Very briefly, Judge. So if Ms. Rooks wanted to transfer the benefits to her son, she couldn't just go to Mass Mutual and say, can you issue the checks to my son?
Correct.
However, if she wanted to give him the money anyway, she could accomplish that by simply endorsing the check over to him, correct?
My understanding is she could endorse the check.
I mean, once it's in her hands, it's her money, right?
That's my
She
understanding.
can do what she pleases, correct?
Correct.
And one way to accomplish that would be to just endorse it over to him and have him deposit it, correct?
Possible, yes.
Okay, thank you. No further questions.
Any follow-up?
No, Your Honor.
Questions from the jurors? All right, Mr. O'Grady, thank you for your time.
Thank you, Your Honor.
Appreciate your effort to be here. We're flying through witnesses. Next.
Your Honor, please call Mr. Vincent Williams to the stand.
I'm sorry, who's the witness?
Vincent Williams.
Vincent Williams, Vincent, Vincent Williams, Williams, MS.
And good morning, Mr. Williams.
Good morning.
How old are you?
58.
And do you work?
Yes.
What type of work do you do?
Mail service.
Did you say meal service?
No, mail.
Mail service?
It's mail.
Like you work for the postal service?
Not really the postal service. It's like a postal service, but it's like a private company.
Like UPS?
No, it's like a bulk mail center, but it's a private owner. He just got a company warehouse, and we just do the mail
Got it.
through the post office.
Okay.
And how long have you been working for this company?
Almost a year.
And what type of work did you do prior to work for this company?
I used to work at a law firm, Kilpatrick in Townsend.
And what did you do for Kilpatrick and Town?
I was in facilities.
Facilities?
Yes.
And how long were you with them?
I was there about almost 20 years.
And do you live in Atlanta?
Yes.
What part of Atlanta?
Fulton, Southwest.
Southwest. And is that the area that you grew up in?
Yes.
Do you have any brothers and sisters?
Yes.
How many?
I have 2 brothers and 1 sister.
Who are your 2 brothers?
Jimmy and Anthony. Jimmy Williams and Anthony Williams.
And do you know Mendoza Rooks?
Yes.
How do you know Mendoza Rooks?
She's my aunt.
And who is her sibling, your mother or your father?
My mother.
And how many siblings did your mother and your aunt Mendoza have?
Might been 4 apiece, 4 brothers and 4 sisters. Might been not for sure how many. Might be about 7 or 8 all together.
So you think it's 8 total or 10 total?
About 10 total.
And where is your mom and Ms. Mendoza originally from?
Ryan, Georgia.
Ryan?
Yeah, Ryan. Rane.
Now, out of all of those siblings, those 10, how many of them are still alive?
No.
What was your mother's name?
Lottie Williams.
Lottie?
Yes.
And did Lottie and Ms. Mendoza have a sister named Osadell?
Yes.
And like you said, Osadell passed on as well.
Yes.
Now, where did Ms. Mendoza live?
She lived on North Avenue.
And since you've been alive, has she always lived on North Avenue?
Yes.
And did she work?
Yes.
What type of work did she do?
I think she was a retired school teacher.
Now, when your aunt was alive, would you see her?
Not occasionally, but often. Like I say, when I work, I used to bring like salads home, and I used to drop salads to her so she can have something to eat.
And you said you would bring salads to her?
Yeah, from work, like it'd be like a salmon salad with fruit or cookie or brownie with it.
And we'll get to that in a moment, like that time frame when you would bring food to her. What was your relationship like with Miss Mendoza?
It was good.
Tell the jury a little bit about your aunt. What type of person was she?
She was a good aunt. She loved food. She loved sports. My nieces played basketball. She loved to go to the games. And to remember other aunt, they'll go traveling or go out of town or go eat or come back. So she was a good aunt.
So she lived an active life.
Yes.
And was she married?
Yes, she was married to my uncle, Jimmy Rooks.
And then did they have children? Jimmy and Mendoza.
Yes.
And who were her children?
Allison Rooks and Hillis Rooks.
And do you see Hillius in the courtroom today?
Yes.
If you can identify him by article of clothing he's wearing.
He got on a blue suit,
Anything else about him?
light skin and bald head.
Yeah, let the record reflect that Mr. Williams has identified Mr. Rooks.
Vincent Williams has identified Mr. Rooks.
Thank you.
Mr. Williams, are you the oldest or youngest? Where do you fall with your 3
I'm
brothers?
the youngest.
You're the youngest.
Yes, ma'am, sir.
Thank you.
And what is your relationship like with Hillius?
Oh, good.
Prior to today,
Yes,
what
sir.
was the last time you've seen Hillius?
I've been years. I haven't seen Hillis, I think, since he tried to call me when my aunt passed, but I tried to call him, but his phone had died out. So I called my brother. He the one told me my aunt had passed. So I haven't seen Hillis since Super Bowl, since he came over, watched the Super Bowl.
Okay, and that'll be right before your aunt passed away?
Yes.
Okay, we're gonna talk about that as well. What about when was the last time you spoke to Hillius?
It's been a while. I haven't spoke to him.
Now, when it came to your aunt Medotha, would you ever go over to her house?
Yes, I'll go over every now and then. Like I said, I'll just bring the food and I'll just go to the door. She just come to the door, or he'll just come to the door, or he'll come outside and receive the food.
And this time period, when you're talking about you would bring her food over to the house,
Yes.
was this after Mr. Jimmy Rooks died or before Jimmy Rooks died?
Before.
Okay, this is before he died.
Mhm.
Now, do you remember when Mr. Jimmy Lee Rooks passed away?
No, I can't recall.
Now, you said that you would bring Miss Medotha food before Jimmy Lee Rooks died.
Yes.
So we're gonna talk about that time period before Mr. Jimmy Lee Rooks died. When you would go over to the house, would you go inside the house?
No, she didn't meet me at the front door.
When do you think was the last time you actually been inside of your aunt's house?
It's been some years.
Would it have been your cousin Addison? He passed away, right?
Yes.
And when he was he living at home before he passed away?
Yes.
Had you ever gone over to the house to visit him while he was at home?
Yes.
Would the last time that you've been at your aunt, inside of your aunt's house, be around the time that Addison was alive?
Yes, I'll just go that way. Allison used to be around. We just get together, go to the park, come, I drop him back at the house and I go into the house. Or we go fishing. I pick him up, we go fishing.
Was that before he got sick?
Yes.
After he got sick, would you ever visit him at your aunt's house?
Yes.
And would that have been kind of the last time that you ever been inside of your aunt's house when Addison was at her living at her home sick?
I can't recall.
Whenever you would have been inside of your aunt's home, how did she keep her home?
Oh, clean.
Now, when your aunt was alive, Aunt Medotha
Yes.
was alive, and that period after Jimmy Lee Rooks passed away.
Yes.
So between the time he passed away and the time Medotha passed away, did any of your aunts or uncles spend any time with Miss Medotha?
Yes, my aunt Osadale.
And do you know how often your aunt Osadale would spend time with your aunt?
I think she might go over there twice a week, something like that. Maybe once a week or twice a week she'll go over there.
To your knowledge, was there ever a time where your aunt Osadale stopped going over to visit with your aunt Medotha?
No, I think because she used to be, well, her cousin had a dog, but the dog was like a puppy. She wasn't really scared of the dog, but the dog like play for jump on us. But she'll call my cousin. He'll put the dog up, and she'll keep going. She'll call him in there, and he'll go over there. She'll go over there.
And when you say your cousin, you mean Mr. Rooks?
Yeah, I'm sorry, Mr. Rooks.
No, that's okay. I just want to make sure I understood.
Yeah, I'm sorry, Anna. So I used to call him cousin.
Cousin's fine. Thank you.
So although he would put up the dog,
Yes.
did you ever know your aunt Osadale stopped going over there because of the dog?
No.
No, you don't know, or no, she didn't.
I mean, she didn't. She did not stop going because of the dog.
Now, during this time after Mr. Rooks died and before and before Miss Medotha died, did you know about the care of Miss Rooks, like how she's being taken care of?
No, my cousin, he just tell us she doing okay, she fine. She might have a little dementia, but other than that, he would tell us she was fine.
He would tell you that she had dementia.
Yeah, something like getting dementia or develop, dementia.
Did you ever have an experience with any of your other family members suffering with dementia?
No.
Now, when he was telling you that she was kind of suffering from dementia, did you ever offer to help with his mother?
Somewhat, yes. And then I was saying, well, maybe he can check into somebody, maybe can help her, or I don't know about law. She has to sign a piece of paper, agreement for him to get authorized to get help. I'm not for sure.
But would you suggest things to him?
No,
So
not really just, but I was asked, yeah, sort of just, but I asked him, can he call somebody or maybe he can check into it
So you
to a
would
place.
I'm sorry.
No, go ahead.
So you would ask him if he wanted to get someone to come in and help.
Yeah.
And what would be his response to you?
He said he's probably just check into it, call around and check into it and see.
Do you know if he ever did that?
No, I don't know.
During the course of this period of time, did he ever tell you that he found someone to help take care of his mother?
No, I don't know how to call.
Did you ever offer to help take care of your aunt?
No, not really. No.
When you say not really, what do you mean?
I mean, as a nephew, I know I couldn't do it because I'd be at work. I couldn't really take care of, be like on the weekends or something. I couldn't really volunteer for nothing.
Did you ever offer to go over and tell your cousin that you would help him clean up the house?
No.
Taking you to February of 2017. Prior to your aunt's death, you said the last time you saw Hilius was on Super Bowl Sunday.
Yes.
Okay, how did you come to see him on Super Bowl Sunday?
Well, I called him and asked him, do you want to come over to watch the game? And he said he'll be over. He came over he left before halftime.
Okay. And how far were you living from his home?
We about like 15 or 20 minutes away.
When you say his home, are you referring to, when you're thinking about 15 minutes away from where your aunt lived? No, I know where you stay, your home, but when you're saying your cousin's home, are you referring to where your aunt stayed?
Yes.
Okay.
Okay. And so do you live in the same house now that you lived in back in 2017?
Yes.
Okay. And when he came over, you said he came over and left during halftime.
Yes.
About how long was that? Like, did he come off the beginning of the game and then left at halftime?
Yeah, he came over to get on the game and then left before halftime.
And when he came over on that Super Bowl Sunday, did he ever tell you the condition of his mom at that time?
No, all he said before he came over, he gonna make sure she had something to eat. She was good, and he was gonna come over and watch the game.
During that time, had he told you that he had to pull her off the couch?
No, I can't recall. No.
And did he tell you that at that point in time she was laying on the ground after he had pulled her off the couch?
No.
So the only thing he told you that you remember is that he had to go get her some food.
Yeah, with her food before he left the house.
Oh, he gave her some food before he left
Yes.
the house. Okay. And at that point, did you think that your aunt was okay, but just at home eating, waiting for him to come home?
Yes.
Had he told you at that point in time he had not spoken to his mother or heard his mother speak in about 2 days?
No.
Now, you said that he left the house around halftime.
Yes.
Judge, I'm gonna object. She is leading the witness quite a lot here. I've let it go for some, but it's time for her to ask questions and let him answer them.
Okay, I'll keep listening. And if I think they are leading as opposed to they're providing a framework, as opposed to suggesting the answer, then I'll ask Ms. Hilton to rephrase them. I haven't noticed that, but I'll listen with a different ear.
Now, once he left at halftime, had you ever spoken to him again that week?
No.
When was the next time, after he left from Super Bowl, when was the next time that you spoke to, if you did, Mr. Rooks?
I haven't spoke to him.
You haven't spoken?
No.
And when was the last time that you actually saw your aunt Medusa alive?
I've been seeing it was some years. Like I said, I never been by the house, so it's been some years since I really seen her live.
And to know about her, would you just ask Helios about her?
Yes.
And he would tell you how she was doing?
Yes.
And based upon what Helios told you, did it ever cause you any room for alarm that she wasn't being treated very well?
No.
Of course, adults are wrong. No further questions.
Mr. Korn?
Other than your aunt, do you know of anyone else, to your knowledge now, I'm not asking you to guess.
Mhm.
Do you know of anybody else that offered to help and come over to spend time with
I
Medusa?
can't recall, sir. I heard some people offer, but I can't recall who the people was. I can't recall.
Were you in their presence when they offered, or did somebody tell you
Somebody
that?
was telling me.
Okay, thank you. No further questions.
Any follow-up?
None for the state, Your Honor.
Any questions from jurors for Mr. Vincent Williams? Oh, seeing none. Mr. Williams? Oh, yes. Okay. Raise your hand when I say any questions. It's all right. Okay, go for it. Thank you. Counsel? We're not ready. You can go. You good with that? Okay. Sorry, short break for you guys. Got to sit back down. Mr. Williams,
Yes, sir.
one more question.
Yes, sir.
Did your cousin, Mr. Rooks, tell you where he was going when he left around halftime of the Super Bowl?
Oh, yes, sir. He said he was going home, back home.
And by home, what does that mean to you? Where your aunt stayed?
Yes, my aunt stayed at.
That's where you understood Mr. Rooks to live?
Yes.
Okay, you thought your cousin and his mom lived in the same place?
Yeah.
Okay, thank you. Follow up, Ms. Hilton.
No.
Mr. Korn.
No, thank you, Your Honor.
All right. Thank you, sir. Appreciate your time. You have a good fourth.
All right.
So, ladies and gentlemen, knowing that we won't break for lunch until 12:25-ish, do you want to have a short morning break now since you were kind of standing up going like that? I'm going to try to keep it to less than 10 minutes. But like I said, if Deputy Gordon comes in there too soon, close the door in his face, push him out, and let him know when you're ready. Please don't talk about the case during your break. No outside research. Feel free to use that hallway to stretch out, do a few laps.
All right.
All right, before we break, anything from the state?
None from the state.
You've got witnesses to get us through lunch? Okay. I'm mildly convinced by that. Mr. Corn, anything from the defense before we break? I'm sorry, Ms. Jenks, it just, when we came back from that, all the jurors were like, oh, we need to stand up. And so I figured we'd take the break now. Mr. Corn, I need you to tell me, if you haven't already told Ms. Hilton, she'll get to hear it as well, what your concern is, area of concern with Dr. Holmeyer, so I can be thinking about it.
In her report, she reaches the conclusion that neglect was the cause of Maydover Rooks' death. She is not a forensic pathologist.
Did she conduct a?
Indeed, she did not conduct any. She did not conduct an autopsy. No, it's not that. She reviewed the reports of Detective Leon Packer and Dr. Henninger.
Okay, before you go any further, because it sounds like there's a lot she reviewed, were you intending on asking Dr. Holmeyer that kind of, it's not quite ultimate issue, but that does seem to be Dr. Holmeyer getting pretty far into things?
I don't have to answer about whether or not this was consistent with neglect or the elements of neglect be consistent with her death. But I do plan on asking were the elements that she saw consistent with neglect.
Okay.
I do plan on doing that. I don't have to ask them.
Okay, you because we're talking past each other here a little bit. I want to avoid a blow up during her testimony, and you'll be able to perfect your concern on the record, and Ms. Hilton can provide assurances or lack thereof, and I'll work through it. But I'm hearing Ms. Hilton say she intends to ask Dr. Holmeyer all about are these hallmarks of neglect, was this present, et cetera, but not, do you believe, doctor, that the neglect that Ms. Madatha Rooks was experiencing caused her death? I'm not saying you can't ask it, but if you are, then we need to engage because that what I'm hearing from Mr. Okay, all right. I'll be thinking about that.
Judge, in addition, I think just asking whether this was legally neglect, I think that's a legal, the ultimate fact for the jury to decide. I don't know if I mean, if she's going to talk about the hallmarks of neglect, I think that's within her purview and her expertise. But to go that last step, say this was neglect.
Well,
legally, I think that's going to be a problem. And
I don't want to use up our break on this, but there's a difference between a medical professional saying this was medical neglect, which I assume she's saying she ought not to, and I would prohibit her saying that's legal neglect. Now, the dilemma you've got is that there aren't a lot of words to substitute for neglect. And so we may need to make sure you're given the opportunity, or I say to the jury, you're talking about medical neglect, not the legal definition of neglect, because I'm not going to prohibit her from using the word neglect.
of course, that's her area of expertise.
Exactly. And so now that I better understand that, for a medical professional to say, it's my view from reviewing the records, et cetera, what I know about human physiology, et cetera, is that the conditions of neglect in which she was living, medical neglect, caused her death. We'll see. We need to talk about that, but it's not neglect in the legal sense.
Correct.
Okay. All right. We'll revisit it, I promise. Enjoy what remains of your break.
You're right. We only have about 1 minute. Dante Thompson, depending on where we are, depending on when we take our lunch break, Dante Thompson may have to come up to get us to the lunch break, or if we stop slightly earlier than your expected time. Because I only have 3 more witnesses. Ideally, I'm trying to get in before lunch. I don't know if it's going to get us. They should get us to the 12:30 hour, but just in case, Dante may be that last in that group, or we can stop at that point and pick up with Mr. Thompson after lunch.
2 things. Let's see where we are. Please don't extend your other witnesses unnecessarily. If we have to end a little early, we'll end a little early. It may be we have our let's talk with Mr. Thompson outside the presence of the jury. They start early, but we don't start. They start their lunch early. Okay? All right. See you soon.
Thank you. Say again. Ideally, I'm trying to get these three people out. It'll be Anthony, Cameron, and Will. I did. She's not there.
So what was up with the parade of kids going through?
I guess the junior deputies, they just wanted to take a peek.
Okay.
I thought it was gonna sit down, but still like.
They've been fine, although some look real young.
Yeah.
Boy, I hope we didn't put up one of those pictures or anything. It just was, at first I thought they're coming in to sit down. They kept going through like, why not use the hallway? But it was just a little peek of like, here's court.
I think they got a graduation at 11, so.
Cool. All right, so they have places they need to be.
Yeah.
So there's a special treat for us back in the office from Judge Ingram.
What's your question? Oh, Krispy Kreme. Donuts.
Bring it up for everybody. Not enough there, but. Just gonna go home.
I'll be right back. So, exactly, I'm like. So, you said she looked in it, she reject. She's. Right. No, can't do it. Again. Anybody.
Yeah. And it happens also to be the truth. They come into the office over the weekend. We'll go through the trades. We don't have to. I mean, I made text to the. We have any suggestions?
Yeah.
I don't know.
I mean, as long as.
I gotta check with my wife. So she can read.
Yeah. I actually do Mondays. The rest of it.
Oh, you're going to get your kids.
They're coming from the bus.
Yeah, of course you gotta do that. Of course.
Yeah.
Long time, sure. Kids, my parents gleefully sent me to camp for a month, and no longer, 5 weeks.
Yeah.
I couldn't wait to get us out. Actually, we lived in Chicago, but they sent us to Camp in North Carolina.
Oh, which one?
Seagull and in Iraq near Newburgh. Off on the coast, near the coast.
Oh.
It's sailing.
You see there?
Yes.
Yeah.
First year I was living in DC actually, and I drove that year on a bus.
How did they know that actually?
Well, I was growing up, I was born in DC in that first year. I was there and a lot of kids there.
Oh, okay, so you just continue to go.
Yeah. I was about as far away as anybody.
Yeah. No.
These stupid sideways reports. These stupid sideways reports. There's no way to turn this. Yeah. Yeah, I mean, I can see why you want to know, but we can't do it right now. Again, we have a goal. It's not disclosing everything. It's a question of, if God willing, you're free man on the other side of this. But today is not the day.
Court of order.
Are we ready, Ms. Hilton?
Yes, sir.
Mr. Korn,
Yes, Your Honor.
let's bring the jurors in, please.
All right,
Thank you. You all can be seated. If you don't mind, no, if you don't mind grabbing that and giving it to Ms. Hilton, I just want to make sure all the exhibits get to where they need to be. Thank you so much. All right, Ms. Hilton, while you're multitasking, who's your next witness?
Sir, they call Anthony Williams to the stand.
Do you swear and affirm that today's testimony? Take your name and spell your name in the microphone.
Anthony Williams, Anthony Williams, Williams.
And Mr. Williams, if you want to, if you're comfortable, you can take your mask off if you choose to, okay? And let me ask you, so do you want to be here today?
No,
And is your brother, Mr. Vincent Williams, who just testified?
yes.
All right.
I'm sorry, Mr. Williams, I need you to get a little closer to the microphone. That chair's heavy. It has no wheels. So if you heave it, you'll get forward. That way we'll be able to hear you. Thank you so much.
And is your cousin Hilliard?
Yes,
And do you still have a relationship with your cousin, Mr. Rooks?
yes,
And do you speak with your cousin?
occasionally.
All right, when was the last time you spoke with him?
A minute ago out in the hallway.
And prior to that?
Well, I can't remember.
Was it sometime in this year?
Yes,
So you still speak with him and have a relationship?
Yeah.
And is that one of the reasons why you don't really want to be here today?
no, I just don't like being away from home, court procedure, the delay, being here all day. It's
Okay.
just that.
Well, we'll get you out here when we take.
Okay,
And how old are you, Mr. Williams?
62.
And do you work?
No,
Why not?
I'm retired. So,
And where did you retire from?
well, my last job was Hormel Foods.
Okay.
Uh,
And how long have you been retired?
God, 20 years, 10 years.
To about 20 years?
Yeah. Mhm.
You're gonna have to answer yes or no for me?
Yes,
And do you take care of your grandkids?
yes.
How many grandkids do you have?
4,
And what's their ranges?
12. My oldest girl is 12, grandchild 12, 7, and I have 2 boys, 6 and 3.
And when you say you have 2 boys, you're talking about all of your grandkids?
Yes, grandkids.
And do they live or reside with you?
Part-time,
Part-time. How long have you been taking care of your grandchildren?
12 years.
And do you live in Atlanta?
Yes,
What part?
Northwest Atlanta.
And did you live near where Mendoza Rooks lived?
Yes,
How far did you live away?
probably 10, 15-minute drive.
Now, do you live with your brother Vincent?
Yes,
And how long have y'all lived together?
30 years or so.
And besides Vincent, how many other siblings do you have?
2 more, older brother and a sister.
Now, we just talked about Miss Mendoza. Is that your aunt?
Yes,
And is your mother Lottie as well?
yes.
Now, taking you back to 2017. When was the last time you had seen your aunt?
Oh, it had been a while. I can't say. It's been months, maybe a year or so.
Back when she was living,
Mhm.
how often would you go and see her?
It was rare occasionally, maybe once a year or twice, something like that. Every now and then,
Say that again.
every now and then.
And
not-
why
not
was that?
frequent. Well, I was busy taking care of mine and I wouldn't have transportation, so
You didn't
I
drive?
don't know.
Now, do you know a Jacqueline Williams?
Yes,
How do you know Jacqueline?
she used to date Hilliard. She was my ex's friend and sister, grew up in the neighborhood.
And she was of no relation to you, right?
No.
Okay. Now, did there come a point in time where your cousin Addison passed away?
Yes.
Do you remember around when he passed away?
Oh, it's been 30 so years, 40 years.
Think so.
I'm not sure. It's
Let me
been a
ask
long
you.
time.
What about your uncle Jimmy? Do you know, did he pass away?
Yes,
Who passed away first, Addison or Jimmy?
Addison.
And with Mr. Jimmy Rooks, do you know about when he passed away?
I can't remember the dates, but it's been a long time.
Now, I'm gonna kind of focus on the years after Jimmy Lee Rooks died,
Mhm.
but before Ms. Mendoza died, okay?
Mhm.
Would you see Ms. Mendoza during that period of time? So after Mr. Rooks died, but before she passed
Occasionally,
away, occasionally? And that was still like maybe once or twice a year.
yeah.
During that time, do you know, outside of Helios, was there any other family members that went over to Mrs. Rooks' house?
Yes, Osadale, her sister Osadale.
Now, with Osadale, do you know, was she older or younger than Miss Mendoza Rooks?
I'm not sure. She may be younger, a couple of years. I'm not sure which one was the oldest. I'm not sure.
What about your mother, Lottie? Was she older or younger than Mendoza?
Younger.
Younger. Now, between Osadale and Lottie, who was older or younger? Do you know?
I think Osadale, but I'm not sure.
Okay. So Osadale out of the three would have been the baby out.
Mhm.
Is that a
No.
yes?
I beg your pardon?
Osadale would have been the baby out of Mendoza, your mom and Osadale. Osadale was the youngest.
I think so.
Now, during that period of time, after Mr. Rooks passed away, before Miss Mendoza passed away, although you did not see her, would you ever ask Helios about how she was?
Yes.
And what would he tell you?
Well, she was saying she thinks she's got Alzheimer or dementia. She's losing her memory like that. She's hanging in. She can't drive anymore, but she's hanging in there. That's what he said.
Now, during that period, again, prior to that, was Miss Mendoza, would she drive around and would she go out before Mr. Rooks passed away?
Yeah, sometimes she would,
Now, let me ask, have you ever had the occasion to have to take care of your mother a lot?
Yes.
And why did you have to take care of Lottie?
She was getting bad on health. Her knees were bad. She couldn't walk as well. She had diabetes and other conditions, medical conditions.
And how did you go about taking care of her?
I had to drive for her, I'd take her to the doctor's, grocery store, wherever she needed, the bank, give her shots, cook for her.
Now, at the time when you were doing this, when you had to start taking care of her, was she living with you or somewhere else?
Living with me. I was living with her, same family home.
Living in a family home?
Mhm.
And is that same home in Northwest Atlanta?
Yes.
About how long did you care for your mother?
Maybe 10 years. We worked together at Hormel. So we worked together for 10 years and I took care of her after that, about 10 years.
So you and your mother worked together at Hormel,
Mhm.
and then, is that a yes?
Yes,
And then once she got sick, then you took care of her?
yes.
At that point in time. Once she got sick, is that when you retired from Hormel?
No, I had left Hormel, but I had to quit my jobs. I was working 2 jobs at the time and I quit both to take care of her.
You quit both of your jobs to take care of your mother. Now, during the period, again, after Mr. Rooks died or before Miss Mendoza passed away, to your knowledge, was Helios Rooks working?
Yes.
Do you know where he was working?
I think Georgia Tech, if I'm not mistaken.
Now, during that period of time, again, that same after Mr. Rooks passed away, and you would ask about how Ms. Mendoza was doing, did you ever offer any assistance to Helios?
Yes,
Okay, what was that?
to take care of the yard, check on her, or if he needed me to sit with her for a little while or something when he had something to do or wasn't available. Whatever I could do, just in general.
And why did you offer to take care of the yard?
Well, I had a small lawn service that I did, help seniors in the neighborhood.
And you also offered to help take care of Ms. Brooks as well?
Yes,
And did Helios take you up on your offer?
a couple of times. Then sometimes he would say, I got it because I get somebody else from the neighborhood to do it.
Okay, so is today your testimony that he took you up on your offer some of the time?
Mhm.
Over the course of those years, how many times did he take you up on that offer?
I think about 3 that I can remember distinctly. Could have been more, but
Now, when you would help him, what did you do?
clean the roof, gutters, cut the yard, trim the hedges.
Okay, so you took care of the outside of the house.
Yes,
What about taking care of Miss Brooks? Did you ever do that?
no,
So did he ever take up on your offer to take care of Miss Brooks?
no,
So the stuff that you did was take care of the outside of the house, make sure the house was clean. But as far as watching Miss Brooks, you didn't do that.
no.
But you offered to do that.
Yes.
Did Hilius ever tell you about Mrs. Rooks' health outside of the dementia seriously declining?
He would just say she's not doing too good because nothing in detail, you know, she's getting old, up in age, not doing too good, just hanging in there.
And based upon your conversations with him, did it appear that he had it all under control?
I thought so. I assume.
You assume so, based upon what he told you?
Yeah. Mhm.
Now, going to take you to Super Bowl Sunday 2017.
Mhm.
Remember that day?
Yes.
Why do you remember it?
I was fresh my memory when we spoke last time.
I'm
Okay.
sorry, I couldn't hear the response.
I was going to say the same thing.
We spoke and I kind of refreshed my memory.
When we said we spoke, are you talking about you and I?
Yes.
Have you
well-
been to, sorry.
Well, the prosecution office that one day, a couple of months ago, I think. So,
Okay. Have you been to my office previously?
I don't know whose office, but someone's up some.
Have you met me before?
Yes,
And did we talk about kind of the circumstances
uh-huh.
of this before?
yes,
Okay. Now, Super Bowl Sunday, was this that Sunday that the Falcons were in the Super Bowl?
yes.
Okay. And did you see Hilius Rooks that day?
I don't think so. I don't remember seeing that.
Do you recall if he was gonna come over and watch the football game with you,
I invited Hilius to come with me to a Super Bowl party.
Where was that Super Bowl party?
South Garden Road over in Mableton area, near Mount Pisco Church, over in that area.
And did he go with you to the party?
No,
Why not?
he told me he wanted to stay close to home. He didn't want to go too far from his mother.
Now, during that conversation, when he said he wanted to stay close to home, did he tell you the condition of his mother at that time?
No,
During that time, did he ever speak with you about things that may have happened that weekend leading up to that Super Bowl Sunday?
not that I can recall.
During that time, do you recall him saying he needed to call 911 to help his mother out during this period of time?
No, not that I can recall.
Now, you said he did not go with you to the Super Bowl party. Do you know if he went anywhere else to go watch the Super Bowl?
I think he came over to the house and.
We said your house, that's your house that you live with your brother?
Yes,
So you need to let him finish his answers before you rapid fire your next question. So Ms. Rivers can get all this down.
Is that the house your brother, you and your brother live in?
yes.
But you did not see him at your house?
No,
After Super Bowl Sunday, when was the next time that you saw Hillary? If you saw him,
I didn't. I spoke to him.
when was that?
I think that morning, this next morning or the following morning, he called and informed me that his mother had passed.
And do you know if, when he called you, had he called 911? Do you know?
No, I don't know.
No, you don't.
No,
And when he called you, did you go over to the house?
no.
Why not?
I didn't have transportation. It was early. He woke me up and I was just trying to comfort him over the phone for the few minutes we talked.
And again, once Ms. Mendoza passed, did you know at that time the condition of how she passed?
No,
Is the only thing he told you was that she had passed?
right.
I have no further questions.
Mr. Korn, questions for Anthony Williams?
Thank you, Your Honor. The time your mom got sick, you stopped work to take care of her?
Yes,
You stayed at home with her full time?
yes.
And how did you pay the bills?
Beg your pardon?
How did you pay the bills?
She paid.
Okay. Um, 4 grandchildren, you take care of them?
Yes,
And during the time Adolph was getting sicker, you were also taking care of your grandchildren?
yes,
That feels like a full-time job.
absolutely.
So even if Hilius had asked you to come help and watch over his mom, you couldn't have done that, could you?
Not full time, anything like that.
Okay.
Just whenever I could, anything I could do.
Sure. No further questions. Thank you.
Any follow-up?
Yeah. But during that time, you had offered to figure out in your schedule to assist him with taking care of his mom if he would have asked
Yes, and if I could.
you, and if you could. Thank you.
Questions from the jurors for Anthony Williams? Yes. Thank you. Counsel?
So I'm gonna ask. Great.
Mr. Williams, you testified about your cousin, Mr. Rooks, letting you know that your aunt had passed away. We're trying to figure out sort of when in time. Super Bowl is on a Sunday. Was it the next day, the next week? What do you best remember as to how many days after the Super Bowl you got that call?
It's my best remember, it's 1 to 2 days.
1 to
I think
2.
I'm thinking it was the next day, that Monday, but it could have been Tuesday. I think it was.
1 or 2 days after the Super Bowl. Okay, thank you so much. Follow up, Ms. Hilton,
None from the state, Your Honor.
Mr. Corn.
Thank you, sir.
All right, Mr. Williams, we appreciate your time. Sorry you had to wait around. We're moving as quickly as we can.
Thank
You have a good 4th of July. The next witness is?
Cameron Rooks.
Crazy. Oh, I couldn't believe you. Crazy. I think that's disposable with that.
Yep, you have an escort right behind you. She'll get you up there.
Raise your right hand. Do you swear to tell the truth, testimony, the truth, all the truth, facts? State your name, spell your name.
So you can take your mask off if you're all right with that. It'll help us hear you. If you're not comfortable with that, you can leave it on. but we do need you, if you're going to leave it on, to speak up real clearly in the microphone.
Yes, sir.
Okay.
Okay.
So could you spell your first name?
Cameron, Cameron.
Okay. Ms. Hilton.
Thank you, Your Honor. Cameron, how old are you?
31,
And when's your birthday?
June 28.
You just turned 31.
Yes, ma'am.
Happy belated birthday.
Thank you.
Where do you work?
At Wyckoff Color Corporation.
I'm sorry.
Are you comfortable taking your mask off or you're not comfortable? Okay.
All right. So say the name of your employer slowly.
Wyckoff Color Corporation.
Got it.
And what do you do for Wyckoff Color Corporation?
I'm a machine operator.
How long have you worked there?
Over a decade.
And what do you do as a machine operator at Wyckoff Color?
I mix ink for companies like Coca-Cola, Sprite, alcohol beverages like Bud Light.
You telling us that ink goes into beer, or like we'll go on like packaging?
I apologize. The packaging.
Okay.
The boxes.
All right.
Are you married?
No, ma'am.
Do you have any children?
No, ma'am.
Where do you live?
In Stone Mountain, Georgia.
And who do you live with?
My parents, or my mother and stepfather.
Is your mom present in the courtroom today?
Yes.
How long have you lived at your home?
Since early 2000s.
And what is your mom's name?
Charla Sanders.
And have you always lived at your mom's and stepfather's house?
For the most part.
When you say for the most part, was there a period of time that you did not live with your mom and stepfather?
When I was away at college.
Was there any other time that you did not live with them?
Yes.
When was that?
Right before college.
Now, when you say right before college, when did you first go to college?
And the year after 2009.
In 2010?
Yes.
Now, 2009, did you graduate from high school?
Yes, ma'am.
What high school did you go to?
I went to 2 different high schools.
What was the first high school you went to?
Miller Grove.
And where's Miller Grove?
It's near Stone Mountain.
And what was the second high school you went to?
Frederick Douglass.
And where's Frederick Douglass?
Near Atlanta, or it's in Atlanta.
Now, when you went to Frederick Douglass High School, where were you living?
I was living with my grandparents.
And who were your grandparents?
Medota Rooks and Jimmy Rooks.
Now, when you went to Douglass, what grade were you in?
From 11th to 12th grade.
And did you graduate from Douglass High School?
Yes, ma'am.
So you spent your 11th grade and 12th grade year living with your grandparents.
Yes.
Now, if you graduated high school in 2009, would the beginning of your 11th grade year be 2007?
Can you repeat the question?
Sure. If you graduated in 2009, would the beginning of your 11th grade year be 2007?
I believe so.
Now, when you lived with your grandparents while in high school, who else lived in the home with you?
No one.
So it was just you and your grandparents?
Yes, and my father would come by almost daily, or whenever he would get off work.
And when you say your father, who are you speaking of?
Helius Rooks.
And do you see your father in the courtroom today?
I'd rather not try to look for him.
I know it might be uncomfortable, but I need you to, for a brief moment, let me know if he's in the courtroom.
I can't see him.
So I need you to stand up and look around and see if you're not standing. I need you to stand up.
Yes, I see him.
Okay.
And what is he wearing?
Blue.
Can you describe if he's sitting next to anyone? What?
Yes, a gentleman in a gray suit.
Okay, that's enough. The witnesses identified Mr. Rooks.
Now, you said you're going back to your high school years, you said that your father would come around sometimes or every day. What was your relationship like with your grandparents?
It was great. We would communicate a lot.
Now, during that time when you were living with your grandparents, did your grandmother leave the house at all?
Not often at all.
Now, I know you moved in your 11th and 12th grade year. Prior to moving in, how often would you see your grandparents?
Probably multiple times throughout the year, like whenever I was on break from school.
Now, by the time you moved in with your grandparents, did you have Uncle Addison?
Yes.
Okay. Had your uncle passed away by then?
Yes, my uncle Addison passed away before I moved in with my grandparents.
Do you know about how long before you moved in with your grandparents that your Uncle Addison passed away?
Perhaps a year or so, but I can't recall.
But at least a year or so.
Yes.
And when it came to your Uncle Addison, where was he when he passed away?
Inside the home
In
that I moved into.
the home that you moved into?
Yes.
And would that be your grandparents' home?
Yes, ma'am.
Do you recall seeing your Uncle Addison prior to him passing while he was living at the home of your grandmother?
Yes, but I don't recall like seeing him right before he passed. But I do remember him being sickly.
And was he being taken care of at your grandmother's house?
I believe so.
When you went to the house, excuse me, strike that, did you ever see your Uncle Addison as he was getting sickly at your grandmother's house?
Yes, there was a hospital bed in the middle of the living room when you first walk in.
And who was taking care of your uncle?
I believe it was his immediate family.
And we say immediate, do you mean like your grandmother and grandfather?
Yes.
What about your father?
Yes, when he could.
When he could. Did he have any nurses or anything like that? Do you know?
I can't recall.
But you do remember him at least having a bed.
Yes.
Now, when you were living with your grandmother back in high school, how did your grandmother keep her house?
She used to play lottery a lot. And so she was heavily addicted to the lottery. So yeah, she would have like lottery papers, newspaper clippings, like all over, strewn around her room.
Okay, so that was in her room.
Yes, but the rest of the house, she would mop and clean like periodically.
Now, as she got older, did you assist with kind of helping her clean the house when you were living there?
Yes, like taking out the trash.
And what about when your grandfather, when he was alive, did he ever take part in keeping the house clean?
Yes, ma'am.
Now, what type of things did your grandmother like to do?
Play the lottery.
Sounds amazing.
Yes.
Did she ever travel or anything like that that you know of?
Yes, but as she became older, it became difficult for her to travel.
So that was mostly before you moved in when you were younger, she could travel.
Yes, ma'am. Yeah, I think I recall a couple of times going to like Disneyland with her as a child.
She would take you to Disneyland.
Yes, ma'am.
Now, for an approach with what's on marked as State's Exhibit 143. Do you recognize State's Exhibit 143?
Yes, ma'am.
And how do you recognize State's Exhibit 143?
That looks like my grandmother's house.
And is that your grandmother in the picture?
Yes.
Is that a fair and accurate depiction of your grandmother inside that picture?
She was always smiling, so yes, ma'am.
Your Honor, this time the state legislature takes bill 143 is having.
No objection.
143 is admitted.
Permission to publish, Your Honor.
Yes, ma'am.
So that is her house on North Avenue?
The furniture looks different. I can't say for sure.
Okay, but that's definitely your grandmother.
Yes, ma'am.
Okay, thank you. Now, let's keep that picture for a moment. Now, when your grandmother was younger, she looks like she's dressed very well. Did she always dress in a very nice manner? Tell the jury a little bit about how she kept her personal style.
As she grew at age, she didn't really dress up to go anywhere. So it would be very rare that I've seen her like fully dressed, like without a robe.
And that's as she got older.
Yes, ma'am.
What about when you were younger?
When I was younger, she would wear things like a jumpsuit, like a sweatsuit.
All right, thank you. Now, did there come a point in time where your grandfather passed away?
Yes.
Do you remember what year your grandfather passed away?
Around 2012, June, I believe.
June of 2012?
Yes, ma'am.
And were you still living with them when your grandfather passed away?
I was away in college,
What college did you go to?
University of West Georgia.
And did you complete your studies there?
I was there for 2.5 years.
And you said you were there for 2.5 years. When you left college, where did you move?
I moved back into Stone Mountain.
Now, when you moved back from college and moved into Stone Mountain, since about 2012, would you see your grandmother after your grandfather died?
Yes.
How often would you see her?
Maybe every other month.
And why was it about every other month that you would see your grandmother?
Well, at that time, I still had in mind that I was going back to college. So I wanted to make sure I had found a job and I had money to go back.
So were you just working at that time?
Yes, ma'am.
Now, when you would go and visit your grandmother, what if anything would the two of you do when you would go visit her?
We would chat and she would laugh. I remember every time I come around, she would give me a big hug and a kiss on the cheek. Yeah, I'm sorry. No, ma'am.
Would you ever have to take her anywhere initially after your grandfather died?
Yes. Around the time when I was taking a break from college, I would make sure she had groceries. So at first I was taking her maybe a few times to the grocery store, but that became difficult because she had like dementia or Alzheimer's. So I would be in the grocery store with her, and every 5 minutes she would ask me, "Where are we?" And because she was so used to being at home. So then I started just stopping by and then going to the grocery store without her, but bringing back the groceries and making sure she had toiletries and whatever she needed.
So there was a period of time you would take her, but because her dementia started, you would just go and get the stuff and bring it back to her.
Yes, ma'am.
During that period of time, so after your grandfather passed away, where was your father at during this time? Was he living at the house with your grandmother?
I'm sorry, what time period?
After your grandfather died? So you said he died around June of 2012. Say the months after your grandfather died, where was your father?
He was with his girlfriend, Johanna.
And where did they live?
They lived off Peachtree.
In Buckhead?
Yes, ma'am.
Now, after your grandfather died, you were living in Stone Mountain. Was your grandmother living by herself?
Yes.
Now, if your grandfather died in June of 2012, if you can recall, when do you believe you started noticing those signs of dementia in your grandmother?
Probably right around it got worse when around the time he had passed away, because she would ask me, "Where's my grandfather?" And she literally just went to his funeral. So I would have to every 5 minutes explain to her like where her husband is.
So you started noticing around that time. Now, about how long after your grandfather passed away did you no longer take your grandmother to the store, but was bringing her food to the house?
So I brought groceries to her maybe 2 times or a few more times than 2. And that's around the time when my dad had told me that he was going to move into my grandmother's house. And so around that time, he had also got a Rottweiler. And I tried to greet the dog when I was checking on my grandmother. And while the dog was in my father's hand, he had a leash on the dog. The dog tried to attack me. And so I couldn't step foot back on the property because I was afraid of the dog attacking me again.
And I know we're like in years. Can you recall around when the time that this may have happened? So this is after your grandfather died, right? If your grandmother died in 2017 and your grandfather died in 2012, about when do you think your father moved into the house and this Rottweiler accident occurred?
Maybe 2013, 14.
And around 2013, 14, how old were you?
I was in my early 20s.
Now, once that dog attacked you, did you ever go back to the house again, or after the dog attacked you, you stopped going?
I was afraid for my life.
Now, with the dog, whose dog was it?
My dad's.
And did your dad ever tell you why he got the dog?
I believe it was to keep intruders away from the house.
Now, did your grandmother, to your knowledge, have an alarm system in the house?
No, ma'am.
No, she didn't?
Not that I know of.
Did you ever tell your dad your concerns about the dog?
I can't recall.
Now, once you stopped going by because of the dog, did you ever speak with your father about how your grandmother, how she was doing?
Whenever the topic of my grandmother would come up, he would always give me the same answer.
And what was it?
Like she's hanging in there, or things like that, of that nature.
When you say she's hanging in there, did it appear that she was doing okay, doing kind of bad, deteriorating?
He never gave me any other type of indication of her well-being.
Did it appear from you speaking with him that he had it under control of her care?
Yes, ma'am, because I remember a few times he told me she was going to the doctor's office. And so I was under the impression that he had everything in control and under his hand.
Now, during this time, did you have any, in addition to working, did you have any other like extracurricular activities?
Yes, I was heavily into music.
And when you were heavily into music, would you go to a music studio?
Yes, ma'am.
Where was that music studio?
Off of Metropolitan.
Is that in the city of Atlanta?
Yes, ma'am.
Now, when did you first get the music studio? Was that before or after your grandfather passed away?
After.
Now, with this music studio, were you renting the space?
Yes, ma'am.
Okay. Were you renting that space with anyone else?
With my father.
And did you have to pay rent to rent the space?
Yes, ma'am.
How much were you paying?
Around $425 a month.
A month? And how long did you have the music studio?
It was quite for some time.
You said quite for some time. You could give
Some
me
years.
some years? Would you say 1 year, 2 years, 3 years? About how long?
Possibly 3 or more.
If your grandfather died in June of 2012, when do you first think that you started using the recording studio?
Maybe a year and a half after that.
So around 2014?
Possibly.
And so it was $425 a month.
Yes.
Who paid it?
At first we were both splitting. My father and I, we split the bill. But then I was having car troubles. And so I had to get a car note, and that prohibited me from paying the monthly fee.
So that prohibited you from paying the half of the $425.
Right.
So at that point in time, who then began paying the entire $425?
My father.
About how many months into the lease did you have to stop paying your portion?
I can't really recall, but it might have been a year
Okay, so you probably would have been paying half of it for about a year,
or more, a little bit
a little
after.
bit more. But then the remainder of that, your father was paying the full $425.
Yes, ma'am.
Did there ever come a time where the lease was up?
Yes.
Recall when that was?
It was after his release.
Okay. So somewhere around 2018?
Yes.
When was the last time that you physically saw your grandmother?
Around the time when I was taking her groceries.
So that had been about 2013?
I can't recall.
If she died in 2017, about how many years prior to that do you think approximately that you last saw your grandma?
Possibly 3.
What about speaking with her? When was the last time you spoke to your grandma?
She had a cell phone, but I believe she lost her cell phone. She used to lose her keys and her purse often.
So although you didn't see your grandmother, would you speak to her on the phone?
When she did have her cell phone, yes.
Now, when you all had the music studio, would you and your father be at the studio at the same time?
Yes, but after a while, I would kind of plan when he would be there, so I would show up when he wasn't there.
Okay. How did you learn about the death of your grandmother?
I had got a text from my father that she had passed.
Now, leading up to this text message, had your father ever indicated to you leading up to this, the severity of her injuries or how she was declining?
No, ma'am.
In the few days before her death, did he ever kind of communicate to you his need to have called 911 to get her some care?
No, I have no knowledge of that.
Now, after your grandmother passed away,
Hold on one sec. We've got a phone that's making happy noises. You need to stifle the happy noises. Because Deputy Gordon can turn it off for you. You just might not get it back after it's off. Are we good? Deputy Gordon has a big hammer in his office that he can use to turn it off. Great. All right, Miss Hilton.
between 2017 and 2018, don't want you to tell me who was paying for the studio between 2017 and 2018. How was the studio being paid?
My dad had taken over the bill for the studio, so he was paying.
Now, after your grandmother passed away, who became responsible for her funeral arrangements?
I believe her brother Elson.
Now, did your grandmother have any property outside of her home on North Avenue, any other property?
Yes. Excuse me. Yes.
Where?
Jasper County.
Jasper County, Georgia?
Yes.
And what type of property did she have in Jasper County, Georgia?
Just like trees, acreage.
So she had land?
Yes.
Anything else?
No, ma'am.
Now, after your grandmother died, did you become responsible for taking care of her financial affairs?
Yes, I went to probate court and I became head of the estate, my grandmother's estate.
You were the administrator of of Medotha Rooks's estate.
Yes, sir.
And did you want that responsibility?
Not in that manner.
Not. And when you say that manner, what do you mean?
I didn't want her to. I didn't want her to have a cruel death.
Now, after your grandmother died, did you ever have to go to the home on 1251 North Avenue?
Can you repeat the question?
Sure. After your grandmother passed away, did you have to go to her home on North Avenue?
Yes.
Why?
Because her brother Elson was stealing property and breaking into the house.
So what happened after that?
I had to send a cease and desist letter.
And what about how was the home when you got there?
It was in shambles.
And is that how you recall the house being when you were living there?
No, ma'am, not at all.
Now, did you go into the house?
Yes.
Did you find items like Amazon boxes inside of the house?
Yes, ma'am.
Who were they addressed
To my father, Helius Rooks.
Did you ever go inside of those boxes?
There's so many bugs and contamination. I didn't want to bring any roaches home, so I had purchased a service for a cleanup crew. I paid around $2,000 to clean the house out. So a lot of things I didn't get to keep because they were contaminated.
And again, you only did you only become the executor of her estate because your father could not become executor of her estate
Yes, I was next in line.
after your father?
Yes, ma'am.
And it's only but for your father not being able to that you assume that responsibility.
Yes, because he had forfeit.
Okay, thank you.
Thank you. As in you're done?
Yes.
Okay. All right. Mr. Korn, do you have questions for
Jenks is gonna do the.
Ms. Jenks? Great. Cameron Rooks is your witness.
Good afternoon, Cameron. How are you?
I'm fine. How are you?
I'm good, thank you. Just a few questions. I know you mentioned a couple of times that you lived in your grandparents' home, but you had actually spent quite some time there when you were growing up, correct?
Not as much as when I was younger.
So when you were younger, there was a visitation schedule because your parents were divorced.
Yes.
Okay, and then how often would you be with your dad? Would it be every other weekend and some holidays?
Like sporadically, kind of, sort of.
Okay, when you did have time with your father, would those visits happen at your grandparents' home?
Yes, ma'am.
Okay. And you would stay overnight over the weekends?
Either with my grandfather or my grandmother. Yes.
Okay, at the home on North Avenue.
Yes.
So you knew that house pretty well, correct?
Yes.
Okay. And from what age, your parents were divorced when you were 3? Is that correct?
I believe so.
Okay, and what age did you start that visitation at your grandparents' home?
From what I was told, there was a time period where there was no contact with my father, but there was always contact with my grandparents.
Okay, so you would be there often throughout your early childhood?
Like they would come to my house, where I was staying with my parents, my mom and stepdad.
Okay. And you had a good relationship with your grandparents
Yes.
all the time?
Yes.
And also with your Uncle Addison?
Yes, ma'am.
Okay. Now, let's fast forward to high school. Why did you end up changing schools in 11th grade?
What's the relevance of changing high schools? You may know, I don't, but the state seems to think it's not relevant.
Well, I'm just wondering why he made that shift from Stone Mountain to.
I know you're wondering, how is it relevant to what we're working through?
Like, I can shift, Judge.
Okay.
Yep, no problem. You changed schools in 11th grade,
Yes.
correct? And you stayed with your grandparents for the whole year of 11th grade and 12th grade,
Till I graduated.
so you graduated. Which bedroom did you stay in?
My uncle Addison, the one that had previously passed away.
Okay. And so that was your designated bedroom?
Yes, ma'am.
And during those years, would you go in and out of the house independently?
No, ma'am.
Why do you say that?
I didn't have a car. I didn't have many friends. I was mostly inside the house.
You're mostly inside the house?
Unless my dad would come and maybe take me out somewhere.
Okay. And how many doors were in the home?
There were a lot. I can't really give you the number.
Was it 3 doors? There was a front door, a kitchen door, and a basement door?
Oh, yes.
Okay. And would you go in and out of those doors
Mostly
different times?
just the front door.
But the back door and the basement door were also doors that you could go in and out of?
But they weren't really points of entry because they weren't very used often.
Okay. Where did the back door lead to?
The backyard. The
Backyard, I'm sorry.
Oh, the backyard.
Okay. And the basement door?
The backyard as well.
Did you get down to the basement from a flight of stairs from the first floor of that North Avenue home?
I didn't really go downstairs often whenever I was there.
But I mean, a person was able to get to the basement through a flight of stairs, correct?
Yes.
Okay. So there were actually 3 ways to get in and out of the house. Would that be fair to say?
Yes.
Tell me which year you went to college.
The year I graduated in 2009, so the following year.
Okay, so would it have been 2010 or would it have been fall of fall of 2009?
I can't really recall.
Let me back that up. I'm sorry, that's confusing. Did you graduate in spring of 2009 from high school?
Yes.
So would you have started that following fall at West Georgia in Carrollton?
Yes, the following.
Okay, so that would have been 2009?
Yes, ma'am.
Okay. And did you graduate from college?
No, ma'am.
Right. And how many years did you complete?
Like 2.5.
And you lived close to the college during that time?
Not at all. It was 3 hours away
Oof. Did you go every day?
to college. I stayed on campus.
Oh, so you were very close to college while you were in college because you stayed on campus.
I was far from home.
Okay.
Thank you, Judge. So you lived on the campus at West Georgia?
Yes, ma'am.
And isn't it true that during that time frame, Cameron, your dad picked you up many, many weekends while you were in college?
If it wasn't him, it was my grandfather.
So either your grandfather, Jimmy, or your dad would pick you up most weekends. Would that be fair to say?
Yes.
And at that time, there was actually, your dad had created a studio, a smaller studio in his Buckhead apartment.
Yes, ma'am.
And that was for music. It was a music studio,
Yes.
just right there in his apartment.
Right.
Why did he start that music studio?
I think it was more so like a way to stay out of trouble, like for me, or like something that I could do, you know what I'm saying, inside.
Okay, so it was for you?
Well,
Interests?
he would also make music as well, so I would kind of learn from him.
Okay, so you would do that together?
Yes, ma'am.
And that was most or many weekends while you were in college over those 2.5 years?
Whenever I could, I wasn't busy at college. I would come home whenever I could.
So he or Grandpa Jimmy would go down, you said it was about 3 hours?
3 hours there, 3 hours back.
And bring you back and forth like that?
Yes.
Okay. Now, I'm sorry, at some point, so after the 2.5 years at West Georgia and Carrollton, where did you then live? Can you just remind me?
Can you repeat the question?
When you came back to Atlanta after those 2.5 years of college, where did you move into?
Stone Mountain.
So that was back with your mother and her husband?
Yes.
Your stepfather?
Yes.
Okay. At some point, in terms of the music studio, it got really loud in Buckhead, right?
Yes.
And so that was a reason for the music studio to be moved.
I think the reason was for, as you say, like noise complaints, probably. But at the time, I was unaware.
You weren't aware of why the studio moved?
No.
Okay. Were you excited though about having a larger studio be created or be rented?
Yes, ma'am.
Now, when the studio was in the Buckhead apartment, your dad's Buckhead apartment, obviously there were no rental fees or what have you, correct?
At the studio?
In the Buckhead apartment.
Oh, I didn't pay any bills there.
You didn't pay for anything involved in that. Is that right?
Right.
Your dad bought all of the equipment?
Yes.
And then just to highlight the time frame, you were in college, you said for 2.5 years. So that would have been fall of 2009 to like mid 2011, correct?
I believe so.
Okay. And that was after your uncle Addison died, right?
I'm sorry, can you go back to the last question?
Your uncle Addison died in 2006?
I think so. I can't recall.
Okay. And then, but your grandpa Jimmy, you remember he died in 2012?
Yes.
So that music studio that your dad had in Buckhead was before Grandpa Jimmy died?
Yes.
You talked a little bit about your grandmother, and I'm very sorry for your loss. And in terms of that, when you, well, let me reverse this. When did you start noticing that she was more so clothed in a robe? You talked a little bit about that with the state.
Around the time after her husband died.
So after 2012?
Yes.
Okay, you weren't living there at that time.
No.
And you said that she was always covered up, correct?
Yes, ma'am.
Okay, so she wasn't one to wear, like, be scantily clad around the house?
No, ma'am.
Would you say she was pretty private in terms of her making sure she was covered?
Yes.
You also talked about this time frame that you helped your grandma buy groceries.
Yes.
And I wasn't clear when you talked to the state about that. When, can you just reiterate, or tell us again, when was that time frame? Was that while you were in college, before college, or after college?
Right before I left college.
Right before you left college?
Or no, right after, yeah, right. I had left college, so I was closer to home. Stone Mountain is like 30 minutes from Atlanta. So I was able to come around more often.
So I'm sorry, so it was after you had finished the 2.5 years in college?
Yes.
Okay, so that's around 2011?
No, because my grandfather had passed away.
Okay, so it's after 2012?
Yes.
Okay, thank you. So you helped her get groceries, and you said it was about how many times would you have done that? After your grandfather passed away in 2012?
I want to say maybe 3 or 4. Of like maybe 2 times I went with her. And then after that, like 2 or 3 more times. And then that's when the dog came in the picture.
Okay, so let's unpack that a little bit. So you helped her with the groceries 3 or 4 times. That was definitely after Grandpa Jimmy passed.
Right.
And that's when would you pick her? Did you have a vehicle at that time?
Yes.
So you would pick grandma up and then go to the grocery store?
I probably only did that like 2 or 3 times because her health, she didn't know where we were and it was kind of chaotic.
Okay, so your grandmom was already having memory issues?
It got worse after 2012. Like her memory loss became a problem, more so of a problem after 2012.
Okay, was it very close in time to when Grandpa Jimmy passed?
Yes.
Okay, and so her memory, you saw that her memory was
Fading.
fading at the grocery store?
Yes.
And when you say things were chaotic with her, what does that mean, that word chaotic, when you say it that way?
Like I was trying to do my best to help her in the best way that I could, but it seemed like when I was trying to help, it wasn't enough because I couldn't help regain her memory.
Okay. So you felt really badly that she couldn't remember things?
Somewhat helpless.
Okay. So was she even able to help in terms of making decisions about what foods to buy, or did you just know what she liked?
I would ask her, and I kind of just went off of things that she used to buy when I lived there.
Okay. So that all started in 2012?
Yes.
Okay. Now, you said that during the same time that you helped grandma with groceries, these 2 to 4 times, let's say, I know you said 2 to 3 and then 3 to 4, but those handful of times, you said that there was a Rottweiler there in the home at that time?
Not when, no. So like probably the last time I tried to check on her, like before I would, okay, so the first 2 times or 2 or 3 times I would take my grandmother with me. And then after I saw that was too difficult of a task, then I would just stop by and then I would go to the grocery store. Then I would come back. And so when I tried to stop by to check and see what she needed, that's when I saw the dog was there, probably like the 3rd or 4th time I tried to go by myself to the grocery store.
So can you give us a time frame or give the jurors a time frame in terms of when that would have been?
What year?
Correct.
Maybe it was shortly after 2012.
Shortly after 2012? Okay. And this time that you remember that there was a dog there, did you ever ask grandma to put him outside so he could come in?
I don't think she had control of the dog.
Okay. You never asked her to let the dog out in the backyard so you could come in?
She was kind of like, she wasn't very mobile. So I don't think she would have had much control of like where the dog's whereabouts were. Like if she told the dog to come here, I'm not sure if the dog would come.
Okay. And you're saying that this is in 2012?
Yes.
I know you also mentioned, so you talked about that at some point, these same trips where you were helping your grandma get groceries. And when she would go with you, so the first couple of times you talked about after Grandpa Joe passed, that she had keys, she had a purse, she would take a purse, correct?
Yes.
Would she pay for the groceries?
Like the first 2 times she was. And then I just started just coming because I had a job then, so I would just come out of my own pocket for her groceries.
So you would help contribute to the groceries?
And I think that was around the time, yes, that's correct.
Okay, and then the keys that she had, I think you mentioned to the state that they were always in her purse.
No, it was either she was losing her keys or she lost her purse or she would lose her phone or she would lose all 3.
Okay, but you do know that she had a set of keys because she was having to come in and out of the house when you were getting groceries together, correct?
She would be in the house and then I had my own set, so I would come in the house, but when the dog was there, I could no longer enter the house.
Because you were scared about the dog.
Yes.
But you said that she forgot that she had keys, but you knew that she did have keys in her purse regularly, correct?
She had keys in the house. I'm not sure if they stayed inside her purse.
So your understanding is that she had keys in the house?
Yes.
And that would have been keys to a car or to the doors or what have you, correct?
Yes, her keys.
Thank you. The state asked you questions about the communication between your dad and you and your grandmother's decline, which started in 2012. Is that right?
Around that time.
Okay. So we're going to fast forward it a little bit. And it sounds like you had some discussion with your dad about how grandma's doing. Is that right? You asked how she's doing?
There were short conversations, mostly him telling me the same thing over and over.
Okay. And I think you said that he would say he had it under control.
Yes.
Did you ever ask him what that meant?
No, ma'am.
One of the last topics the state talked to you about was, I know after you became executor or you went through probate court, is that right? And started taking care of your grandma's financial affairs, right?
Yes.
So you went back to the house and I believe you said that her brother, is it Elson?
Yes.
Had broken into the home.
Yes. Multiple times.
Multiple times. And you said that you paid some money to have the house cleaned up. What was the time frame on that? If your grandmother passed in February 2017, when did that occur that you described to the state?
Within the following year or 2.
So 1 to 2 years after your grandmother passed?
Yes.
And is that because it took time to go through probate court?
Yes.
Okay. If I can just have a moment, Judge. Nothing further. Thank you, Your Honor.
Any redirect? I see what time it is. We're going to wrap up this witness.
Okay.
The next event can wait.
Okay. Mr. Karen, the defense counsel just asked you about your grandmother and her keys, right? Now, that was the period immediately following your grandfather's death in 2012. That is safe to say?
Yes.
You were noticing that she would lose her keys.
Yes.
Is that a yes?
Yes, ma'am.
Closer in in time to her death in 2017, do you know anything about whether or not she had access or keys to her home?
I believe my father had access to her keys and purse
Your
and
father
phone
had-
as well. Oh, and cell phone as well.
Your father had access to her keys or her cell phone.
Yes.
Did your grandmother, do you know if your grandmother had that access?
She would lose them very often. So I'm sure she did have access and then she would misplace it. But I'm sure that my father probably could find whatever she was looking for.
But during this time, you weren't living with your grandmother, so you don't know what was going on.
Exactly.
Now, this music studio that was at your father's apartment in Buckhead, you said that was a studio that was there before your grandfather died, so before 2012.
Can you repeat the question?
Sure. The music studio in Buckhead, you had that music studio before your grandfather died?
Yes. Well, hold on. I'm thinking about the Peachtree because we were there for so long. There's a studio off Peachtree,
Yes.
and my grandfather was alive around that time period. But when we got the new studio, I think that was after 2012.
So the studio in Buckhead, that was on Peachtree. Did you have that studio after your grandfather died, or once your grandfather died, you all moved to that metropolitan?
Yes, that was around the same time period.
Okay, all around the same time period. Who, you said your father paid for the equipment in the studio.
Yes.
About how much is music equipment in a studio? What's the cost?
The price range
Yes,
for the equipment that we use,
yes.
it's expensive.
When you say expensive, give me a ballpark.
Maybe close to 10,000.
And at this time, before and after your grandfather died, your father was working at Georgia Tech.
Yes.
Thank you. No further questions.
Any redirect?
Just briefly, Judge.
Briefly is the operative word.
I'm with it. Just real quick, Cameron, the two studios, the one at your dad's apartment initially, was there any income generated from that?
Very little.
Okay, and then the one that was a rented facility, was there income generated from there?
Very little.
Okay, but there was an ongoing, you did have customers that came and recorded there?
Not often because he didn't really want a lot of people coming in.
Okay, thank you. Nothing further.
Ladies and gentlemen, do you have any questions for Cameron Rooks? Yes. All right, take your time, write legibly, one side of the card. Deputy Gordon will collect them. Thank you, sir. Counsel, please.
actually set up on my staff.
Mr. Rooks,
Yes.
you shared with the jury about the dog. Your dad was holding the dog on a leash and the dog attacked you. Could you share a little bit more what that event entailed? I understand it was traumatic, but did the dog actually bite you? Did it growl? Did it bark? What happened?
So I drove my car to my grandmother's house to see if she needed anything. And so right when I got out the car, I saw my dad was there and he had a new dog in his hand, with the leash in his hand. And so as I approached, I see the dog on his hind legs, inches away from my face. And so that's when I get back in my car and I left and I didn't return.
Okay. And when the dog was on its hind legs, inches away from your face, was it growling or barking or?
I saw teeth and that was enough to scare me.
Okay. You remember teeth. Understood. And would that have been before or after your grandfather passed away?
That was after.
Okay. Did you and your grandmother ever discuss how she felt about the dog? I know how you felt about the dog. Did she ever say, I love it, I'm scared of it?
I feared for her.
Okay, but did she ever share with you her feelings about the dog?
No, because the way my dad would explain it, he said they were getting along.
Okay.
So
you never asked her?
Right.
Okay. And she never volunteered anything to you?
No, sir.
Okay. Do you remember what day your father texted you that your grandmother had passed away?
It was the week before I found out he was in jail.
Okay. Do you follow NFL football at all?
It was right around the Super Bowl that the Atlanta Falcons went to and lost.
Okay. Thanks for reminding us. Do you recall if you got that text from your dad before or after the Super Bowl, or just that it was near it?
We went to like a Super Bowl viewing at my cousin aunt and Vincent's house, and my dad was acting perfectly fine. So I didn't have any suspicion of anything was wrong with my grandmother because he didn't say anything to anybody.
So you were at the Super Bowl event with your father?
Yes.
Okay. How would you describe for the jury your relationship these days, we'll say last year or so, with your father?
We didn't talk often at all. If we were in the same room, I would try to ignore him or act like he wasn't there, just so that, because he's argumentative. So a lot of times I would tell him, I'm not trying to argue with you. And I would just leave it at that.
So my question was, how is it now? Is that a fair description of how your relationship is with him now?
Nothing has changed.
Okay, so back at the time of the Super Bowl party, where you and your dad were at the same Super Bowl party around the time your grandmother passed away, same kind of relationship where you tried to just keep your distance?
I found out like the less I say, I guess the less like riled up he'll get or like angry at me he would get.
So the dynamic that you described that is present today, it was that way back when the Atlanta Falcons lost the Super Bowl?
Yeah, I just try to avoid him now.
Okay, but my question is, did you have the same kind of relationship back then that you describe now?
Yes.
Okay, thank you.
Okay.
Ms. Hilton, any follow-up for Mr. Rooks?
Nothing, Mr.
Ms. Jenks? Mr. Rooks, thank you for coming in. I appreciate it. You are free to go.
Okay.
Have a good weekend.
You too.
Ladies and gentlemen, I'm gonna let Mr. Rooks get out of here, and then I'm gonna excuse you for lunch. Given what time your lunch is starting, I'm gonna ask you to be back in the jury room by 1:45 on that clock. So again, adjust your watches. I don't know how accurate that clock is. It's just court time. So court time, 1:45, if you could be back in the jury room. You're welcome to come back earlier. You're welcome to come back into the courtroom to watch what's going on, because it has absolutely nothing to do with State versus Rooks. And during lunch, you should have absolutely nothing to do with State versus Rooks. No outside research. Don't talk about the case. Enjoy the food or the weather or anything like that. We'll see you at 1:45 or as close to after that as I can make it. Any logistical questions? Seeing none, go enjoy yourselves. Thank you so much.
All right, for the jury.
Thank you. That's so annoying. All right, you can be seated, please. Miss Hilton, anything before we break?
Nothing from the state, Your Honor.
When we come back, should we have, I think it's Mr. Thompson, Mr. Thomas, the APS person. Should that be what we do? He answers some questions outside the presence of the jury. I know you want to get your doctor on. We need to work through that. So we have a few moving parts. I don't know what you have to do today because of conflicts for witnesses and what you want to do today.
He won't be our priority today.
He, Mr. APS. Okay.
Mr. APS. So if we get to him, I will make sure it won't be directly after.
Okay. The good doctor, though, does need to be today at some point.
Okay. And we have Wells Fargo that has.
Okay, but I'm hoping there's not an issue with Wells Fargo testimony. I would ask that you spend a little bit of time during this lunch break talking with Mr. Korn about the contours of what you want to cover with Dr. Holmeyer, so that when we have our discussion, it's as tight as can be, because time will be tight. You've highlighted some areas you want to go that Mr. Korn thinks you ought not to. And the more you can hone in on the disagreement, the better I'll be able to, the more quickly I can resolve it.
Yes, Your Honor.
All right, Mr. Korn, anything from the defense before we break?
Nothing other than what we just talked about.
Great. So we may not get to the admissibility of the APS report as non-testimonial, or some parts of it, as I may conclude. We'll definitely need to work through what Dr. Holmeyer can and cannot discuss. Excellent. If at 1:45 we're still humming, you're welcome to be in the courtroom. Just don't assume counsel table if it's occupied. Thanks.
Cleaning myself out.
Well, and you're welcome to leave things around. This is the priority. Just leave a little surface area for the attorneys. And I'll tell them not to harass your stuff. And Deputy Gordon, you can let whoever needs to come in to set stuff up do that now. You do. It's not a Yeti. It's not that nice, but I'll go get it. It's some law firm thing. It should actually be for me. They don't need to bribe you.
Yeah, Come in, ladies and gentlemen, make yourself on silent operator. Take your phone. Take your phone. During this time, y'all, lights on the action.
Okay, thank you. Stay here.
I learned that from watching the January 6th hearings. You gotta hit that button.
Mr. Samuel? You were going to skip that one. Still, Mr. Samuel, they were not rising for you, to be clear. Yeah, there you go. Thanks for sharing. It was odd, it was not coffee that was in there either. Do you all need more time or are you set? All right, great. And you're Ms. Hill? Are you ready? Excellent. Okay, we are here for a hearing on a motion to quash certain subpoenas that the district attorney's office has served. I think right now it's 2 that we're working through, but it's one of the things we're going to explore in the matter of 2022 EX 4024, the special purpose grand jury that was convened on May 2nd of this year. It would help me if I could know who from the district attorney's office will be doing the speaking. If it's just one person, we can get that name on the record.
Good afternoon, Judge Donald Wakeford, for the district attorney representing, as the legal representative for the special purpose grand jury.
Great.
And Mr. Nathan Wade may also speak to certain matters. That's WADE, if we get to them today.
Great. And to be clear, I'm not limiting either side to one person, but if I have a question for the state, I'll start by saying, Mr. Wakeford. If Ms. Willis wants to answer it, she can answer it. She's your boss. But I'll direct questions to you.
All right.
All
Thank you, Judge.
And on behalf of the subpoenants, I don't know what we call it, the motion, the petitioners, we'll call it.
We actually called witnesses, but
Okay.
Don Samuel and Amanda Clark Palmer is here and Ed Garland.
Hello, Mr. Garland.
Hello, Your Honor. Good to be here.
Good to see you. In the same way, I'll refer my questions to you, but if they're hard, you can pass them to Ms. Palmer.
Yep.
All right. Let's start, Mr. Samuel, by having you make as clear as you can who it is you represent, because I know we've had some conferences with both the district attorney's office and you present about sort of a collective representation you have. But as I understand the law around legislative privilege, which is what we're working through, or legislative immunity today, it is unique to the legislator and perhaps his or her staff. There may be rulings that flow from today that logically and hopefully reasonably apply to anyone you end up representing. But as I read your motion, it's currently Lieutenant Governor Duncan and former Senator Ligon that you have specific representation of. I may be wrong about that, but we ought to get clear as we move into this, in particular because of some of the things the state has said in its response about former Senator Ligon and his connection to the committee hearing, et cetera.
Right. So let me respond this way. First of all, Ms. Clark Palmer and I have both been designated as special legal counsel for the legislature, special legislative counsel. And so in that capacity, we have been asked, because they don't have lawyers in their shop who do much grand jury work or any, if we would help perform the functions that they generally perform, which is to advise members about their rights in all kinds of contexts. So we agreed to do that. We've written some memos to them. Some of them were shared with the entire membership of the General Assembly. and their staff. So we've been providing kind of consulting services, if you will. We were then asked, because they also do, in fact, represent members individually in certain cases. Have to be careful about conflicts, which sometimes arise. So we said that we would do the same thing that you would generally do. And we advised the members that we could provide consulting advice. We could actually represent them to the extent there wasn't any conflict with any other member. Or you could have your own lawyer, or you could do it without a lawyer. Whatever you want is fine. You have absolute right to make any one of those choices. So there have been a number of members we have talked to individually who said, we want you to protect our privilege and our immunity. Some of them, however, have said, we do not want to be in the pleading at this point. And so,
meaning the motion to quash that you filed.
Exactly.
Okay.
I think it's just, they're thinking about having separate counsel. Some of them do have separate counsel. Some of them just, want to get a sense for the pub, they're politicians. Let me just leave it like that. And so as of today, I represent two people, both of whom have authorized me to speak on their behalf. There are many people, including the office that we work for, that Amanda Clark Palmer and I work for, who expect your rulings to be of general applicability to anybody who opts in. The state is absolutely right. Mr. Wakeford's absolutely right. Mr. Willis is absolutely right. Anybody can opt out. I gather from the newspaper, for what it's worth, which is very little, but I gather that there have been people who've gone and testified. There have been many people, I gather, who have made voluntary statements. That's perfectly okay. It's their right to do so. I don't know whether they asserted some privilege. I don't know whether they waived it. I don't know whether they were asked any questions that prompted it.
So lots of scenarios insofar as members of the legislature or staff, because you flagged for me, again, with the district attorney's office present, that there could be not staffers of legislators, but Mr. Cook, that someone who works for the Senate. Both, right. All of the above could be your clients. For today, your clients are two.
With the understanding, again, that there are, for example, are we on the Zoom with Mr. Durham?
We are.
Okay. Well, he actually is Mr. Lyden, so that's kind of irrelevant. But there are others who are, expecting to the extent that you make decisions today, and Mr. Wakeford and I have talked about that a lot, what you are going to end up doing today. To the extent that you do of general applicability, everybody expects to take advantage of it if they want to.
Okay.
So that's the short answer to the question.
Got it.
I do want to say something on behalf of the Lieutenant Governor, who's asked me to specifically tell you that he voluntarily went and was interviewed by the folks at the DA's office. Didn't require a lawyer there, didn't require being compelled. He voluntarily went, answered all their questions as far as I know. And I assured him that I would make that known to you today. But as with everybody who I've spoke to, and then I'll sit down because you asked a very simple question. It's going too long already.
Long hearing.
I know. What time is the jury coming back in your other case?
Soon.
Okay. Okay, well, then I'll just leave it at that for now.
Well, but the Lieutenant Governor did those things. Good to know. And yet he is still under subpoena to appear, or were you going to end with, and so there's no more subpoena?
No, he's been subpoenaed to appear and wants to assert the privilege and immunity because for institutional reasons, the General Assembly and many of its members want to assert the privilege and the immunity because it's important to them as institutions, as an institution, not to individually as members, as many of the Supreme Court cases have stated.
Understood. Okay. Well, to one of the points you made, I would hope that whatever guidelines flow from today's hearing, and they won't flow now from my mouth to everyone, but ultimately on paper, the guidelines that are developed would apply to any future clients you have. You mentioned that some may want to avail themselves of it, some may not. It'll be my ruling as to how individuals who may avail themselves of legislative immunity are going to work the process. So in some ways, it's not going to be an optional. I don't like the McBurney rules. They can not like them, but it's how it'll work such that hypothetically client 3, who we don't have yet, is testifying in front of the grand jury and says, well, that's not a question I'm going to answer. Mr. Wade and his team will be free to, pursuant to the guidelines, say, well, we're going to get Judge McBurney down here. And client 3 is not going to say, no, that's not my guideline. That was a guideline they established for the Lieutenant Governor and former Senator Ligon. Just so you can let folks know that.
I agree with you 100%.
Okay.
I think they know that.
Good. All right. Mr. Wakeford, is there anything you wanted to add? Solely threshold, we're here, as I understand it, Lieutenant Governor Duncan, former Senator Ligon. There may be recipients of your subpoenas who fall into this same category. They'll be governed by these guidelines. They may handle things differently by not retaining Mr. Samuel and Ms. Clark Palmer's services, but what flows from today, I think, will have that carryover effect to anyone your team subpoenas who can rightfully invoke the legislative immunity.
Well, at the outset, Your Honor, I think what this is making clear is that one proposal by the movements, by Mr. Samuel and his motion on behalf of these two officials was to hope to set down general guidelines and avoid an individual assessment for each person who invokes the privilege. I think what's clear is that we cannot avoid an individual assessment for each person because the parameters of the privilege are necessarily, they're context dependent. It depends on what you're actually talking about. Also, as you mentioned at the outset, it's an individual invocation. One person's invocation doesn't apply to anyone else. So I think what we can't avoid, unfortunately, for efficiency's sake, is each time a witness comes in, having an individual assessment of how the privilege will apply to that witness and their questioning.
My response is yes and no. I think both sides would agree it's going to be, certain aspects will be different for each witness. But I think there are some bright lines. That's actually what we're going to talk about for the rest of the hearing. That I think can be rules that can be enforced by one side or the other. And I think that'll become a little clearer as we work through it. So I'm not disagreeing with you. I do think there is some clarity that can be provided that would apply to any legislative witness that your team may choose to subpoena and who shows up. But there'll be refinements at the edges for each person. A staffer is different from a legislator. A legislator from one party, frankly, is going to be different than one from the other party because of the nature of what you're exploring. And so there might be different issues that come up, but I think they can all be informed by some basic rules about where I suspect I will, in applying the case law that has applied legislative immunity, I will be establishing some fairly bright lines that should you try to cross them and the witness says, that's not where I'm going to go, and you disagree and I get involved, I'll be saying, once again, that's getting in that area where I've tried to make clear you ought not to go. But there will be gray with each witness.
Yes, Your Honor, we understand. And also, we acknowledge that some general guidance is honestly necessary because the body that is making this inquiry is a grand jury. So questions come from the grand jury. And so if there are times when we, as their legal advisor, have to speak to them about what the parameters are, we're going to need to have that come from you. So I understand that.
And that's a very helpful point. I'm glad you brought that up because I know one request Mr. Samuel had on behalf of his clients was, well, if the DA's office would just tell us the questions they're going to ask, then we could highlight that these are problematic. Let's talk with the judge about those. If only it was just the DA's office asking questions, but you have 26 people in there, any of whom could have a question, any of which could be problematic in light of legislative immunity. So again, some guidelines, and it may be helpful in the end for whether it's someone from your team and Mr. Samuel, the role he represents, or the judge to meet with the grand jurors to say, when you have witnesses that fall in this category, there's some areas that you go ahead and ask the question, but know that that question won't be answered because of. So you can think through how you want that to work. But I do think we're ending up talking about guidelines because, of course, the motion was to quash. You may not have my client. These witnesses don't have to appear. And I deny that. I'm not quashing any of these subpoenas. But I do want to provide a framework so that it's not every third question that we're having to call a timeout and the lawyers huddle up either with lawyers or with judge. And then we go on, those witnesses will be in front of the grand jury for days. So I appreciate that. All right.
Thank you, Judge.
You're welcome. So let me share some of the brighter lines that I have found in reviewing the pleadings, the motion and the response, as well as case law highlighted therein, or case law I've looked at myself, whether it's from the US Supreme Court, Georgia cases, or some federal cases that both sides seem to like. First, I think there is some common ground across the two pleadings. Everyone agrees there is a legislative privilege, there's legislative immunity. And so that if the district attorney's office is subpoenaing a legislator or a staff member thereof, this is an issue. Everyone seems to agree that guidance would be helpful. And regrettably, everyone seems to agree that there ought to be day of judicial availability. We can't say, cover all the questions that you think are okay, let's take a break, and 3 days later, bring that witness back. So at the end of today's session, we're going to need to agree on some cadence as to when you all let me know that X days out, we're going to have one of Mr. Samuels's witnesses so that I can be available that day to assist if needed. Some legal, as opposed to procedural bright lines that I think apply here is that, number one, and the baseline of everything we're working through, is that this legislative privilege is absolute for all legitimate legislative activity. I didn't see any pushback from the district attorney's office that there is no privilege, or if it's legitimate legislative activity, the privilege has exceptions to it. And so the discussion and the back and forth between the briefs were, well, what constitutes legitimate legislative activity? And definitionally, that would mean you're on the floor and you're arguing, you're preparing a bill, legislators are conferring within the same side or across the aisle. That would all be in that sphere of legitimate legislative activity. If the legislators are performing a discretionary policy-making function, or an agent of the legislator is doing that, then that conduct is privileged and cannot be examined. Why did you say what you say? Why did you do what you do? That it would be one branch interfering with the business of another branch. That's our baseline. Flowing from that would be, I think, a bar from on the district attorney's office from asking anyone subpoenaed who enjoys that privilege or that immunity from asking why certain things were said on the legislative floor, in a committee meeting, et cetera. Or exploring what I'm labeling internal legislative preparation. What did you and your staff discuss as you prepared for the December 2, 2020 subcommittee hearing? What did you and another legislator discuss in preparation for that subcommittee meeting? The internal preparation is privileged. Where it becomes less clear, and I am presently leaning in the direction of ought to be allowed, is that a communication that a legislator or her staff member had with a third party, whether it is in connection with work that the legislator is performing or not, is subject to exploration by the grand jury, given that the grand jury is investigating possible third-party crime. We do not have before us at this juncture, at least not been brought to my attention, that any of the witnesses need to be worried about their Fifth Amendment rights. This is solely an investigation into conduct that the district attorney's office is investigating concerning third-party actors, not the specific witnesses at play here, the lieutenant governor or former Senator Ligon. So as an example, a question I think is permissible and what I want us to engage on next, in particular, starting with Mr. Samuel or Ms. Clark Palmer, would be a question from the district attorney's office or a grand juror. Mr. Ligon, did you speak with anyone, not a member of your staff or a member of the legislature, about planning, preparing, or convening the December 2, 2020 subcommittee hearing you chair? Yes, I did. Who was it? He's answered that question as well. What did you talk about? This would be the senator or his staff member talking with a non-legislative official. Fred Smith, not a legislator, not a staffer for any other legislator. Yep, we're going to have this hearing at which we're going to talk about rectifying the election. And this is what we discussed. This person urged me to do it. This person told me not to do it. This person said, you need to call person X to come down and offer his view about suitcases of ballots, things like that. I believe, pursuant to Gravel versus United States and other cases, that interaction, legislator or staff member with someone not within the legislative sphere, is not protected by the immunity. I appreciate that Mr. Samuel has relied on a Ninth Circuit case to say that it is. I don't think that's what Gravel says. That's a US Supreme Court case, which I would follow before I'd follow the Ninth Circuit case. But I'd like to start the discussion about where we're drawing some of these lines with that. And then Mr. Samuel, you can take it from there if you think there are other lines, guidelines that would be helpful as you work with your witnesses in advance of their subpoenas.
Thank you, Your Honor. I said to Ms. Clark before we came here, I could write, 20 to 25 minute opening statement and then we could put it in the garbage can because Judge McBurney is not going to be giving us that privilege. So
I read your brief, so you gave your opening.
You're exactly right. Yeah. Thank you. You're right. You're exactly right. So, you actually switched your conclusion there midstream. I'm a little unsure why. You said, at first you said that communications with an outside party involving third-party crimes could be the subject of inquiry. And then by the end, you were saying any third-party inquiry.
So I must have misspoken because, first of all, I'm not suggesting there was a crime anywhere. But if the grand jury is investigating alleged criminal actions by third parties, not the witnesses, then if their exploration leads to questions of a legislator or her staff members about communications with people outside that legislative sphere that are related to the investigation, I believe those are not protected by legislative immunity.
Okay, well, we do disagree with that, as you know from our brief. First of all, the Ninth Circuit case is very clear that it would inhibit communications between legislators and the people who inform them what are appropriate legislative acts, what are good legislative responses to a problem, what are bad legislative responses to problems. If those become an open book and anybody, anytime could ask them or subpoena them or force them to answer a question, what did John Smith, an abortion rights activist say to you about, or doctor say to you about, some issue. If all of that becomes an open book, you have eliminated a great deal of what the legislative privilege is designed to facilitate, which is truthful investigation, honest investigation, attempting to come up with a good response to a problem, avoid a bad response to a problem. You will inhibit not just the legislator from asking the question, you will be inhibiting the informant, the lobbyist, the person on the expert, the Georgia Tech professor, whatever. Doesn't have to be someone involved in this case. Your ruling, if it's true, would apply in all situations. Nobody's going to want to go talk to a legislator.
But it doesn't apply to all situations. If the key is that the grand jury needs to be investigating some, it's not just, hey, we don't like the way the debate on climate change played out. So let's start subpoenaing people to say who talked to Senator so-and-so about climate change.
Well, I don't know how you would ever control that with a grand jury that doesn't, come to you and say, let us tell you what the investigation is about before we do any. I mean, you don't know what the investigation is about. We don't even know what this investigate.
Well, so that's not fair because you can't, special purpose grand juries don't fall from the sky. They have to be authorized, a separate branch. It's not the executive branch that can willy-nilly say, today, let's have a different special purpose grand jury because I'm not happy with X. The judiciary. Okay, so you understand it. So then it's not actually that just randomly special purpose grand juries appear with no charter.
Well,
Correct?
You're absolutely correct. Judge Brasher, Chief Judge Brasher was very specific and so it does have a purpose, but I don't think that opens the door to all communications outside of the Capitol building itself. All communications that any member ever had with anybody, just because we're dealing with a special purpose grand jury. I think
right. It wouldn't be relevant if the district attorney's office asked one of your clients, well, what about gun control? Why were you, that's not within the scope of the special purpose grand jury's charter. So there are rails keeping the district attorney's office heading in a certain direction in their pursuit of should this be formal charges or not. And those are rails that your client would be able to invoke. Wait a minute, now you're asking me about gun control. That's not, this is why we're talking about guidelines.
Right.
So it's not anyone about anything.
Well, obviously it's not going to be about anything. If they're asking about the Braves score,
but it was your phrase, anything, not mine. I don't think it's anything.
Well, you haven't defined exactly what it has to be. If it has to be specifically dealing with, well, in this case, for example, does that have to deal with the committee hearings? The committee hearings weren't part of the special purpose grand jury. They weren't saying we're investigating the legislators or what the legislature did. They were looking, investigating efforts to, it seems to be, the former president of the United States and maybe other people involved in his circle, as opposed to the legislators who were doing inquiries, who were doing what we expect legislators to do, who were talking to constituents.
We won't debate about whether we expect legislators to say we should create a new slate of electors or not. That's not my role. Well, not your role right now either. But the role of the special purpose grand jury was defined in the order that Chief Judge Brasher signed, and it empowers them to investigate whether there were illegal efforts to interfere with the conduct, the outcome of the 2020 general election.
Right.
So that is in some ways a big topic, but in other ways it's not so big. And so, yes, the subcommittee hearings about what should we do with the 2020 election could be germane to that.
Well, I think that you ought to use as an analogy the crime fraud exception. We're talking about breaching a privilege here, a constitutional privilege, more so even than the crime fraud exception is just a kind of a common law privilege, the attorney-client privilege. And yet here we're talking about something that's enshrined in the Constitution, and it has been for how many years has it been? 300 years almost, that we are not going to interfere with the legislature doing its business. And its business includes talking to constituents, talking to experts, so they can figure out what they need to do.
Beyond the
fact that
older Ninth Circuit case you found, are there lots of cases, any Georgia cases, any 11th Circuit cases that say actually a legislator's interactions with a private citizen are within the protected legislative sphere?
The Ninth Circuit case certainly is the one that everybody cites over and over again as the authority. But there are other cases that talk about you can't ask a legislator his or her motivation. Well, wouldn't the answer to that be it? Because I spoke to a Georgia Tech professor who told me this about ballots, or I spoke to the former mayor of a big city and he told me this or that. You're saying he has to answer that question. Many courts, including Gravel, I think it's pronounced Gravel, but including Gravel, says that you can't ask about motivations. I agree with that. So that's going to, under your ruling, the legislature can say, well, I'm not going to answer that question. It's just because it was framed the wrong way, because the DA framed it as, what was your motivation for maybe a certain finding in your committee report? What was your motivation for investigating, whatever aspect that that the DA is inquiring about at that point? If everybody agrees you can't ask a legislator's motivation, and 90% of motivations are going to be based on, information coming to him or her, then you are contradicting your own rule. The crime fraud exception would require that they make a preliminary showing. Not Judge Brasher said that this is a legitimate, course of inquiry for the special purpose grand jury. And the crime fraud exception doesn't just say the DA gets to say it. I declare that there was that the client was engaged in an effort to commit a fraud or a crime. crime fraud exception, there's no such thing as attorney-client privilege. You've dealt with that, I'm sure, many times in your former role, and probably here as well. And there's very specific rules in the 11th Circuit about what the government has to do, what the prosecution has to do in order to invoke that privilege, what they have to prove to you, which is that there's something about the communication which makes enforcing the privilege not worth it.
So how am I misreading or misapplying the now correctly pronounced Gravel?
Gravel involved, as you know, the Pentagon Papers, and it involved and it's a weird case, really, when you think about the facts of the case. Gravel was...
Is this a normal case, the one we're dealing with here?
Gravel was involved in the Buildings and Grounds, committee of the U.S. Congress. He was in charge of, landscaping. That's the committee he invoked at midnight. He convenes the grand jury at midnight, and someone has slipped him or his aide a set of the Pentagon Papers. And he says, I'm going to take the Pentagon Papers, I'm going to put them in the record of the United States Senate, in the Journal of the United States Senate, and then he's going to have his staff person send them to Beacon Press. Right.
So strange facts make strange law. The conclusion of Gravel was, I think, along the lines of what I'm describing, but maybe I'm
because in that case, they were specifically investigating who stole the Pentagon Papers, as opposed to we can ask you any question about anybody you talk to, in connection with this grand jury that is investigating the theft of the Pentagon Papers. Not just, the person who was engaged in it, but we can talk to Daniel Ellsberg. We can talk to all these people. I'm sorry, we can demand that you say, Senator Gravel and Roddenberry, I think was his assistant, his staff person, we can demand that you tell us everything about how you came into possession of this, how you acquired it. Oddly enough, they also say, but you can't do anything to Gravel about it. The immunity did protect it. Right. But the communication, but it was very focused in that case. When you say, well, strange case, well, those are the facts of that case. And to broaden it and say, I'm going to extrapolate from that anything you want to ask about from, let's take Senator Ligon, anybody you talk to from November 3rd on, or before for that matter, about anything dealing with the election, you can ask them. I don't think the law allows that. I think you would be doing enormous damage to the legislative privilege.
So I'll let someone else fix the microphone you broke. What is an in-between ground that you think is more workable? Because you would say, nope, that's not an area that can be explored either. Assume that's not how it's going to play out. That the question was there the narrower one, as former Senator Ligon, was there anyone you spoke with outside the legislative sphere about preparing for that subcommittee hearing? What?
I wouldn't agree to that at all.
No.
Anybody you talk to prepare for a hearing would be, how is he going to answer the question? What was your motivation? We all agree you can't ask a legislator, what was your motivation?
If his answer is, I talked to Fred Smith, what? I don't understand.
Well, you're then saying that you have to answer the question as to motivation, which the court says you can't force them to answer. Even Gravel says that. All the Supreme Court cases say it. There are a long list of cases that say you can't ask a legislator why you did something.
Okay.
If you can't ask that, then you can't then, say, I'm not going to ask you why you did something. Did you talk to John Smith?
Right.
But you agree they can't ask why you did what you did, just what you talked to him? You're just making the motivation prohibition irrelevant, when in fact it is one of the key aspects of what all the cases say is the privilege. You can't ask what's going through the legislator's mind why he did something.
I agree with that. Okay. I disagree that finding out with whom someone spoke therefore proves motivation. I don't know with this situation how it would play out, but I suspect most legislators would say that a bunch of people called who were pro, a bunch of people called who were con. Have we thus asked the legislator what motivated you to vote the way you voted? I heard a lot of different perspectives on this. I hope they would hear a lot of different perspectives, but I'm asking you for something more helpful than that's why that's impractical, Judge. is there a middle ground you think is navigable between, nope, you actually basically can't ask anything about, which I think is consistent with Gravel, anything about interactions you had with these third-party actors?
I would say, first of all, use the Brewster, Renzi line of cases, the bribery cases. They talk about the ability to do that because obviously that's not a legislative act because you are engaging in a crime. Obviously, that's different than the question you're asking. But other than that, I would say the attorney-client, the crime fraud exception should be your model, where there has to be a predicate shown, not just Judge Brasher's order saying what the scope of this grand jury is looking at, but rather there's a reason why this specific question can be asked and breach the privilege. You are breaching a privilege because we contend it is privilege to begin with. You are breaching the privilege by compelling, you're going to be compelling the legislator to answer the question, it's in the record, we've already talked about it. What did Giuliani tell you? Right? I mean, that's what they pose in their briefing paper is, that's what the kind of question they want to be able to ask. What did Giuliani tell you?
Well, you read more into it than I do. My question was framed, not that I'm writing questions for anyone, is with whom did you speak? You get the list of people with whom that person spoke. You go talk to them. You don't need to ask the legislator what the person said to you. That's the evidence you glean.
Well, that wasn't clear to me. You're saying they can't ask?
I didn't say that, but that's why I'm asking you if there are lines short of the prohibition, which I suspect you're not going to get, are there a way? Because I don't disagree with you at all that getting into motivation is improper and can't be backdoored. And so I'm understanding a little bit more now why you're resisting me on this notion of, well, what's an in-between space? Because it may be sufficient to enable the grand jury to pursue what I believe it's entitled to pursue if it gets the leads, if you will. Well, I talked to these 5 people.
I apologize because I didn't realize that you were so limited, or at least maybe that was the proposal you were making midstream here, is, if the only thing the legislator is going to be asked is show us your phone records, I'd say you shouldn't do that. I think it breaches the privilege. But I can certainly live with that a lot better than tell me what conversation you had with somebody.
Okay.
If it's just identify the names of the people you spoke to. I mean, I can tell you from having talked to my clients without breaching either attorney-client privilege or legislative privilege, they all have thousands, more than that, hundreds of thousands of constituents who are writing to them, who are, calling them, sending them affidavits, telling them things. If all you want to know is a list of your constituents, if that's
I don't want to know anything, but I'm trying to understand where the tripwires are. And it sounds like more alarm bells go off in your head if the district attorney's office is empowered to say, tell me the substance of the communication you had with person X, then alarm bells go off. If it's, did you have communication with person X concerning the preparation for and conduct of the December 2020 subcommittee meeting?
Yeah, I don't want to waive my argument.
You waive nothing. You want no questions asked of your client that violate the legislative privilege.
That's right. And we contend that any questions at all is a violation of the separation of powers. We can get into that later when we talk about some of the other issues that the prosecution has raised here. But I would certainly be happier if you were going to make a ruling that said you can only ask them with whom did you have a conversation, but can't ask what was said. And obviously, the grand jury can question all those other people. There's no privilege if they want to go speak to John Smith, who's not a legislator.
Right. There's Fred, but yes.
Fred Smith?
Yep.
Okay. I'm sorry, I wasted too much time. If that was the only thing we were talking about, I would have probably.
That's all right. It's helpful to, the crime fraud exception is going to be a helpful framework for me to look at as an analog. Other things you wanted to cover, I want to make sure that Mr. Wakeford has a chance.
Well, obviously the big issue here is they don't concede that anything they were doing. My second client, Senator Ligon, was doing, none of it was a legislative act. Well, if that's true, you're halfway point isn't even a tenth away. They're going to call him in and they're going to say, tell us everything that happened in that room. Why did it happen? Who did you talk to? What did you say? I mean, I thought was going to be how we were going to spend an hour and a half today, is talking about whether having a subcommittee where they don't like what was going on or the findings or the recommendations. I certainly want to reserve enough time because I think that's the only thing they want to talk about. Frank, I don't know.
We'll find out what they want to talk about. I read their brief as well, and a thrust of it was that the December 2020 subcommittee hearing didn't constitute legitimate legislative activity. Certainly the form of it was a committee meeting, right, in the Senate. So it is, at least definitionally, legislative activity. There is argument made by the district attorney's office that it wasn't legitimate. I'll let them give the airtime they want to that. If I need any feedback from you because I'm persuaded by what they say, I'll let you know.
Or if you're even on the fence.
Correct.
Okay.
All right.
Kind of, 1 second.
Judge, quickly, it's Jim Durham. As long as we're pronouncing names correctly, it is Ligon instead of Ligon.
Someone told me Ligon. I apologize. So I've been.
It wasn't me, Jim. I've always called him.
Yeah. All right. Thank you, sir.
Sure. Is that the only thing you wanted to say, Jim?
For now.
Okay. Can I just
earlier next time?
Can I add just a few seconds, a second or two that Ms. Clark Palmer. I don't want people running to you, during the sessions, during the grand jury appearances and asking, well, they didn't frame the question right. So I think we should get specific. And the question is, how are they going to ask the question, with whom did you speak? Obviously, there's going to have to be some narrowing about who they want to know about. They may say, who did you speak to on December 2nd? They may say, who did you speak to? You don't have to tell us the topic about the election. Well, now you're getting into the content. So we're going to have to really think about how that question could be asked. If you come to that middle ground,
right? How
is the question going to be asked where the question itself doesn't answer what was the content? Because it's like the document searches, the Hubble case, where they ask the question and because you answered it, obviously it's untaxpaid money, right?
Right.
So whatever. So,
okay.
All right.
Thank you.
Thank you.
Mr. Wakeford, you've sat very patiently.
Well, Your Honor, there have been a few things covered. So where would you like me to begin?
Wherever you want.
Okay. Well, let's begin with third-party communications, since that's what most of the discussion has been about. I would direct Your Honor to the exact language of Gravel and its holding, delineating in that case what kind of questioning would be allowed. And in Gravel, the Supreme Court said that there could be no questioning of a senator or his aide, except as it proves relevant to investigating possible third-party crime concerning any act in itself not criminal, performed by the senator or by his aides in the course of their employment in preparation for the subcommittee hearing. So
it seems like it's tailored for your investigation.
And it says it's talking about any act. And it's sort of backwards because it's talking in the negative here. Here are the things you cannot talk about. Any act except this. So then, therefore, it's any act that proves relevant to investigating possible third-party crime performed by the senator or his aides in preparation for the subcommittee hearing. That is the extent of my response. That Gravel is clear in that instance that is the scope of what can be questioned. Additionally, we've talked a little bit about the Ninth Circuit case, the Miller case. As we state in our brief, that is a civil case. So on its terms, it's just not applicable in this situation. And the concerns discussed may be applicable about freezing possible sources of information or chilling debate or communication with constituents or something. That may be a concern that is relevant in a civil case where we're weighing concerns, weighing the importance of the immunity against a private litigation. What Gravel does is say, this is a criminal investigation. So the inquiry is different. That's what this is. The order impaneling the special purpose grand jury refers back to the request originally made, and it says that the grand jury may investigate any facts or circumstances relating directly or indirectly, which is language directly from the statute authorizing special purpose grand juries, any of that relating to possible criminal disruptions of the 2020 elections. So that's the remit. That's what the special purpose grand jury can look at. It's, as you've already stated, we can't go outside of that. But to the extent that it's an investigation of possible third-party crime within that sphere, I'm sorry.
Is that you?
I don't think so, Judge.
He's just going to act like that.
Yeah.
He's gonna act totally oblivious.
Exactly. Actually, Mr. Samuel has a button at his desk that he can press.
Should have known. To the extent that that there are questions within that sphere about possible third-party crimes committed with that exact description, then the grand jury can ask about acts in preparation. That's it.
So let's explore that some. Under your reasoning, is it an appropriate question to ask former Senator Ligon? Did you talk with the Lieutenant Governor about this? Your preparations for it, and what was his advice?
Well, it's interesting that you chose the Lieutenant Governor, because that in itself is a thorny example, because you have stated already that you feel like communications between members of,
That's why I'm asking, because I don't think Gravel says that the legislator or her staffer could be asked about communications within chambers, if you will. I'm Senator Ligon, and I'm speaking with my staffer about getting ready for the subcommittee hearing. I don't think the fact that you have this investigation into potential third-party crimes empowers you to ask that question. In other words, immunity is intact for that. Similarly, former Senator Ligon speaking to the Lieutenant Governor or another senator or a representative about preparations for conduct at, results from. Are we going to do a report? Who's going to write it? Senator Ligon says he'll write it. Great. If that again is the classic immunity protects, despite the existence of an investigation of third-party crimes. What I think Gravel says, it's going outside that bubble where it is allowed. Contrary to Miller, a civil case. And if you're saying the same thing, then I'm following what you're saying.
I have absolutely nothing to add to that formulation.
All right. Tell me if you want to share today, beyond what you put in the district attorney's response to the motion to quash, about a claim that the legislative activities that occurred on December 2, 2020 in the subcommittee that former Senator Ligon chaired were not legitimate legislative activity.
Point of clarification, Your Honor, I think it's December 3rd, 2020.
Okay, 1 day later.
Yes, Your Honor. The point that we had to reach, that we felt like we had a duty to make on behalf of the special purpose grand jury, was that the invocation of privilege here spoke to some lofty ideals and the reason for that privilege existing, all of which are true. The independence of the legislative branch is, of course, important. That's why it's there. The integrity, the legitimacy of the legislative branch, all of these things were mentioned, and all of those are important. But we felt, the district attorney's office felt, it would be that we could not go without commenting upon invoking this privilege to avoid questioning from Georgia citizens on the basis of legitimacy, when the actions contemplated here, although yes, in a hearing, in a report, suggested illegal extrajudicial activities by the legislature. And if the watchword, if the important word is legitimacy, we felt like a comment had to be made about whether that is a legitimate legislative act. And I understand, as you said, the form of it if the inquiry ends at the form of it, that is one thing. But the substance of it cannot possibly be said to be legitimate, or let me put it this way. The district attorney's office will not concede that the substance of that is legitimate.
So legislatures almost on an annual basis pass laws that courts ultimately conclude are invalid for constitutional reasons, any number of reasons. The fact that the legislators may have been well-intentioned or not, which we don't explore because of the immunity, results in a law that a court later on throws out efforts that were made. You can't do that, unconstitutional, or your own laws prevent you from doing that. Wouldn't be a reason to go back, I think, and say, let's explore the how and the why and the who of that subcommittee that yielded that law that prevented transgender individuals from participating in high school sports, something like that. Someday that may get challenged, it may get reversed, but I think if a lawyer stood up on behalf of a legislator who helped get that passed, who was then going to be investigated for, where'd you get your information that this was an issue and a problem that needed attention, the door would be slammed in that effort to explore that. How is this different? Your conclusion that, and maybe ultimately correct conclusion, that the Georgia legislature didn't have the authority to submit a different slate of electors.
I understand the point that Your Honor is making, and I would simply respond that the point that the district attorney's office was trying to make in its response was in response to the invocation of the immunity on the basis of legitimacy. And we actually heard from opposing counsel, Mr. Samuel, earlier in this hearing, that the invocation would inhibit truthful communication. And we think in the context here, with what occurred, that is
ironic.
Not ironic. It's not something that can go uncommented upon. But I understand where Your Honor, what Your Honor is saying.
Okay.
If I could just have one moment, Your Honor.
Sure.
Did he take a position on exactly what they asked about? He basically said they should go much further.
The Constitution is different from what's in the federal Constitution.
Oh, I'm not sure about that.
No, yeah, but this, I don't think that's not how it reads in there.
Thank you, Your Honor. I just had to confer with the table there for a second.
Not a problem.
There was another subject that was brought up. And as I said, I believe our position on that is clear, and we've made the point we intended to make. But we can provide more information to the court as it requests.
Okay.
More argument. There was a mention of the Fifth Amendment as well. And I want to make clear that this conversation is about legislative immunity and privilege. The Fifth Amendment rights are a separate conversation and also never go away.
And to be clear, I brought it up. Mr. Samuel didn't. And it was just as an example of, sure, if the conversation veers in this direction, it might be a Fifth Amendment privilege that's being invoked. That was not Mr. Samuel's point. I was just in trying to work through the contours of his argument.
Right.
I brought that
I
up.
understand. And I wasn't suggesting that it was brought up by him. I just meant it was mentioned. Don't worry.
Yes, it was mentioned.
Casting aspersions. No, but it was mentioned, and I wanted to clarify for Your Honor. This is a question about the application of legislative privilege and immunity. And one place where it overlaps with the Fifth Amendment is, and this is very clear, criminal acts are not immunized. And so there may be situations where there is a witness can be called before the special purpose grand jury and ask a question, and their Fifth Amendment right, they can invoke their Fifth Amendment right. There's nothing that any power on earth can stop them from doing. from doing that in that scenario. But the legislative privilege has nothing to do with it. And I just wanted to be clear about that. And the purpose of the special purpose grand jury is to investigate this subject. It is not to hand down charges like a normal grand jury.
Merely recommendations.
Right. So the witnesses, to the extent that as we've gone over, they are relevant and have information that they can provide the special purpose grand jury, come forward. If they have rights that they can invoke, they can still do it there.
Right.
The question is whether the question can be asked in the first place. And if a question is about, well, we've already covered one area where the questions can be asked, but another is if a question is about commission of a crime, privilege does not prevent the asking of the question, but the Fifth Amendment privilege exists for them to say, I don't have to answer.
Right. No, I agree.
To make that clarification.
And much of the case law that Mr. Samuel highlighted in his motion, I think one of them is Georgia-based, Representative former Congressman Swindle. It's too late if you let the question be asked and then maybe even answered and say, well, let's stuff that genie back in the bottle. That's as to the immunity. That's why we're working this out in advance.
Right.
So that someone doesn't feel compelled to answer something where later on someone decides, oh, that one you didn't need to answer because that was protected by the immunity. So I guess my last question for you, and if there are other things you want to cover, let me know. I've shed some light on one dimension of a guideline that I'd like to set forth, which is going to be along the lines of the permissibility of asking a legislative witness about contacts with third parties. So outside the legislative sphere. Senator Ligon, with whom did you speak about X? I suspect I'm going to say that's okay. Are there other dimensions of your inquiry that you would want to try to lay some general framework in place so that it doesn't explode every time it comes up?
I think, I'm glad Your Honor asked. I think that certainly we've gotten far enough to say questions can be asked. Who did you talk to? Who did you talk to prior to the hearing?
Well, there may be something hung around that. To Mr. Samuel's point. Well, you know what? My staff gets 10,000 calls a week. And when we were getting into towards December 3rd of 2020, it was 100,000 calls a week because I'm a senator, and maybe I'm adding too many zeros because it's a state senator. And so I didn't mean it quite like that. I assumed it would be a little more cabined. Either did you talk to so-and-so or with whom did you speak who wasn't just a constituent, that kind of thing. But either way, assuming that category of questions is assuming it's allowed, are there other areas that you know will be recurring across legislative witnesses that you think we ought to try to sort out in advance?
I think that going past merely contacts to the actual conversations is something that the special purpose grand jury will likely, almost certainly want to ask about. Okay, well, you talked to them. Did you talk to X? Yes, I did. Well, what'd they say? At that point, I think that Gravel makes clear that any act is more expansive than just what happened. And the content of the conversation, what did they tell you, doesn't speak to we're not asking about motivation. We're not asking about why things occurred. We're asking about what information came to you as you prepared for the hearing. And this Gravel is about sources. And to the extent that there is information coming in preparation, then the special purpose grand jury should be allowed to ask, what information? Okay, so you spoke to John Q. Well, what did John Q say? I think that's the next logical step. And that category of question, I think, would be allowed, with the exception, of course, that we can't say, okay, and is that why you did what you did? Or why did you, any of that would be foreclosed. But what did they say to you, I think is encompassed within the ruling in Gravel.
It does get closer to the sphere, the area of motivation. If the answer is, I only spoke with this one person, what this person say, it would be hard to insulate that from now you're exploring potential motivators. I mean, to Mr. Samuel's point, any feedback, any input that someone received from a third party is a potential motivator. And I appreciate you're not saying the follow-up would not be, you agree it would be impermissible. Oh, so that's why you did X. That's where this report came from. Because then you're getting into the thought processes and the reasoning. So I'm going to need to work through a little bit about the content question that you'd want to ask in particular, because is there not a safer, equally valid source? Sure, it's a conversation. And so it would be talk to that Fred Smith.
Yeah.
Not that, I mean, I understand there could be issues with that as well, but I think pushback and protection would be, now you know who I talked to, they can tell you what it was we talked about.
Well, Your Honor, that we have two competing concerns here. There's the concern, there is legislative privilege and immunity and all the concerns that are protected by them. And there's also the duty of the grand jury to pursue its remit, to do its duty, and to thoroughly investigate possible criminal activity. And so I think when you're talking about what did this person say to you, that we are drawing the line there where there is legitimate inquiry allowed to be made by the special purpose grand jury without getting into motivations of an individual member.
Okay.
I also want to mention one other thing, Your Honor, which that we have not gotten into, and that is communications. Well, actually, no, never mind. I believe Your Honor said that your understanding right now is communications between members and their staff, correct?
Protected.
Understood.
Correct. So that sphere or bubble I was drawing, I think very, very clearly, strongly protects, immunizes legislator to legislator communication, legislator to staff, staff to staff. That's all within, I mean, if you think about it sort of figuratively, that's happening under the Gold Dome or those flat roof buildings nearby. And that's the protection. But when you get that phone call or that email, or I was back in my district and I talked with so-and-so about X, that's the third party that I think Gravel, in this narrow context with the remit that the special purpose grand jury has investigating possible third party crimes, opens up.
Okay. If I could confer with the table, just 1 second, Your Honor.
Confer again, not a problem.
All right, well, Your Honor, unless you have any further questions as to this, sort of the topics we've covered, or if there's anything else, I still think we have some scheduling and sort of logistical conversations to have, but I'll sit down at this point.
Great. And I won't neglect to say, is there anything else before we wrap up? Because we will cover the logistical. That's why one reason why Mr. Durham is on for his client, former Senator Ligon, is to sort out when that grand jury appearance might occur.
Well, that's okay, Don. The question was, is there anything else? I'm sure there will be, but this is sort of where we run into the inquiry for each member, each witness is going to necessarily be a little different.
It will be.
There will be other subjects to the extent that they apply to everyone. I don't know that there's anything I'm going to speak to now.
Okay. And I suspect that as we work through this over the coming weeks, we'll develop additional guidelines. And it may well be, as your team, as the district attorney's team thinks through it more, they can bucket witnesses into, well, these are folks where we want to understand third-party sources. And these are folks where we need to know when they were somewhere. Well, maybe that's a different set of concerns for Mr. Samuel and his team, and we'll have to work through that. All right.
Thank you, Your Honor.
You're welcome. I hadn't invited you up, but tell me what you want to tell me, Mr. Samuel.
Well, I wanted to respond to some of what the prosecution said, but if you don't think it's necessary.
On the legitimacy side, I don't need to hear anything unless you just can't leave without saying it. You can't. Okay.
Here's the problem. I can't believe it's not going to rear its head again, only because it was such an important part of their brief they filed yesterday. It was the essence of why they said they were entitled to do anything they want with the grand jury with regard to Senator Ligon, at least. And if in fact they have just waived that entire argument, they agree it was legitimate or the inquiry is irrelevant, then I suppose I'd be wasting time. But I just,
Okay, I didn't hear them waive it. I don't think they've waived it. They've communicated to me what they felt they needed to communicate. I understand what's in their brief.
And I haven't briefed it because it was never raised beforehand, which is the only reason I want to make some observations about it. I never addressed that issue.
I understand. If you want to make 30 seconds of observations, you can. You don't need to make more than that.
Okay, my problem with it is defining legitimacy. Who's going to define it? Is it you? It sounds like you are going to. My problem with it is this repeated assertions in their brief that the findings that the senator made were false, as if somehow that makes it non-legislative. I mean, you kind of observed it yourself. Tell me when I'm running out of time. That sometimes the legislatures do unbelievably stupid things.
I didn't use
politicians.
that. I did not say stupid, just that courts.
And
ultimately-
unconstitutional.
Yes.
They do all kinds of things that don't make sense in hindsight, but they investigate. They're oversight. They're trying to figure out the truth about things.
So you actually did argue it in your motion. You just didn't label it legitimacy. It was the importance of legislative inquiry. And sometimes there are outcomes with which we disagree and are reversed, et cetera. And it was very well written. And I read it.
Thank you.
You're welcome.
With regard to, it sounds like they're not agreeing to your middle ground, but maybe you're still up in the air about that anyways, about who you can talk to and what you can say to them or ask them. You can ask Fred, but you can't ask the senator. I would just remind the court that the speech and debate clause, or whatever we call speech or debate clause, not speech and debate, speech or debate clause, and what we have in our state is absolute. You began the presentation today by saying it is an absolute privilege when it applies. And what it says is no member shall be liable to answer in any other place, which includes the grand jury. That is a place, for anything spoken in either house or in any committee meeting of either house. Clearly, that applies to the reports. It applies to the minutes. They cannot be asked anything about those matters. They want to go ask Fred Smith, they can ask Fred Smith anything they want to ask. But there's no exception.
True, but it doesn't say or communications with outside parties. It says
I understand
in the
that.
committee, the subcommittee, in the reports, et cetera. So if it actually said that in there, you wouldn't need to rely on the Ninth Circuit case. You'd say,
well, I'd also bring to the court's attention another case, Brown, which is in our brief, which is a DC Circuit case. I'd also ask you to, and Brown says you can't talk about documents they received, right? I mean, that's the same thing. You're talking about outside information coming to you, which informs your legislative decision-making, the discretion. And I'd also point out one more thing for what it is worth. We are not bound by the Supreme Court decision in Gravel, as you observed before. It's very persuasive. It's very helpful in understanding how the feds deal with these issues. You ought to read the dissents in Gravel. It adds another 20 or 30 pages. Justice Potter Stewart says, absolutely, you can't ask anything about outside sources. Justice Brennan, you can't ask anything about outside sources. We don't know how the Supreme Court of Georgia will rule. What they're going to, we never do we?
No, we don't.
Enough said. And the point is that we are not bound by Gravel. This is not a federal district court. This is not an 11th Circuit that's bound by Gravel. We look to Gravel for guidance. We may very well want to look at what the other justices said as well about the importance of preserving the integrity of all the communications as long as we're dealing with legislation. If the senator, I'm not talking about my client here, is out there just soliciting a bribe from John Smith or Fred Smith, clearly we're outside the realm of legitimate legislative activity. But if he's talking to an outside person and the outside person is saying the election was a complete fraud, that is legislative. He's trying to figure out what do we need to do? What should we do with absentee ballots in the next session? And they did address it. Right? They had this committee hearing. They listened to a whole bunch of people. They talked to a bunch of constituents. They talked to experts. They talked to ex-mayors. And then they addressed it in legislation. SB 202, the next January, February, dealt with the very issues they were investigating during that. So I'm worried about inhibiting their ability to acquire information. The more you tell them, it's an open book. And I agree, the grand jury has an unbelievably important function in this state to pursue its mission. I've never disagreed with that. You know, the DAs these days want to abolish the grand jury in this state, right? And just have, you know, everything done by accusation. Putting that aside, we think the grand jury is important, but the grand jury has rules, and we have privileges in this country. We have the attorney-client privilege. We have judicial immunity, right? All these things. We have prosecutorial immunity. We have qualified immunity for law enforcement. There's all kinds of rules that inhibit, quote, the search for truth. And they are unbelievably important. And this privilege is as important as anything because it's in the Constitution, separation of powers. If you let the judges start inquiring legislators, why did you do what you did? Or the legislators start asking you.
I saw your parade of evils, and what if the judge who rules that the subpoena shouldn't be quashed gets hauled in front of the Senate subcommittee?
There you go.
Yikes.
Amazing. It'd be unbelievable, wouldn't it? So I hope you keep in mind, you know, what's good for the goose is good for the gander in this situation.
Understood.
All right.
Thank you.
Thank you.
I'm sorry, Your Honor, may I respond to one legal point made by Mr. Samuel, and I'll sit down.
Yes, except you don't need to sit down because then I'm going to ask you about former Senator Liggins' scheduling. That's again why we got Mr. Durham. He's welcome anyway, but we need to sort that out since we've got everyone together.
Yes, Your Honor. There was mention of, I believe, a case called Brown. The DC Circuit is, to my knowledge, as I stand here, the only circuit which has ever recognized a non-disclosure privilege attached to the privileges and immunities for legislators. The Third Circuit and the Ninth Circuit have explicitly rejected that idea. So Brown, I mean, if we're looking to dissents and isolate it, I mean, you can find an argument. This is an issue with lots of opinions and very little Supreme Court precedent, which makes the Supreme Court precedent all the more important. And what the Supreme Court has told us is unequivocal that these questions can be asked. The only other thing I want to point to, and I think it's an important concern that has not been brought up, is that the Brown case in the DC Circuit, where they recognized a much more expansive definition of this immunity than anyone else, it hinges its decision on the point of distraction. That these questions, these cases that can be brought against legislators are distractions from their official duties that they are not supposed to be subject to. And I think it is important to note that Mr. Liggin is no longer a senator. So the animating concern in the Brown case and in the DC Circuit's reasoning is not present with regard to the movement, Mr. Liggin. He is no longer a member. So
I appreciate that. I think the concern would be the precedential value because, well, one, you may also have subpoenas for current active legislators. Note, they're not in session right now, so it's a different type of distraction.
And the inquiry would be different with regard to them. We would argue if I was simply pointing out that the basis of that distinction in the DC Circuit is distraction.
Okay. Well, I will review Brown again.
And that case is discussed. I have some citations to other decisions which have analyzed Brown
and didn't like it.
That is, it was mentioned actually by Mr. Samuel, United States v. Renzi, R-E-N-Z-I. That's 651 F 3rd 1012.
All right.
And from the Third Circuit, in re Fatah, I think, F-A-T-T-A-H. That is 802 F 3rd 516.
All right.
I believe if now we're going to move to discussion, and obviously on any of these points, if further briefing or clarification is needed, we're stand ready to do that.
I won't be scarce.
If at this point we're moving to a discussion of Senator Liggins' scheduling, I believe Mr. Nathan Wade, I think, is going to present for the District Attorney's Office in that regard.
Okay. Are you all right, Mr. Samuel, if we pivot away from this topic, work through former Senator Liggins' schedule, Mr. Durham's schedule as well? Because as I understand it, Mr. Durham, you still with us?
I'm here.
You want to be here, meaning in Fulton County, when your client is appearing in front of the grand jury so that you can play the role that we're envisioning should an issue arise where your client thinks maybe I need to invoke a privilege here.
That's correct. And I also think that my appearance, there are issues that may be broader than the legislative privilege.
Okay, but either way, broader or narrower, the scheduling issue is that you want to be here and you've got a big trial somewhere that you're saying would make it difficult for you to be here at the current date of the subpoena.
That's right.
All right. Well, why don't you start and then I'll hear from Mr. Wade. Why don't you tell us, I don't have it right in front of me, but you've got a trial somewhere, you attach the trial notice, et cetera. When are you not available?
I am not available from, first of all, I'm not available on the date of the subpoena, which is July the 20th. My trial begins July the 18th. It is scheduled to go 4 to 6 weeks. The week before that, which he's not been subpoenaed to, would also not be available because of, I'm going to be trying a 4 to 6 week trial starting on July the 18th. The earliest I think I will be available, if it's a 4-week trial, will be August the 12th. The DA's office offered as far as, I believe, Thursday, August the 4th, which obviously is still within the trial period. If it's a 6-week trial, it'll be over. That would put me at August the 26th. My proposal would be is that I just simply let the DA's office know what is going on with the trial and agree that within 1 week of the trial being over, that Mr. Ligon could testify before the grand jury. So for example, if it's on the 12th, that's when the 4 weeks are over. I'm in contact with the DA's office and say, look, if you guys are Tuesday, Wednesday, Thursday, which is what I was told the grand jury, special grand jury is meeting, then my client, Mr. Ligon, can appear on that following Thursday, which I believe would be the 18th. But obviously, if it lasts 5 weeks, but regardless, I think I put in the motion that in any event, it would be no later than that. I believe that's that Thursday, September the 9th, would be no later than. That would obviously be longer, further out than the 6 weeks. The judge down in Brunswick, which is where I am right now, is not going to allow the trial to go past 6 weeks. I don't know if he's going to allow it to go past 4 weeks, but this is a case that has been filed in 2019. I'm representing 21 plaintiffs. My co-counsel is several attorneys from Bondurant Mixon. There are 75 attorneys for the defendants. There's 3 pharmaceutical distributors. It's a big case.
Okay. Lots of big cases out there. Thank you for sharing that. Mr. Wade, your thoughts and good afternoon.
Yes, sir. Good afternoon, Judge. Thank you for taking the time. A couple things that the District Attorney's Office would like to deal with. First off, Mr. Durham points out that in his motion, he points out that he is co-lead counsel. So if need be, I think that the other lead counsel could probably take over for him for that few hours gap of time in that trial. That's the first thing.
Okay, so let me pause you there because you said few hours. And that was going to be my question. How long do you envision Mr. Ligon's testimony to last? And you're having to ballpark it, but 3 days, 3 hours, 20 minutes?
Maybe 3-4 hours.
We'll call it half a day.
Half a day.
Okay, all right.
The other piece of it is at the end of Mr. Durham's statement here, he stated that there were 75 other attorneys involved. Certainly one of the 75 could potentially step in and help him for those few hours. But here's the concession from the state. We could potentially move Mr. Ligon's testimony up to July 12th. And that is clearly outside of the conflicted time. Just purely in the spirit of compromise, we could do that. Or if he needs to move it a little sooner, if he'll concede to coming in before the 12th, we can move mountains and do that for him.
Your preference is sooner and not September?
Absolutely.
Because of the way information is flowing and the way in which your team is compiling, presenting information to the grand jury?
Yes, sir.
Okay. So Mr. Durham, tell me why between the middle of next week and the start of your trial, you're going to be unavailable for half a day.
Well, Judge, as you know from your own experience, it is not going to involve a half a day. It is going to involve me sitting down with my client, preparing him for the grand jury. I do not have 2 days to give up in order to prepare for this case. That's number one. Number two, I was told by the district attorney herself that next week was off, that during the 4th of July week that there were not going to be meeting. But even if they were,
And to be very clear, I don't set the dates, and I'm confident that was a valid representation. I was just trying to explore your schedule. You've now shared, gosh, I need a whole day to prepare my client. Well, that could be next week, and then it's only part of a day the week after that. So I don't know. Also, not sure why you and Mr. Ligon haven't already started talking about this, and I'm sure you have. But my question is why a half day that I know you'd need to give up for the actual grand jury time is something that you can't provide between now and the start of your trial. And you're telling me what I expected you would, which is a big trial. I need that time to get ready for trial.
right. And as it relates to what was said about the 75 attorneys, it's 75 attorneys on the defense side.
I understand. That's what you said, not on your side. I got that. I wouldn't expect someone on the other side of the V to manage your presentation. They may love to. I'll take that up while you're gone, Mr. Durham.
I say I'm co-lead counsel, but Judge, I'm picking the jury. I'm giving the openings, and I've got over half of the witnesses that are going to be presented during our case in chief, and a number of the cross examinations. It is, for a special grand jury that has been scheduled to last a year. I don't know that the date given to me, August the 4th, moving that 2, 3, at the outset 4 weeks is a huge concession by the district attorney.
So, Mr. Wade, the 3 dates that would be available, I think, the week of July 11th would be 12, 13, 14. That's the Tuesday, Wednesday, Thursday.
Yes, sir.
And you're willing to have Mr. Ligon fit in anywhere? First thing, morning of the 12th, last thing, afternoon of the 14th.
Absolutely.
Okay.
Judge, and I'll say it again. I am moving down to Brunswick. I live in Savannah. I am moving down to a hotel in Brunswick on that Monday. My availability to drive up to Atlanta to speak and prepare my client during that week is 0.
I don't know where Mr. Ligon's home is. Is he closer to Brunswick and Glynn County, or is he up in Blue Ridge?
No, he's in Glynn County.
Oh, so it would be you're close to him.
That's right.
Okay. All right. Anything else, Mr. Durham, you want to share with me about your busy schedule?
No.
Okay. I appreciate that. Mr. Wade, anything else in terms of your team's scheduling for that week of, I'm calling it July 11th just because that's the Monday. I know that's not an available day. Okay. All right. And again, I wasn't trying to tread on anyone's scheduling space. Accurate statement, no grand jury activity next week, the week of July 4.
Unless there's some emergency situation that will arise.
Currently, no activity planned. The grand jurors are looking forward to a week off. Okay, thank you.
Judge, can I ask whether or not there is grand jury time that's been scheduled during the weeks of August? Outside of the August the 4th that was offered to me?
You know what? I'm going to let you guys work through that. I've heard what your constraints are, and I've heard from Mr. Wade, and you and Mr. Wade can keep talking about that stuff. I'll weigh in as I see fit. Thank you. Mr. Samuel, anything else you want us to discuss while we're all together concerning your motion, not scheduling?
No, Your Honor, thank you.
Your witnesses, I appreciate Mr. Durham is the one who would be there for Mr. Ligon, but the two people on whose behalf you're speaking today, Lieutenant Governor and Mr. Ligon, they're both July 12 subpoenas right now?
No.
No. I ask only because I need to get some guidance out that's timely. If I get guidance out in August, that's less helpful.
Ligon is what you've been talking about with Jim Durham. He's not the 12th.
Right.
No, he's the 20th. So he's the 20th. When is the lieutenant governor's?
12th.
Is the 12th. Okay. The 12th was rattling around. We had to have this session before you turn into a marital pumpkin, not your wedding. So the lieutenant governor is currently, okay. All right. So I need to get some guidance out for that date.
And there are others that week
who are hovering in the background,
who are going to want to know the answers to the questions, and their lawyers are going to want to know because their lawyers call me every hour. So they're going to want to know.
Okay. I'm not trying to delay anything.
No, I just want you to not think once I take care of Lieutenant Governor, I can take another week off. There's going to be more, I think, on the Thursday. I'll talk to them about when, but
I'll speak with the DA's office separately. We are developing a communication plan, so I know hot days versus not hot days.
Right.
Okay. Thank you. All right, Mr. Wakeford, anything else we need to cover?
Other than the fact that individual issues will inevitably come up and have to be discussed, nothing right now.
Okay. Then I see as the next steps, I need to do what I can to resolve Mr. Ligon's scheduling conflict. I need to provide some guidance to Mr. Samuel and his clients and the district attorney's office. And then I'll work independently. I'll reach out to Mr. Wade, but he can deflect me to the right person so that I'm knowing when dates are going to be approaching where we think there may need to be my availability because you're forecasting that a witness is going to say, that's a question I'm not going to answer. Okay, fantastic. Well, I appreciate everyone's time. I apologize for the initial name mispronunciation, but I will get to work on this. I hope everyone has a good 3-day weekend and beyond. And I'm going to ask you to get the heck out of here because I have a jury that needs to come back in here and pick up the criminal trial. Thank you.
yeah.
You're welcome. And thank you, Ms. Hill. Really? So you're now in for retirement? Or you just... Really? Congratulations. Judge Adams's court reporter went to the feds here and loves it. Good for you. Yeah, I know. It's just such a different pace. Yeah. No, Miami, yeah, but here it's just it's a for that role, that's a good development. Oh, yes. Not good. You'd be ex-dad. What, where in the list of 97 kids does this one fall? Really? Last of the bios. Yeah. But you have more girls? Because it's more of a production. I like this. Yeah. Little badges get you through strange doors, I've learned. See ya. I gotta go finish my donut. My breakfast.
You said, hey, John, I didn't get it done. I didn't get it done.
So one left? You know this guy could kill it. He still has a little right here. He doesn't know it.
It's kind of hypothetical, but,
So that's why I'm going with it. So that's not what I would ask.
right. I think that I would understand kind of see kind of deal with that.
Thank you.
Oh.
Yeah, just put it next to the chair there.
Yeah. You want to see what all those.
Yeah. Okay. You know you turn on YouTube, right? And then you can see what's going on. Okay, you know you YouTube. Yeah. See. Asia. Yeah. Because I can send it right now. I have it. I'll send it right now.
Same. We'll go to our room. Same.
It's the same.
Yeah.
It sure is. All right, you
Clearly.
gonna get it out again? Right. But you know what, you should, I know, you should actually show it, because they will remember that it'll look the same, so just, let's make sure it's showing. Right, right.
They're gonna see it's not forgery.
Right, that's the important, that's the part. The important part.
And that's part of the accusation is this forgery. Or crap. Absolutely no.
But you know what
basis
you
to claim
can
that.
do? You actually, you could, well, no, I guess you can't. I guess in closing, I could put both next to each other.
Yeah,
You're in the hallway.
and then they can make their own call.
Correct.
But
But just try to get one in from this group. I guess they will.
Assume the judge has not had a break.
I was really showing, so I'll just say.
Oh, yeah, mine is. Thank you. Hold up, Lord. Lazy. Thank you.
Are you with it? Okay. You're in school then? Yeah.
NYU.
NYU? Are you from Atlanta or you just came down here for this?
Just came down here for the internship.
Thank you very much.
Yeah, of
Awesome.
course. And there's that.
Okay. I don't know if you want another copy for them, but.
I got it.
Oh, okay.
She made it.
Oh, okay. No, I didn't know if you wanted a copy for.
Oh,
someone else.
maybe, I don't know. When the time comes to argue that, maybe. I don't think we're doing that today. I think it's gonna be tomorrow.
Oh.
Or, yeah, constructive tomorrow.
Oh, okay.
Are you ready, Ms. Rivers?
Yeah.
I know you're having to rearrange everything. Let me know when you're good.
I forgot. I thought it was today.
I don't think we're getting that kind of.
Yeah.
God bless you. Thank you.
All right, hold on one sec. No, I had started something because you were busy. All right. Ms. Hilton, are you ready for the jurors to come back in?
I am, Your Honor.
But
Well, a button, Your Honor, we have 4 witnesses outside.
okay,
In our ideal world, we would like to get to all 4 of them today.
okay,
Which may lead us to maybe a little over, not too much. And so our request is that we can have all 4 go today, and then we believe we would probably rest either Tuesday or first thing Wednesday morning, depending on how long Dr. Lee Parker is.
okay,
If that request is granted, then Your Honor, if we're going to move in a quick fashion, then we would need the rulings for Mr. Thompson and Dr. Holmes. Moving through one after the other.
okay. So Mr. Thompson, I can't rule on till he provides some testimony outside the presence of the jury. So maybe we could do that during an afternoon break if we do an afternoon break. The doctor, you and Mr. Korn were to have spoken during our extended lunch break and maybe refined a bit the nature of the concern. I'm happy to talk about the doctor now, but the way I thought we had left it with the APS report is that I need testimony, not in front of the jury, about here's what we have to do as our agency. We're obligated to do X and Y. Is purely ministerial that we send someone out and this and that, because that I think would get some of the APS reporting in, and then we could discuss about whether some of the narrative comes in.
Well, he's here. And
Okay.
in my ideal way, that I would like to bring in the witnesses, he would be number 3, and the first are pretty short. So I don't think a afternoon break would really occur before it would be silent. That's what we do that now. We could literally, it would be 1, 2, 3, and my last witness would be Dr.
Okay. Mr. Korn, have you had a chance to look at more, think more about the APS report?
I have, Judge, 2 things. One, you indicated that you saw a line where in the report where it said it was not substantiated.
No, I didn't. I said I didn't see in there one way or the other the kinds of things that you see at the conclusion of a DFACS report. If there's a report made to DFACS and they are dispatched, there's usually that conclusion. I didn't see a conclusion in this one. It was, I had 3 contacts. I contacted the medical provider who said everything seems good. I spoke with Ms. Rooks. I spoke with Hilius Rooks.
On page 6, there is that conclusion.
Oh, well, let me look.
Page, there's no page 6.
Understood.
Page 1 of 1, 2 of 1 of 2, then it starts over again. It's the 6th page in the full document.
Substantiated. Okay.
So
that would be a page we wouldn't show.
correct.
There's a conclusion.
So we want to make sure that we're clear on that. The other thing is, if the question is whether this is testimonial, and we'll obviously we'd have to talk to Mr. Thomas about that, but I did check with the APS. Well, Ms. Jenks found it. Their policies and procedures manual, they are reporters, mandatory reporters, and if they find neglect, they're obligated to tell law enforcement. So I can't imagine what this else would be for, but
Okay.
review of litigation.
Then let me ask, is it Thompson? Let me ask Mr. Thompson a few questions under oath. You can as well, and Ms. Hilton can, and that'll help inform my sense of what we do with that. Before we go that far, though, tell me, to what end would you want to use, assume some or all other than the part that says substantiated and alleged perpetrator. So I mean, that doesn't come in. What's the relevance of this coming in? It's from 2014, 3 years before Ms. Rooks's death.
Yes, Your Honor, it's the state's theory because in this case that the defendant failed to give her, provide her medical care at the point in time when he assumed her care. And Your Honor, it would be relevant to show that during the course of these years leading up to her death, he was told on multiple occasions. Once, which we'll get into in a moment, at the ANC Medical Center, that she cannot be left alone and that she needs certain care. And at this point in time, in June of 2014, he was also told she should not be left alone and also provided resources or told about resources in order to assist his mother in her care. And I think a part of the defendant's theory itself is he had no one to help him. No one ever provided him any help. No one ever gave him any assistance. However, consistently through witnesses and now through an agency designed to protect adults, they, with their concerns, said, you are her caregiver, here are some resources. And I believe that is important and relevant for the jury to understand that consistently over the course of time, he was given resources or told about resources to assist him.
So not a conclusion by APS that the concerns were substantiated, but instead the fact that once again, someone alerted, once again, you contend the evidence shows, Mr. Rooks was alerted to the needs of his mother and offered resources to assist in meeting those needs. Okay. And if that's the limit of it, this is a question for Mr. Korn. If that's the limit of what the state wants to do, isn't there a way to redact some of what's in here or exclude certain pages? Or you think that's not?
I don't think that's a limit. I think that's a very expansive testimonial bit of information that's not subject to cross-examination. I would request that not be admitted at all.
Because you wouldn't be able to ask Ms. Moman about what she told your client, for example. Okay, understood. Let's get Mr. Thompson in here, please.
Remember the report came from somebody who didn't even.
Correct. And you're not gonna be able to cross-examine Moman related to all of that lead up. That's also another important piece.
It's the whole testimonial.
Right. It's like hearsay, caption, hearsay.
Always been hearsay. But they use it to prove the truth of the matter, certainly, obviously, but it's testimonial.
My name is Dante Thompson. That's spelled D-A-U-N-T-E. My last name is T-H-O-M-P-S-O-N.
Mr. Thompson, I'm Judge McBurney. I'm going to ask you a few questions. There's no jury in here. We're trying to establish some basic parameters of the nature of the work that APS does and maybe did in connection with the alleged victim in this case, with whom a colleague of yours had contact, but your colleague, Ms. Moman, is deceased. And I trust some of that's been explained to you already. But I needed to just better understand the framework of the work you do. The lawyers for both sides may have a couple questions for you. Then we're going to send you back outside, and then you may come in again, get sworn in again so the jury sees it, and then answer questions for the jurors, okay?
Okay.
All right, couple questions, well, several questions from me. If your agency receives a web report, I've got concerns that the lady next door is being neglected, she seems to be left home alone, it smells strange over there, whatever the complaint is, does APS and it's an elderly person, does APS have to investigate that, or is there some screen or discretion that your agency can use? Like, nah, we're not interested in that one.
If the allegation is as you stated it was, then yes, we would have to go out and investigate. They do have a screening out process, but it's all on a case-by-case basis.
Okay.
We have a unit called Central Intake that receives all the web referrals and telephone calls that are received.
So the fact that there was follow-up in what I'll call our case, Ms. Rooks's case, means that the anonymous online complaint that APS received passed that screening test.
Yes.
In other words, whatever was alleged was enough to have someone dispatched.
That's correct.
Okay. Does the person who is dispatched, in this case it was Ms. Moman, have any discretion as to with whom she speaks? Can she say, you know what, I don't want to talk with the elderly person because those are always difficult conversations. I'm just going to talk to the caregiver.
No, in a situation like that, we're obligated to speak with the client.
The client, and so that's what we call it. The client would be the person who is allegedly being neglected.
Yes, sir.
And are you obligated to speak with the primary caregiver as well?
We are.
In this case, Ms. Moman also reached out to a medical provider who was identified by someone and had a good exchange with that. Is that another required contact?
We're required to do collaterals. It doesn't necessarily have to be with a medical professional. It could be with a neighbor or another family member.
Okay, but medical professional can be a collateral.
Yes.
All right. If the conclusion after the APS, what would we call Ms. Moman in this case? A field worker, an agent, investigator. If the investigator's work results in a conclusion that the alleged maltreatment of neglect has been substantiated, does that trigger a reporting requirement from APS to any law enforcement agency?
Yes, anytime a case is substantiated, we have to send a report, a copy of our findings to law enforcement.
Okay. And that I'm using the right term. If your conclusion is substantiated, then it automatically, whether you want it to or not, it's not your decision to make as a supervisor. It must, per law or regulation, go to law enforcement.
Yes.
Okay. Got it. Is there a standard interaction that an investigator has with the primary caregiver if neglect is alleged and if the allegations are sufficient that you all open up a matter? Is there a standard interaction whereby the investigator would speak to the caregiver about additional support that's available, things like that? I'm wondering if there's a litany that the investigator goes through. Tell me how it's going with your mom. Do you feel like you need help? There are resources we can provide, et cetera.
Yes, we're required to talk to the primary caregiver, especially if alleged neglect is in place. And if we have some concerns that there is neglect, or if the caregiver or alleged perpetrator, reaches out to us and say, hey, I need some help. Can you help me find some resources in XYZ? Well, then we'll offer them some help.
Okay.
We'll make the necessary referrals if we have to.
Sure. Got it. Mr. Korn or Ms. Jenks, I don't know who's handling the APS piece. Do you have questions for Mr. Thompson?
Actually, Judge, I believe you covered what I needed to cover.
Okay. Ms. Hilton, do you have questions for Mr. Thompson?
Just for the court clarification, are all cases that are substantiated sent over, and there's some substantiated cases that are not sent?
Self-neglect is the only category that when it's substantiated, we don't send it to law enforcement.
Self-neglect.
Yes.
So there's no caregiver but the client.
Yes, the client is neglecting.
You wouldn't report that to the police because that's someone who needs help, not law enforcement intervention.
Correct.
Got it. Okay. Great. If you don't mind stepping back outside, that was very helpful. So, Ms. Hilton, my ruling here is that if you want to call Mr. Thompson to have him establish that APS received the anonymous complaint, which we now know is not anonymous, the thing from, I think it was a Ms. Williams, not the Williams brothers relative. And then Mr. Thompson could describe what would typically happen upon receipt of that we would dispatch an investigator to talk to the client. We would dispatch an investigator to talk to the primary caregiver. What are the types of things that would be discussed with the primary caregiver? We would typically discuss these things. You may do that. The only thing specific to this case would be, we did in fact receive the anonymous complaint that the jury's already heard about. And as a result of that, we did open up a matter and an investigator was assigned. But no specifics from Mr. Thompson about, did the investigator actually make contact with the client? Did the investigator actually make contact with the primary caregiver? And then obviously the follow-up, and what was the nature of the exchange? That, I believe, stays on the appropriate side of testimonial versus non-testimonial, given what I learned from Mr. Thompson's sworn testimony, what APS's obligations under the law or regulations are to do should an allegation of neglect, not self-neglect, but neglect be substantiated like it was in this case. Was that ruling clear enough? You can obviously talk to Mr. Thompson before he testifies, but I want to make sure I'm clear to you so that you don't inadvertently ask a question and then Mr. Corn's jumping up. I'm not trying to be vague.
I'm not that fast. I'm not that.
Okay, that his voice moves quickly.
Yes, Your Honor, it's clear. The only thing I would ask, because I feel like the jurors will say, well, what happened? If I could ask, who was that investigator and is she still living with us? So just thinking, if the question comes, they probably have a context, like the reason why you're not gonna hear anything because she's not.
I don't have an issue with that. The guardrail I'm establishing is the jury ought not to hear about the content of any interaction that Ms. Moman had with the collateral, with the client, or with the alleged perpetrator / primary caregiver. I think that's my ruling. I want to have you object, say, if you'd modify it a little bit, there'll be no objection, whatever you want to do, Mr. Corn. First, do you understand my ruling? And then second, reactions there too.
My preference is that there not be many reference at all to it, but I can live with that rule.
Okay. No, all I was going to say is I'll police it, but if you are perceiving that unintentionally, Mr. Thompson is veering off that, feel free to object. I'm not saying, great, we're done then, I don't want to hear from you. But I will be particularly dialed into this as well so that you don't need to look like you're trying to keep something from the jury. I'll take care of that. But if you see me going horizontal, then you need to get involved.
I'm not sure you had a break. It might happen.
I'll take a moment to instruct him, but I also want to be clear for the record that there are 2 reports. And so I will specify the 2013 report separate from the 2014 report, but I just want to.
When you say 2 reports, meaning reports that were made to APS?
Correct.
Or reports that APS generated?
There's 2 reports that were made to APS. One in 2013 that he was actually the case taker and went out to the scene and he was the investigator. And then we have the 2014 report, which is the context from the farm.
Who was the source of the 2013 report?
It was an anonymous report, but I was gonna say, did you receive a report?
Okay, but that's not one you've solved. You don't know who the anonymous reporter was.
Correct, and he unsubstantiated that report.
Okay.
I really want to be able to talk to him about going out and then subsequently.
Okay, and that may help the jurors even more with the context. Like these are the kinds of things we discuss. Mr. Corn, your objections were 100% focused on the 2014 report. 100%. Ms. Moman. Understood. Good, because I would think that's the way you ought to handle it. Okay, then let's get the jurors in. If you don't mind, while that's happening, because you've got 2 lawyers sitting right there, go talk with Mr. Thompson. We won't start unless it's one of their witnesses. Fantastic. Let's do that. Thank you.
And I guess they have to,
Substantiated report, right?
right, I mean, I guess they have to mention the 2014 report because there was a lay witness that already talked about that, so I guess there's no harm in it.
How can I be a primary? You talk about all our lives, we got a caught. It's never even solved. Stupid pre-COVID suit.
Too tight.
I feel like a button may pop off and you dodge it.
Suck your
Or an
stomach
eyeball,
in.
one or the other.
Suck your stomach.
Some of the way I feel it it's better than it did in the last trial of COVID.
Ms. Russell, do you know if Ms. Hilton's estimate of when you would close factored in the fact that we start late on Tuesday?
It would probably be Wednesday, yes.
Okay.
All right, adjourned.
They are. Please be seated. Welcome back, ladies and gentlemen. Thank you for your patience. The other matter ran a little later because those lawyers were talkers. But then we had a matter we had to take up here that we've worked through. And the plan for the rest of the day, we may take a break partway through our window. The state has 4 witnesses they'd love to cover. I'm told 2 are real brief, 1 is medium, and 1 is a little longer. And so we may go a little past 5 unless you revolt and say, it's a Friday. But if we can get through those 4 today, the state says they're pretty much on track and they're envisioning resting probably Wednesday morning sometime. No court on Monday, federal holiday, and state and county holiday. We've got a partial day on Tuesday. So 1, I'm giving you an update that we seem to be on track, which is good. But 2, because this special purpose grand jury thing took a little longer today, with your indulgence, we might go a little late today, but let's see. We'll take your pulse as we get closer to the 5 o'clock hour. Next witness.
Ms. Savita Davis, excuse me.
My name is Savita Davis. It's spelled S-A, V as in Victor, I, T as in Tom, A, last name Davis, D-A-V-I-S.
Okay, Ms. Davis, will you please just introduce yourself to the jury, please?
Absolutely. My name is Savita Davis. I am an employee of Wells Fargo Bank. I operate as what they call a business execution consultant. And today my role is as a custodian of records.
Can you just, I know today your role is a custodian of records, but can you explain what a business execution consultant is?
Absolutely. Also known as a BEC, if that's shorter. Business execution consultant. I specifically work for a team that's known as the Regional Support Litigation and Research Support Team. So basically our team researches cases that come in, whether they're small claims, litigation, demand letters. We go through and we make sure that whatever the claim is, that we have legit reasonings for whether upholding or withdrawing from a claim before it's either in court or settled outside of court.
And then you also said for today's purposes, you're here as a business records certifier. Is that what you?
Custodian of records. So that role, what it entails, a custodian of records is a person who either brings or certifies the documents that are already in court, just to say that they are true and correct copies of Wells Fargo. They've been dispersed by Wells Fargo, and Wells Fargo certifies that they know the contents and the creation of those documents.
For today's purposes, have you been able to review any documents concerning Wells Fargo statements?
Not in thorough proportion. They've been sent without me bringing them here particularly by hand, but I was able to review the declaration page, which tells me the contents of what's in that binder.
Let the record reflect, I have shown opposing counsel what has been marked as State's Exhibit 145. May I approach the witness?
Yes, again, the lawyers have continuing authority to approach witnesses until you have it revoked.
Ms. Davis, do you recognize State's Exhibit 145?
Yes.
And how do you recognize that?
This is a typical page that, or document that is sent to show that business records have been printed on behalf of Wells Fargo.
Okay. And can you just, after reviewing those records, you saw those today, correct? You saw that binder today, right? Okay. Are those records certified business records that were certified by a colleague of yours?
Yes.
Okay. State tenders State's Exhibit 145 into evidence.
No objection.
145 is admitted.
Can you just explain what was, I guess, pulled, or what did Wells Fargo send as a part of the records in this particular case?
Sure. So going back to the business records declaration, it specifically tells you the document type as well as the accounts that are detailed in here. So if you'd like me to list them, I can list them for you. So we have deposits and offsets for an account ending in 0141. We have all transactions or signature cards, I should say, for 0141 as well. We have credit card statements for an account ending in 4350. We have checks or debits. That's also for account ending in 0278. There are statements, bank statements, which end in the account of 2938. Signature cards ending in 2938. Statements ending in 0141. Checks and debits for an account ending in 2938. Deposits with all offsets for an account ending in 0278. Deposits with offsets for account ending in 2938. Signature cards for the account ending in 0278, and also statements ending in 0278. So a total of 277 pages.
Okay. And can you please just tell the jury on what date do these records begin?
Sure. If you don't mind, I need to flip through to tell you that
problem.
Specific date.
And what are you flipping to?
I'm going to the bank statement, which will tell me the starting date, and which will be the first set of bank statements, and the end will be, of course, where they ended for the statement period. Let me find the last part for you. Okay, so from what I can see, statements start from June 26th of 2014 through July 25th of 2014, and they go all the way through January 28th of 2017 through February 27th of 2017. So the very last date will be February 27th, 2017.
Okay. And do you mind just going to that last statement?
Sure.
Your Honor, may I publish that last statement, please?
You can publish any part of the vast Exhibit 145. If your tech team can do it. And we know the Elmo works.
Yes. And again, that last statement is for the dates January 28th, 2017 to February 27th, 2017?
That's correct.
Okay. Quick question. How many accounts are in these Wells Fargo records here today?
So specific to the document that we're looking at right now, the very bottom of the page, it details 3 accounts. So that's the Crown Classic Banking account ending in 2938, the Wells Fargo High Yield Savings ending in 0141, and the Wells Fargo Gold Savings ending in 0278. So a total of 3 accounts.
And do you mind just, and you can, on that screen there, if you touch the screen, there's going to be a little pin at the very bottom of the screen, and you can use that.
Look in the lower left-hand corner. See that?
Gotcha. Yeah.
Great. Now your finger is the writing implement. Yep.
Gotcha.
That was a good motion too. If you're going to circle, just like that.
All right. And can you please tell the jury, and I don't know if that got out, whose records are these?
Okay, so I'm gonna circle that for you.
Okay.
So the records is based on the individual name listed on the bank statement, which is Medotha R. Rooks.
Okay. And can you please tell the jury the ending balance for account number ending in 2938?
Okay, I'm just gonna put a little dash next to it. So if you look at that corner there, the ending balance for the account ending in 2938 is $4,598.70.
And what about the high yield savings account that we have?
That would be the one right below it. And that is account ending in 0141, a high yield savings. The ending balance is $1,002,571.79.
Okay.
102,000.
Okay.
102,571. Yes.
All right.
And 79 cents.
We can go to the next page, please. And then on this page, what can you please, which account is this currently showing?
Okay, so up at the top, right-hand corner, it's for account ending in 2938, which is the Crown Classic Banking.
Okay. Were there any deposits in this account during this time period of January 28, 2017 and February 27, 2017?
So based on the page in front of me, deposits are in this first column, and you can see there's one right here. So on February 1st, there is a deposit for TRS of Georgia benefit for Medotha R. Rooks for $3,523.55.
Okay. Can I have a moment, Your Honor?
You may.
All right, no further questions.
Mr. Korn, questions for Ms. Davis?
No.
None. Jurors, questions for Ms. Davis? No? Ms. Davis, did you come from far away? Oh, we do have questions. Sorry. Thank you. Oops. Council? Ms. Davis, does the states 145, that big binder in front of you, does that include the signature cards?
Yes.
If you wouldn't mind turning to that, and Mr. Korn, you did a good job before. Could you cause Mr. Elmo to come out?
Your modern ways confuse and frighten me. I wanted to say that on the record ever since Phil Hutton did.
Caveman lawyer?
Yes. Oops, that's off. I'm gonna turn it back on.
On. I haven't activated it yet.
Yeah, I see.
There we go. Excellent. Show us that hand. You know what? I'm not going to make you look for it. Ms. Russell, are you able to find in states 145 the signature cards?
I have my own copy, Judge.
Okay. As long as that's the same thing that Ms. Davis has, if you could publish the jury.
It's backwards on here, so that's why it's.
Yeah.
Oh, sorry.
And you can zoom, there's some button that'll zoom in. Okay. So this is part of the exhibit that the jury has. That's the signature card. Next question. Ms. Davis, you rattled off a few account numbers. I don't know if you have in front of you the universe of account numbers, but the question is, did you mention an account number that ended in 4350?
Yes.
What is that account? Was it one of the three accounts where you were saying one of them is 100,000, and or is it not one of those accounts?
It's not. It's marked as XCC statements, and that stands for credit card statements.
So the account ending in 4350 would be a credit card account?
Yes.
Okay. Are you able to tell if in February of 2017, there was an outstanding balance for that credit card?
It says there's statements in here, so if we can locate
Let's
the
see.
statements.
And Ms. Russell, if you know how to find those things, we'll appreciate your movement. You could pop it on the Elmo.
Okay, I found it.
You found it. All right. So we may have the same thing on the Elmo. What is this? Whoop. What did you touch?
Totally wasn't me. Yeah, hit the power button. I think. Yeah. There you go.
I may have to reactivate it, but you can, if you've got the credit card statement in front of you, Ms. Davis, was there a balance on the credit card in February of 2017?
Okay, so the first statement I see is actually for 2014. Trying to locate a 2017.
So there may not be, did you have, Ms. Russell, something from the binder that shows whether the account was even active in February of 2017?
Your Honor, I do not have anything from February 2017.
When do the records end? What's the?
For account ending in 4350, it's, looks like 2016.
Okay, and Ms. Davis is the actual testifying witness. You agree that the records Wells Fargo has provided only go up through 2016 for the credit card account ending in 4350?
Yeah, I have October 14th of 2016 as the
Okay.
final date.
Is there any indication on that final account statement that the credit card was closed, or any reason that would help you explain why you don't have records beyond October 2016?
It does not state closure on here. It just gives a balance for that month.
And then if we can go back to the page that was displayed on the screen where you were circling or marking, you know, this account has a balance of 4,000, this one has a balance of 100,000. The question is whether there was a debit, a withdrawal from those accounts on a particular day, specifically February 8th of 2017. Do the records you have allow you to determine, we're not talking about the credit card account anymore, but for those other accounts, the gold count, the super duper savings, that's not what it was called, but it was something like that. Whether there was a withdrawal.
Let's see. Sorry, what was that date again?
February of 2017, specifically February 8th.
Let's see. So for the account ending in 2938, there are no debits on February 8th.
Are there any debits around that date, you know, plus or minus 2 days?
There is a debit on the 6th of February for the account ending in 2938 for $300, which was done at the ATM.
So that would be a cash withdrawal?
Yes.
Okay. That was on the 6th of February, 2017.
And to be more specific, the transaction line reads that it was authorized on on February 4th. It just posted to the bank statement on the 6th of February. So this was done on February 4th.
All right. So this was my account. I was at an ATM on the 4th of February. I took out $300.
Right.
Okay. All right. Any other activity, plus or minus 4 days, since that's what we got to, of February 8th?
Okay, so let's see that next account. That's 2938. The high yield savings does not show any activity for withdrawal or deposit. And the goal savings account ending in 0278 also does not show any activity.
Okay, so across those three accounts that we focused on, just the one, and it was a $300 cash withdrawal 4 days before the day I asked you about.
Correct.
Okay. Ms. Russell, any follow-up with Ms. Davis?
Just very brief, Your Honor. in the account ending in 4350, that last statement that you spoke of, at one point you said that there was I believe you said that there was looking at the balance, excuse me. What was the balance on October?
So for October 14th, 2016, there was absolutely no type of transaction done. It shows a zero statement balance for that month.
All right, that's it. Thank you. I appreciate it.
You're welcome.
Mr. Korn.
Yes, one follow-up question.
Yes.
Did any of those counts show any kind of power of attorney for anyone else other than Mendoza Rooks?
Not that I can see. Generally, if there's a POA, it will list that on the address line. It'll have a POA underneath their name with the name listed.
Thank you. No further questions.
You're very welcome.
Thank you, Ms. Davis. Appreciate your time.
Absolutely.
Have a great weekend.
Thank you.
You can leave that binder right there. The prosecutor will figure out what to do with it. Next witness.
Mary Ellen Ireland.
Mary Ellen Ireland.
Ms. Ireland, good afternoon.
Hi.
Thank you for being here. You're very soft-spoken, which is okay. If you're comfortable removing your mask while you testify, that'll help us hear you. Thank you so much.
Ms. Ireland, can you introduce yourself to the jury?
My name again?
Yes, just to the jury.
Mary Ellen Ireland.
And how are you currently employed?
I'm retired.
And where were you previously employed?
For Dr. F. William Dowda.
Okay, and when did you begin working there?
February of 1981.
And when did you stop working for Dr. Dowda?
May 15th, 2015.
Why did you stop working for him?
He passed away.
Okay, and when did he pass away?
I'm sorry?
When did he pass away?
May 15th, 2015.
That day. Okay, I just wanted to clarify that. What was the last position you held with him?
Office manager.
Okay, and have you had the opportunity to review any records in this case?
Yes.
And what were those records?
For medical records for the since 2013, I believe.
You said medical records?
Starting with 2013.
Okay, and who were those records for?
For Mrs. Mendoza Rooks.
Do you recognize these?
Stop.
I'm sorry. Ms. Ireland, have these records been certified?
Yes.
Which exhibit is this?
I'm sorry, State's Exhibit 111.
111. Thank you.
How do you know they've been certified?
Because I was the one that copied them and certified them.
Say that again for her, a little louder.
Oh, because I copied the records and certified them
Okay, and where did you get these records from?
from my house.
So you said you got them from your house after Dr. Dowd passed. I'm gonna assume then that you kept them?
Yes, I have all of the records.
Okay. Your Honor, the state would move to tender State's Exhibit 111.
Mr. Corn?
No objection.
And, okay, they are admitted.
Okay, Ms. Ireland, do you recall Ms. Rooks?
Yes.
And can you tell the jury just a little bit about her?
Mrs. Rooks was a very nice, attractive, well-dressed, well-spoken, quiet lady.
And how long was she a patient of Dr. Dowd?
She was a patient prior to my starting to work for Dr. Dowd in 1981.
Okay, and did she ever come to the?
Did you say 1981 or 1989?
1981.
Okay, thank you. That's.
And did she ever come into the office with anyone else?
Yes, with her sister.
What's her sister's name? Do you remember?
Her sister was Osadell Reeves.
Okay, and when was the last time Ms. Rooks was treated?
July 28th, 2014.
Okay, and do you recall what she was treated for at that time?
She was seen for hypertension, hyperlipidemia, painful swelling joints, failing memory.
Okay, and specifically as to the failing memory, did the records reflect any recommendations that were made?
Yes.
And what was that?
An MRI of the brain, carotid Doppler studies, and Dr. Hedaya, a neurologist.
Do you know if any of that was followed up based on these records?
I do not know.
Okay. And was there any more contact with Ms. Rooks in reference to her care?
I know that she called him after she was seen on 7/28 to go over her lab work, which we always pull the lab work when he is going to talk to them on the telephone. I know that he also sent her a letter September 8th asking her to come in the following week.
Did she come in?
No.
Okay. Was there contact with anyone else regarding Ms. Rooks' health?
Not to my knowledge.
Just for clarification, who were those recommendations made to for her follow-up care in the MRI?
Now, that is not stated in the chart. She would be scheduled at a hospital.
No, not who the referral, like the doctor. Who did Dr. Dowda tell that she needed to have an MRI?
Mrs. Rooks.
Nothing further.
Mr. Corn, any questions for Ms. Ireland?
Hello.
Sure. Don't break our stuff.
I'm trying not to.
Be the next Mr. Corn.
Thank you. No further questions.
Questions from the jurors for Ms. Ireland? No? All right. Thank you so much, ma'am. Appreciate it. Be safe. Next witness?
Yes, Your Honor, state calls Dante Thompson to stand.
My name is Dante Thompson. That's spelled Daunte. My last name is Thonpson.
And Mr. Thompson, where do you work?
I work for the Division of Aging Services.
And what do you do for the Division of Aging Services?
I'm a supervisor with the turf unit.
How long have you worked for the Division of Aging Services?
10 years.
What is the Division of Aging Services?
Division of Aging Services, basically we go out and we do investigations for any abuse, exploitation, or neglect in the community.
And you said right now you're a supervisor of the turf unit.
Yes,
What is the turf unit?
it's an acronym for Temporary Emergency Respite Funds. And basically what we do is we find placement for elderly individuals.
Now, under the Division of Aging Services, are there any other subgroups within the Division of Aging Services?
Yes, Adult Protective Services and Public Guardianship Office.
Now, the public,
Guardianship Office.
what is the public guardianship office?
Basically, if you have someone in the community who possibly like suffers from dementia or any other cognitive impairment, we could find a guardian for them.
And then what does Adult Protective Services do?
Investigate abuse, neglect, or exploitation with any adult over the age of 18 or senior citizen over the age of 65.
And have you ever worked under the umbrella of Adult Protective Services?
Yes, I have.
In what capacity have you worked under the umbrella of Adult Protective Services?
I was an investigator for 5 years.
And what does an investigator with Adult Protective Services do?
Basically, we go out into the community and, like I said, we do investigations on someone who, if it's alleged there's like any abuse, neglect, or exploitation, we'll meet with the individual. We'll meet with the alleged perpetrator and make collateral phone calls to like doctors, relatives, or neighbors, anyone involved in their client's life.
And what are you trying to find out through your investigation?
Just to see if there's any validity to the allegations.
Now, are you all a law enforcement agent?
No, we are not.
So do you have arrest powers?
No, we don't.
Now, are all of your investigations subsequently turned over to law enforcement?
Not all of them.
Okay. How was the case, or when would a case be turned over to law enforcement?
If we have belief that the claims are indeed true, then we'll send a summary of our report to law enforcement.
Now, I think you said this earlier, but what is considered an elder in the city of the Division of Aging Services?
Anyone over the age of 65.
And are you a state agency?
Yes, we are.
Now, when you're talking about investigating abuse, what types of abuse are you charged with investigating?
Sexual abuse, physical abuse, verbal abuse, emotional abuse, neglect, and self-neglect.
And so when you're discussing neglect, what is it that you're looking for?
Basically to see, if the client is malnourished, if we're able to get into the home, if they let us look in the refrigerator to see if they have proper food in there, to see if the electricity is on, and to, in some cases, see if they have the proper supervision.
Now, when you go out to begin your investigation in those kind of different areas of abuse, financial exploitation, are there certain warning signs that you look for under those various categories?
Yes.
So let's first start with financial. What type of warning signs are you looking for when you go out to start your investigation?
If they're behind on their bills, if some of their utilities are turned off, if their spending habits have changed, or sometimes if they're very guarded about their finances and don't want to answer certain questions.
And what about sexual abuse? What type of warning signs are you looking for?
Sometimes isolated or depressed.
What about physical abuse?
Any marks on the body, you look for physical marks on the body. Sometimes depression also.
Emotional?
Very withdrawn and isolated, and sometimes timid.
And then what about neglect?
We look at the condition of the home. Like I said, if the client has lost a lot of weight over the past several weeks or so, if there are a lack of utilities or proper food in the home.
Now, how does a report normally come to the agency?
We have a unit called Central Intake. They receive web referrals as well as phone calls.
And once a report comes into Division Services, tell the jury kind of the steps or the process as you before it may get to an investigator.
Okay. When the referral is made, Central Intake has the ability to determine if it's a valid case. If it is indeed a valid case, then they'll assign an investigator to that case, and that investigator has 10 days to make contact with the client.
Now, once the investigator has those 10 days to make contact with the client, what happens next?
They'll go out and see the client, kind of assess the situation, get some information. Well, first of all, we meet with the client privately, and then we'll make contact with any collaterals, family members, neighbors, friends that are involved in the client's life, as well as make contact with the alleged perpetrator.
Now, after you have the ability to make contact with those various individuals, what do you do?
We just kind of come to a conclusion as to, how we feel about the case to see if there was actually, any type of neglect or abuse that occurred.
And once you do that assessment, what happens?
Let's say in a situation where, we don't have enough information or we do not think that anything occurred, it was just a simple misunderstanding, we'll just type up our notes and close the case. On the opposite end, if we do feel like there was something that happened, then we'll type up a summary of our report and send over to law enforcement.
Now, during the course of your investigation, your analysis, do you sometimes provide recommendations to maybe the alleged perpetrator about any services or resources that one may be able to use to help the client?
Yes, we'll speak with both the client as well as the alleged perpetrator or caregiver to offer them some resources or recommend some services for them as well.
I want to take you to the reason why we're here in court today. Did Adult Protective Services receive any anonymous reports for adult drugs?
Yes.
How many reports did APS receive?
2.
What were the dates of those 2 reports?
The first one, I believe, was in April of 2013, and the second one was in the summer of 2014. I believe.
And how did these reports come in?
They were anonymous reports, and I believe they were called in.
All right, let's first start with the April 2013 report. Was that case assigned to a case investigator?
Yes, it was assigned to me.
It was assigned to you. And I'm going to show you what's been marked as State's Exhibit 109. Some of you reckon, and what's been shown in the defense counsel, the State's Exhibit 109. Do you recognize State's Exhibit 109?
I do.
And how do you recognize State's Exhibit 109?
Because this case was assigned to me.
Is that the April 2013 report that you did as a result of your investigation?
Yes, it is.
And is that a fair and accurate depiction of the report that you did in 2013?
Yes.
You're at this time, state like the State's Exhibit 109 for the record.
Mr. Korn, any objection, number one, to States 109 being admitted, but number two, for now at least, for record purposes only?
Yeah, no objection.
Okay, it's admitted.
Thank you, Your Honor. Now, once you got the case, what were you charged with investigating?
In this particular case, I believe there was alleged neglect. So I wanted to go out to meet with the client, to see if those claims were indeed true or not.
And at that time, did you have her name and date of birth?
I did.
What was her date of birth?
2/3/34.
And what did you do once you got the report?
I went to the home to try and meet with her. Most occasions, people will let us in the home. She declined to let me in the home.
And I don't know if you made notation of it or if you recall what she looked like when you went to the house.
I do not.
Okay. And how many cases have you seen since 2013?
Hundreds.
And did you make anything of notation in your report about her condition?
I didn't, which means that I didn't see anything that was of concern.
But she did not let you in.
No, she didn't.
After trying to speak with her, did you try to speak with anyone else regarding the allegations?
I couldn't get in contact with the reporter, obviously, because it was an anonymous report. So I went to the neighbors' homes. But there was no answer at the door. Because I was hoping they'd give me some indication of, if they've seen anything or had any concerns about it.
And were you able to speak with anyone?
No, I was not.
Were you able to speak with any collateral individuals that's related to this 2013?
No, she declined to share any information.
She declined to share information. So at that point in time, what did you ultimately do with that report?
I closed my case.
Now, so there was a 2014 report in the summer of 2014.
Yes.
And was an investigator dispatched on that case?
Yes, there was.
And who was that investigator?
Teresa Moman.
And is Teresa Moman still alive today?
No, she passed away a couple of years ago.
And was an investigation completed just in general?
Yes.
I have no further questions.
Mr. Korn, do you have questions for Mr. Thompson?
Very briefly, you observed Ms. Rooks through the door when you went there?
Yes.
Did there appear, at least from the exterior of the house, because you weren't inside, that everything seemed to be in order?
From what I could see, I didn't see anything out of the ordinary.
Okay. Could you tell whether the electricity was on?
I could not.
Thank you. I have further questions.
Any follow-up?
Just really briefly, when you can't speak with anyone in order to determine what's going on, when you close the case, it's unsubstantiated case at that point, because you can't speak with anyone.
That's correct. And because what she told me, she was fine.
Okay, thank you.
Jurors, questions for Mr. Thompson? Not seeing any hands moving. Thank you, sir, for your time.
Thank you.
You have a good weekend. So we have one witness left. We, the lawyers and I and Mr. Rooks need to have a conversation before this last witness can come on in here. So you're going to have a break in a second. It's 3:33. Do you feel like, knowing what you want to cover with this witness and knowing that there may be a cross-examination, that's pretty easy to fit in by 5, or should these folks be checking their schedules to say, yeah, I could be here till 5:15, or what's your best guess?
My best guess, we should be able to get by 5, no later than about 5:15.
So it's close.
Yeah.
All right. I'm going to keep this break short, partly because your lunch break was long, but it'll be driven by the length of the discussion I need to have with the lawyer. So go with Deputy Gordon. Don't talk about the case, no outside research, and we will see you shortly. Thank you so much.
Thank you.
All right, you all can be seated. So, Ms. Hilton, I'll have you start. I know you and Mr. Korn have been talking about this. Share with me the pointiest point you're trying to make through the doctor. You want her to opine what? It sounds like a bunch of what she's going to cover may not be great for the defense, but it's not something that would withstand an objection, or it would withstand the objection, and the jury could hear about it.
Yes, Your Honor, and I can go specifically to that last concern of Mr. Korn, and the state does not intend to ask whether or not, based upon her review of the records, is this consistent with murder. I told him my last 2 questions of her were probably, someone gonna phrase it in the same manner. The questions will be, one, based on a number of risk factors, were these risk factors consistent with neglect? And it would be medical. And then my last and probably final question would be, based upon your medical training experience, if Ms. Brooks would receive the proper medical care, emergency care, or nursing care, could her life have been prolonged?
Okay.
Those are the two areas that's really the research, which I think is to be all based upon her knowledge training.
I think so too. That's a different way than, and Mr. Korn may have been phrasing it for you because of his concern, but when we left at lunch, I was uneasy because you may not have had a chance to think it all the way through. It sounded like you wanted to ask, well, isn't it true? You wouldn't ask it that way, but is it the case that everything you've read suggests that the neglect she suffered is what killed her? And you're not asking it that way. You may argue what you want to argue, but you're approaching it from a different way that gives me less pause, not having heard this individual's credentials, but having a sense of what they likely are. Mr. Korn, if things play out the way Ms. Hilton described, tell me what you want to get on the record.
I won't object to that, Judge. I think that's acceptable. I think that's kind of the point of having an expert.
Other than the coroner, I agree.
Right.
Yeah.
And I mean, we'll have the coroner too.
Correct.
I'm fine with that. We'll work on that.
But I don't think this usurps the coroner or is cumulative of the coroner. It's coming at it from a different perspective.
It is, and I don't love that she can say that, but she's not a medical doctor, right?
Yep.
I mean,
Correct. And now,
I mean, I've got what she's read is limited. It's not the whole story. And I intend to
explore that.
get into the whole story.
Okay. Got it.
That's the point of the
And Your Honor, I do want to say, and Mr. Corner had talked about it, because she is being called slightly out of order, there are some things that she will discuss that have not come into evidence yet, but we believe will come in on Monday, but because she has been called out, I mean, Tuesday, excuse me, but because, and I believe that Mr. Corner might have any objection to that be given where we have.
right. It's the way we were going to handle, I don't remember who the witness was. It may have been the woman, Ms. Williams. Someone was trying to authenticate some pictures, but they were going to be, the foundation was going to be laid later. That's fine, especially with experts. They often have to come out of order. So you'll be assuming some liability, but if you're able to close those loops, then it won't be an issue.
If it's an issue, I'll let you know.
I know you will. Does anyone need a comfort break?
Yes.
Now.
Well, there's a question for you guys. You get that. For hours.
Can you check on them? We won't bring them in until Mr. Korn's back, but let's start corralling them. It's their weekend. How was lunch? Hero. It was good? Mm-mm. Yeah. Yeah. Huh. Is it spelled hero like superhero? But it's not just Subway sandwiches. Huh. How'd you learn about it?
I just.
Cool. No, the different is good. And that's not too far away.
The sandwich place around the
You can't walk to it. Not that close, unfortunately.
Well,
That'd be too helpful.
I drive funny.
It's called Hero, she's saying.
Where's it at?
Over in the Somerville area. Oh, it's delicious, and the coffee is good. The draft latte.
No, it's not. Yeah, you wouldn't want to walk there if it's real hot out.
I didn't know others that we're going to.
Really? Excellent. All right. Yep. I'm going to make that happen someday. Are they ready? No.
Okay, thank you.
You have those stacks.
We could find out if Judge Brasher's gone. They could use his restrooms. I don't want them coming through the courtroom to there, but you know, the jury room right down the hall. So is it broken? Okay. Well, they'll need to fix that.
Which was signed here.
Okay. Why don't you see if yeah. Yeah.
Yeah, just to have it nearby.
I swear the Fulton County plumbing is the least reliable on the planet. Those jury rooms don't get used much, but they always break. Yeah, what's happening? State's 144, that would clog the toilet.
Oh.
On your back.
But
Only say nice things.
Why, you can hear me?
I just heard the name.
Just, all I said was we'd be here a while. My microphone's off. It does. Okay. No, it's for the state.
No, it's okay. I just.
Are they better? They're ready. Great. We're ready. Your witness is ready?
Yes.
All right, sure. Yeah. That's right.
Thank you, Deputy Gordon. Sounds like we have a plumbing issue. I hope everyone is okay. And hopefully it was just water that was leaking and not other things. But Ms. Hansberry, who you may have seen her today, yellow shirt, she's called the plumbing 911. They're going to address that. Were you able to get folks into Judge Brasher's? Okay, so there are restrooms there. I don't think you need restrooms again today because we hopefully won't need another break today. And hopefully we'll get that fixed. Those bathrooms don't get used much. And yet throughout the courthouse, that's what breaks and leaks. And then when it's a bad leak, because we're on the 8th floor, it goes through 7 other floors. Those are county buildings. Ms. Hilton, if you would call your last witness of the day.
Yes, Your Honor. We're gonna call Dr. Diana Holmeyer.
You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth. Go ahead and have a seat. State and spell your name for the record.
Diana, D-I-A-N-A. Homeyer, H-O-M-E-I-E-R.
And Dr. Holmeyer, how are you this afternoon? How are you this afternoon?
I'm fine, thank you.
Now, if you are comfortable, and it's totally up to you, you can take off your mask to testify, or you can keep it on, but it's up to you.
Thank you.
Where are you employed?
I'm a physician that works at Mercer Medicine in one of their rural clinics in Putnam County.
Okay. And how long have you been with Mercer?
About a year and a half.
Okay. And where were you prior to that?
For the 20 years prior to that, I was working at the University of Southern California in Los Angeles at LA County USC Medical Center, where I ran a geriatrics clinic and also a hospital-based elder abuse program.
Okay. Now, if you could tell the jury a little bit about your education and experience.
Sure. I graduated from medical school in 1991 from the University of Southern California. After that, I spent 3 years doing a residency in family medicine at David Grant U.S. Air Force facility up at Travis Air Force Base. And then I spent 4 years working as a physician in the U.S. Air Force. After that, I went back to do further training in the care of older adults. So I did what's called a geriatric fellowship for 2 years at Oregon Health Sciences University. After that, I took a position back at the University of Southern California, where I worked then for the next 20 years. I started a geriatrics clinic at a big county hospital where there hadn't been one before, and also started an elder abuse hospital-based program where I saw victims of abuse and neglect in the emergency room or on the hospital wards, and then also went out to the home to see victims with adult protective services workers. And then in 2006, I started the Los Angeles County Elder Abuse Forensic Center, which is a multidisciplinary team that got together once a week to discuss difficult cases in the county and then would try to develop a plan to see what could be done to help resolve those cases.
And what got you interested in geriatric care?
I like older people.
And during the course of your career, have you had the abilities to conduct any trainings yourself in the area of elder abuse?
Yes.
About how many trainings have you conducted yourself?
Oh, gosh, if you consider even just trainings to medical students and residents, there've been, hundreds, I suppose. I was teaching on a daily basis in my clinic. I taught the residents in the clinic about elder abuse and neglect. I did lectures that are larger at the medical school. I went out to the community and taught practicing physicians at grand rounds about elder abuse and neglect. I taught on the state level and then gave lectures even on the national level at the American Society on Aging.
And have you ever obtained or written for any grants in relation to elder abuse and getting money for some of your clinics and programs?
Yes.
And about how many such grants have you written for in order to get funding for some of your programs?
About 15 grants.
And are you a member of any organization that specifically deal with elders and elder abuse?
Yes, I'm a member of the American Geriatric Society, and we have a small chapter of that deals with elder abuse, and then also the National Center for the Prevention of Elder Abuse.
Have you conducted any studies as it relates to elder abuse?
Yes.
About how many?
Gosh, studies that I was involved in or conducted, there was probably 9 or 10 that were specifically about elder abuse.
And generally, if you could tell the jurors, what did your studies entail?
Sure. So one study involved trying to determine what the prevalence of abuse and neglect was in Los Angeles County. So we sent people out to interview older adults in the community. Another study was looking at bruising as a possible marker of elder abuse. So we looked at bruises in elders who hadn't been abused and bruises in elders who had. My most recent study was funded by the National Institute of Justice, and we looked at all injuries that were sustained by older adults who had been victims of physical abuse.
And have you ever testified in Georgia courts as an expert in elder abuse and geriatric medicine?
I have not.
Okay. And is that because you recently moved to Georgia?
Yes.
Okay. Have you ever testified in any other jurisdiction as an expert in elder abuse and geriatric medicine?
Yes.
Where?
Los Angeles County.
And how many times have you been qualified such as an expert?
About 30 to 35 times.
At this time, Your Honor, I would ask that Dr. Diana Holmeyer be qualified as an expert in the area of elder abuse and geriatric medicine.
Mr. Corn, any objection to having Dr. qualified in those two fields, elder abuse and geriatric medicine, or the alternate, do you want to examine this witness on those areas?
If I may briefly, I just have one, maybe two questions.
Sure.
Of those 35, I'm sorry, I didn't mean to rush you. Of those 30 to 35 times in which you've been qualified as an expert in Los Angeles, how many of those did you testify for the state and how many were for the defense?
Predominantly, most were for the state. I did testify in a few civil cases, and in one of those I testified for the defense.
So out of the 30 to 35, one for the defense.
Correct.
Okay, no further questions. Thank you. I don't have any objection.
Okay. So Ms. Hilton, you can resume questioning after I share with the jury that I am qualifying Dr. Holmeyer as an expert in two fields, geriatric medicine and elder abuse.
Now, what is geriatric medicine?
Geriatric medicine is the field of medicine that deals with caring for older adults.
Okay. And what is generally elder abuse?
Elder abuse is the mistreatment of an older adult by someone else.
And are there various types of elder abuse?
Yes, there are.
And how many?
Generally 5 or 6 types that are mentioned in the literature.
Okay. And if you could tell the jury, what are the 5 or 6 types that are mentioned in literature about what is elder abuse?
Yes, so physical abuse, which is basically what it sounds like when somebody inflicts injury on an older adult. Neglect. Yes, I'm sorry. Physical abuse, which is where somebody inflicts injury on an older adult. Sexual abuse. Neglect, which is where a caregiver fails to provide adequate care for an older adult. Psychological abuse, which is where an older adult is subjected to emotional distress. Financial abuse, which is when an older adult's money or things are taken for somebody else's gain. And then the sixth type that is sometimes included as a type of elder abuse is self-neglect.
And what are some of the risk factors to look to determine if an elder is being abused?
Well, any elder could potentially be a victim of abuse. The things in the literature that are discussed that tend to be larger risk factors other than age are when somebody has a disability of some kind, be that a physical disability or a cognitive disability. Depression is thought to be a risk factor. Social isolation is thought to be a risk factor. So not having other people around or being connected to a lot of other people is thought to be a risk factor as well.
And does elder abuse only affect a certain type of population, or does it affect only a certain type of population, or are there a variety of individuals who could suffer from elder abuse?
No, any older adult could potentially suffer from elder abuse.
Now, are you familiar with the ways in which a caretaker may use certain type of tactics to exert power and control over over an elderly person that they're taking care of?
Yes.
And are there any type of demonstrative aids that can assist in explaining the tactics that a caretaker could use if they're trying to exert power and control over an elderly person?
Yes, there's a graphic for elder abuse called the control wheel that demonstrates some of the tactics that older adults actually talked about in focus groups to help researchers understand what tactics were used when they were being abused.
I'm going to show you what I've already shown the Defense Council. So the market states exhibit number 149. Some of you recognize this exhibit 149.
Yes.
And how do you recognize exhibit 149?
This is the control wheel we were just discussing.
And is that a fair and accurate depiction of the control wheel that we were just discussing?
Yes.
And would it assist in your testimony today to the jury to talk about the various tactics that some may use to exert power and control?
Sure.
At this time, state by 149 is evidence.
Is this for the record or for?
Demonstrative purposes.
So yes, it'll be made part of the record because it's something that we'll be looking at. But this is a demonstrative aid, as it has been, the foundation that's been laid for it is as a demonstrative aid. That's how it will be used with this witness. What happens when it's time to send evidence out to the jury, we'll discuss outside their presence, but it will also be made part of the record.
No, Judge.
Okay, 149 is admitted. Granted.
Now it should come up on the screen in front of you and on the side of you.
Okay.
And I believe on the screen in front of you, we can go here to the and you'll be in the circle if you need to circle anything up here. So if you can kind of orient the jury with this kind of control wheel for elder abuse and talk about the various tactics and some of the things that one would see if someone who's an abuser would use under the various different tactics.
Yeah, so I'll just describe some of the things that are shown on this wheel, starting sort of at the 12 o'clock position and going around. So the first says abusive dependency. So as I said, people who are more dependent or have disability of some kind are more likely to be victims, and sometimes their dependency can be taken advantage of. So maybe if they have medical needs, those medical needs might not be met. If they need a walker to walk, maybe they're not allowed to use their walker, or if they need hearing aids to hear, their hearing aids are kept from them. So they have a difficult time communicating. The second one you see says ridicule of values, and something that is important to the elder might not be recognized as important by the abuser, and they may actually be made fun of because of those things, or not allowed to participate in things that are important to them. Emotional abuse is basically when there may be name calling or humiliating behaviors to the older adult. Manipulation of family. This is when an abuser might take advantage of the fact that family might not live close, may keep family from being able to see the older adult, or may try to tell the family that the older adult doesn't want to see them anymore. And then that sort of also feeds into isolation, which is the next part of the wheel, which is when an abuser really tries to keep other people from seeing what is going on. And so tries to isolate that older adult by maybe controlling their phone calls or their mail or not allowing them to see other people. Misuse of privilege, that a caregiver or abuser now may be in a situation where they're making the decisions and they take advantage of that. So they make decisions that are maybe more beneficial for them than for the older adult. Financial exploitation, they may take advantage financially, especially for an elder that's got cognitive impairment. It can sometimes be very easy for them to take advantage financially. And then threats and intimidation. I certainly heard about this from a lot of victims of abuse, that they felt threatened that they would be placed in a nursing home if they didn't do a certain thing, or threats, other types of threats, like threats to their pet and things like that. So these are just some of the tactics that we see in elder abuse cases.
And I think you briefly touched on this, in kind of doing your research and speaking with elders yourself. Have you observed elders speaking with you about various different factors used with these tech, or these various different tactics being used?
Yes.
Now, I'm going to take you to the present case that we have at hand. Were you hired by the Fulton County District Attorney's Office to review items and to make a report and a determination if there was any evidence consistent with neglect?
Yes, I was.
In the case of Ms. Mendota Rooks.
Yes.
And how much are you being paid in order to have reviewed the record and come to testify today?
Yeah, my rate is $250 an hour for review of the records and testimony.
And
testimony.
Do you mind getting a little closer to the microphone? The chair is heavy with no wheels so that you don't roll right off the edge. Thank you.
And were you able to review records and ultimately make a report in this case?
Yes, I was.
Now, what did you review in order to conduct your report here in this case?
So I reviewed available medical records from Ms. Rooks' primary care provider, Dr. Dowda, as well as 2 visits she had to Atlanta Medical Center. I also reviewed Adult Protective Service reports. I also reviewed the police department report and the medical examiner's report.
Did you review any videos or autopsy photos?
Yes.
Now I'm going to show you what's already been admitted as State Exhibit number 111. Do you recognize State Exhibit 111?
Yes, I do.
And how do you recognize State Exhibit 111?
These were the medical records from Ms. Rooks' primary care provider, Dr. Dowda.
And were those one of the medical records that you reviewed in preparation for this?
Yes.
I'm going to also show you now what's been marked as State Exhibit number 112. Please tell me if you recognize State Exhibit 112.
Yes.
And how do you recognize State Exhibit 112?
These are the medical records from the 2 hospital stays at Atlanta Medical Center that I reviewed.
And looking at page 3 of State Exhibit 112, is there a certification of authenticity on page 3 of 112?
Yes, there is.
Your Honor, at this time, pursuant to a business record section, the state record, State Exhibit 112.
No objection.
Give me 1 second. There's no objection. Admitted. You okay? Do you need a little water?
Yeah, and I have to.
You're good with those. We'll try water first, then we'll get to your Ricolas. Better? Okay.
And were you able to create a report in this case?
Yes.
I'm gonna show you what's been marked as State's Exhibit 151. Tell me if you recognize State's Exhibit 151.
Yes, I do.
And how do you recognize State's Exhibit 151?
This is the report that I wrote.
And is that a fair and accurate depiction of your report that you wrote?
Yes, it is.
You're on this time, state like tender State's Exhibit 151, into evidence for the record.
For the record, no objection.
Okay, 151 is admitted. We're getting beyond my list here. I don't have space. Okay, it's all right. 151.
We're gonna have to give you a second page on Tuesday.
It's okay.
Now, in looking at the items that you reviewed, what were some of the information that you relied upon in order to conduct your report?
Yeah, well, first in the medical records, looking at the records from Ms. Rooks' primary care provider, she had had a history of hypertension and diabetes and had been on medication for those. And in the records, I saw several notes from 2013 and only one note from 2014. So that was significant. There was almost monthly notes from August through November of 2013, and then nothing until July of 2014, and then no further notes after that. There was a diagnosis of dementia that was written in the medical chart as of August of 2013, and there was talk in the notes about memory loss in each of the notes.
And looking at, was there anything else in those records that were significant to you to do your report?
In the Atlanta Medical Center records, there were some very significant things. So there were 2 hospital stays that were really more emergency room visits. And the first one was in 2013. And at that time, Miss Rooks was found on the ground and brought into the hospital and was described as having been lying in her urine. And family members brought up concerns about her inability to care for herself. And there was a note from the emergency room physician that stated that he discussed with the patient and her son that she really should not be living alone anymore, that she cannot be left alone, and that really they should discuss with her physician the possibility of placement. And there was a discharge note that was actually signed by her son that stated on it that she cannot be left alone at home anymore, and that they would have follow-up with her primary care provider in 2 to 3 days, where they should discuss placement.
And I'm gonna approach you again with State Exhibit number 112. Looking at State Exhibit number 112, within their record, because we don't have page numbers, is this the discharge sheet that you were just referring to, in which her son signed indicating that he was made aware that she should not be left?
Yes, it is.
You're on permission to publish old school?
Old school. As long as you keep your distance, we don't hand things around with the jury anymore. So we have the Elmo. You don't trust the Elmo. Okay.
Yeah. We're gonna skip that. Now, looking at the 2013 APS report, did you review the 2013 APS report?
Yes, I did.
And was there anything of significance in the 2013 APS report that you noted?
Yes, it was a report made by an anonymous caller to Adult Protective Services who had concerns about Miss Rooks living alone, stating that she had memory problems, that she really was having difficulty taking care of herself, she was left alone a lot, and that there was a locked door that she couldn't get out of in case there were an emergency.
Okay. Now, were you provided the Atlanta Police Department, were you given his investigative report?
Yes, I was.
And what from the Atlanta Police Department report did you have that you looked at as a part of your analysis?
Yeah, so there were 3 things in that report that I thought were important to note. So the first is just the description of the home and the victim when they arrived on the scene in February of 2017. And they described that the home was dirty and that the victim was lying unclothed, dirty, in feces and urine with multiple wounds and flies and maggots of different stages on her body. The second thing in that report that I thought was significant was the interview with her son, who admitted that he had been back into the home. He had moved back into the home somewhere between a few weeks to a few months to provide care, that he had been taking care of the bills and making sure those were paid. And also that he described what happened on the Saturday before she died on Wednesday. So on Saturday, he found that she was stuck to the couch, and in order to get her off the couch, had to tip the couch over and pull her off, and noted the large wound, and had her lie on the ground, and then left her there, and also described that she really wasn't eating or drinking from that day on, or speaking to him from that day on. And then the third thing that was significant in that investigative report were interviews with family members and neighbors who mentioned that they had difficulty accessing her because of a locked burglar door, as well as a dog that they were frightened of. That one family member couldn't reach her because the phones were disconnected and he had no ability to connect with her. And also that a neighbor had attempted to talk with Ms. Rooks' son about some resources. She specifically mentioned caregiving resources.
I'm going to object to the hearsay.
Your Honor, this witness has already testified. It would be Kathy. I mean, I can tell her if she recalls the name.
Okay, but the fact that the person has testified doesn't make it hearsay. This could be prior consistent statement, although it sounds like what the doctor reviewed would be reports as opposed to having interacted directly with that person.
Right, she's reviewing a summary of the reports so she did not interview Ms. Alston.
Okay. So if you think there was an impeachment of Ms. Alston such that her prior statement, not to Dr. Holmeyer, but prior statement to X, wherever that is, then there may be a basis to explore that. I'm not quite sure.
No, Your Honor, I don't believe that she was impeached. I believe that Dr. Holmeyer is going through.
I know what Dr. Holmeyer is doing, and Dr. Holmeyer is free to rely on hearsay, but the hearsay doesn't come in through her testimony. She could say, I read reports from Ms. Alston, but she's not a conduit through which you can get the contents, the hearsay, what was said being offered for the truth of the matter asserted. Now, if you're not offering it for the truth of the matter asserted, you're not relying on Ms. Alston being truthful about that. It's just what would inform the doctor's opinion. That's different.
And that's where we are. What informed her opinion based upon what she read, whether or not we believe that Ms. Alston, because she testified to it, and the jury can determine her credibility of what she testified to, but that Dr. Holmeyer is reviewing these records and going through what she reviewed.
So this was an area of concern for her because, and then the content of the statement. Okay, I'll allow it in.
We continue.
Okay, so this neighbor had, in her statement to police, stated that she had talked with Ms. Rook's son about some possible caregiving resources and actually maybe assisted living facilities or facilities, and gave contact information for some of those, and was told that that wasn't needed.
And did you have the occasion to review some videos provided to you of Ms. Rooks?
Yes, I did.
And were there anything with those videos that were that factored into your analysis?
I think the significant thing about the videos that I saw were that in 2013, Ms. Rooks was robust, still able to walk, but clearly having cognitive issues, having difficulty really understanding her bills and why her bank's name had changed, and really struggling cognitively. And then in 2016, there was a clear, obvious decline in her physical functioning. She's now lying on the floor, touching feces. Clearly, her cognitive impairment has gotten worse, as has her physical abilities.
And then the medical examiner's reports and autopsy photos. Were there anything on that review of information that factored into your report?
Yes. So the medical examiner described Ms. Rook's body as being slightly underweight, matted hair, dirty, with feces caked on her and urine soaked, with multiple wounds that had flies and maggots of different stages on her body. There was also poor dental hygiene. Gingivitis was evident. And then there was a description of multiple pressure wounds, 3 of which were very severe and showed signs of infection.
Now, when you talk about pressure wounds, is there another name for pressure wounds?
Pressure ulcers?
Okay. Are they sometimes called decubitus ulcers?
Yes.
Okay. And if you could tell the jury a little bit about what is a decubitus ulcer and how are they generally?
Yeah, so there are a couple of factors involved in the development of a pressure wound. So a pressure wound is basically just a wound to the skin, and pressure is the biggest factor. So if you're sitting on one spot for a long time, the skin under that spot develops pressure and then starts to die if we don't move. So we're constantly shifting in our chairs and moving or rolling in our bed so we don't have pressure in one spot for a long time. So pressure is the biggest factor, but moisture also plays a role. So if somebody is sitting in one spot but also has moisture from urine or sweat or feces, the skin breaks down even easier. If they have immobility and they're unable to shift or move, that increases the risk of these developing. And if they have poor nutrition, that increases the risk of these developing.
And can decubitus ulcers or pressure wounds or pressure ulcers become painful?
Yes.
Why is that?
Well, especially in the early stages, when any of us get something that ulcerates on our skin, there's a burning sensation of pain that's associated with that. As the wound becomes deeper, it can get infected, and the infection itself can cause pain.
And if one has an ulcer or a decubitus ulcer or pressure wound, are they able to be treated?
Yes.
Now, you identified about 8 items that you reviewed. Did you review the entire case file as it relates to this case?
No, I did not.
And was the information provided to you enough for you to make a decision based upon what you received about what we will talk about later, about whether or not this was neglect or could be consistent with neglect or not?
Yes.
Now, after your review of the documents and the items that you reviewed, did you determine or see any signs or markers of neglect?
Yes.
Okay. And how do you determine what signs or markers of neglect were present?
Yeah, so as I review the records, when I look at a case like this, I look for some of the markers that are discussed in the medical literature about what are the things that we sometimes see in these cases of neglect. And so in this case, I identified 9 of those markers that are documented in the literature.
Okay. And let's start with, what was the first marker of neglect that you found?
That there were risk factors present for neglect. So that's the first marker. And in this case, Ms. Rooks clearly had both cognitive impairment and then towards the end of her life, physical impairment where she could no longer move herself. So there was no way for her to really access any help or care. She was completely dependent on other people at that point. So that is, those are both clearly risk factors for her. She also displayed some of the difficult behaviors we sometimes see in patients who have cognitive impairment or dementia, meaning, pulling down their pants or playing with feces. It's just a difficult thing to deal with as a caregiver. And that is known to be a risk factor. The more difficult the behaviors are, the harder the care is, the more likely somebody is to be neglected.
And what was the second risk factor that you observed?
So the second factor that I noted was a neglect to seek medical care. Ms. Rooks had been seeing the doctor in 2013, saw the doctor once in 2014 from the records that I received, had 2 emergency room visits, and then there was the last emergency room visit was in 2015, and then there was no medical care documented that I was able to see in that entire time. And one would expect a reasonable caregiver to take somebody with dementia and high blood pressure and diabetes and the inability to walk and pressure ulcers to care.
And let me ask you this, in 2015, I know, do you recall from the records why she had to go to the emergency room in 2015?
Yes, in 2015, so I think it was March of 2015, she went to Atlanta Medical Center. 911 was called to the home. I don't know who called, but the emergency personnel came out. She was found on the floor, again, just lying in urine and feces, and was very confused.
Now, what, you said there were 9. What was the next risk factor, the third risk factor that you noted?
Yes, so the third factor was a delay in seeking care. And by this, I mean that Ms. Rooks' son called 911 after she died. And there was many opportunities to call 911 sooner. And I think in my experience as a geriatrician and dealing with families who are caring for people with dementia and pressure wounds, people might call 911 when somebody can no longer walk or is no longer eating, or if they notice wounds on their skin at all, or if they're basically unable to get up off the floor. So I think there was a delay in seeking any sort of emergency care until after the fact.
And are you referring to that kind of weekend prior to her death, after he had pulled her off of the couch, that there was a failure to seek care in those 3 days leading up, 5 days leading up to her death?
Yes.
What was the next risk factor that you found?
The next factor of neglect was a neglect to provide adequate caregiving. And Ms. Rooks' son in August of 2013 was given information that, she clearly has cognitive impairment, and this is the hospital that told him she really cannot stay alone anymore. And that he should really start to look at other options, talk to her physician about possible placement even.
What was the next risk factor?
The fifth marker are the pressure wounds. There were multiple pressure wounds on her body, most of which were fairly shallow, what we would call a stage 2. However, there were 3 very large pressure wounds that went down very deep to the subcutaneous tissue and even down to muscle and possibly bone. And these are high risk for infection, and the infection can travel all over the body once it gets to the bloodstream. And so those are more dangerous wounds.
Now, you just talked about stage 2 and maybe like stage 4. So can you explain what would a stage 2 also look like versus a stage 4? And would there be a skin graft or anything that can assist you with your testimony?
Sure, yes.
I'm going to show you what I've already shown the defense counsel states exhibit 139. What states exhibit 139 assists you in explaining how you determine the difference between stage 2 and stage 4.
Yes. Yes.
Your Honor, this time state by Tennessee states exhibit 139 into evidence for the.
All right, 139 is being tendered as a demonstrative aid. Any objection? Admitted.
Permission of the question.
Yes, ma'am.
Oh, yes.
All right, if this could assist, if you can explain the difference between stage 2 and a stage 4 ulcer.
Sure. So we usually talk about, there's actually 6 stages, but there's 4 basic stages of pressure ulcers. So the first is just that the skin becomes red and doesn't return to its normal color. And so that's usually an impending sign that there's going to be more damage to the skin. A stage 2 ulcer goes through those 2 top layers of the epidermis and the dermis of the skin and just usually looks like a shallow ulceration. A stage 3 ulcer goes down into where the fat is, which is the yellow stuff. And you can see there's blood vessels there. So that becomes more dangerous because infection can get into the blood system. And then a stage 4 wound goes down to either muscle or tendon or bone.
And some of the ulcers that you observed were that stage 4 that went on down to either that fat or that bone.
Yes.
And again, I believe as you mentioned earlier, would that be painful for someone?
Yes, definitely deeper wounds are painful in the initial stages. There's some controversy about that, that the longer they're present, actually nerves may deaden. And so they may not be as painful if they've been there for a long time, but in the development of them, they would be very painful.
In the development, but sometimes because there's no more nerves, they don't feel.
Right.
Now, what was the next risk factor be?
Poor hygiene. Poor hygiene we see very commonly in neglect. And in this case, Miss Rooks, was found a couple of times lying on the floor in her own urine. But at the end of her life, was clearly found with matted hair lying in feces and urine with flies and maggots on her. Clearly wasn't receiving good hygiene and was also not clothed.
What was your next risk factor that you noted?
Malnutrition and dehydration. And this just basically speaks to the fact that she wasn't receiving nutrition or anything to drink really for those last few days of her life, which is not going to allow her to really heal any wounds or fight off any infection.
What was the next risk factor?
Isolation. And I think I mentioned some of these factors already, but the fact that Miss Rooks was kind of kept behind a door that was locked and was unable to get out, and other people were unable to come in is one form of isolation. The fact that there was a dog that prohibited some people from feeling comfortable coming into the home, isolated her from certain people in her life. The fact that the telephones were not working in her home isolated her from other people in her life.
Okay. And the last risk factor, if you can only focus on the 2013 report and if that was a risk factor.
Yes, so the last factor that I looked at is the fact that there had been a prior APS report. And so there is more of a pattern here of neglect of care as opposed to just a one-time incident.
Now, Dr. Homeyer, in your knowledge and your training and your medical opinion, when you look at the totality of all these risk factors, were these risk factors consistent with Ms. Rooks being neglected?
Yes.
And given your medical training, if Mrs. Rooks would have received any type of medical care for maybe some of her pressure wounds, or she received any type of nursing care at home or at a facility, or even if the weeks leading up to her death, she would have gotten any emergency care. In your opinion, could her life have been prolonged?
Yes,
Why do you say that?
because her wounds at the end of her life were definitely treatable wounds, and could have been prevented, I think, if she had been getting routine care and if she had had adequate caregiving in the home, was being given proper nutrition. If she had a caregiver who understood that she needed to be turned and shouldn't be lying in one spot, if she had a proper, maybe even just mattress to lie on the floor, or a special mattress that helps prevent pressure wounds, that could have been helpful. If she could have been kept from lying in feces and urine, all of these things could have helped prevent those wounds from happening. But even once the wounds happened, they could have been treated. It's not easy to treat pressure wounds and they take a long time to heal, but the infection from them can be treated and then the wounds themselves can slowly heal.
And then, but some of her other medical care, those things could have been treated as well. Some of her other medical conditions, I'm sorry.
Oh, yes.
Going back to the pressure wounds, about how long does it take to kind of go through those stages of from even stage 1 to stage 4, if you can give an approximation?
Yeah, there's a lot of controversy about that as well. So, I mean, sometimes when we have a patient in the intensive care unit in the hospital, even with the best of care, they can develop pressure wounds if they've got tubes and stuff and can't be turned adequately. And that can happen fairly quickly if they're completely immobilized. So, pressure wounds can happen quickly if somebody is not moving at all. If there is some movement, and maybe some care for moisture and some of those other factors that we discussed, it can take a lot longer than that. But to develop stage 4 is definitely a process that takes at least a few weeks to develop.
Thank you. You have no further questions, Your Honor.
Mr. Korn,
Thank you.
you're welcome.
I like podiums. I'm old school that way. Good afternoon, Doctor. My name is Larry Korn. I represent the defendant Hilius Rooks. You indicated that you reviewed the 2000, what year was the Atlanta Medical Center report?
August of 2013 was the first visit.
You indicated that you saw a signature and you attributed that to Mr. Rooks.
Yes.
Right. Were you present when he signed that?
No, I was not.
So you don't know for sure it was him that was his signature, do you?
No, just that the medical notes actually say that the patient and the son were present for this discussion that they had regarding this.
Okay. In reviewing your report, I noticed large chunks of it reflect almost identical, if not identical, to the report that Dr. Detective Leon Packer wrote. The report you reviewed, did you just cut and paste that and put it in your report?
Yeah, so the way that I do my reports is I take pieces of the medical record as well as pieces of the investigative report that stand out to me. And then my opinion is at the end.
Okay. And, but you didn't interview any of the people involved?
No, I did not.
You did not conduct an autopsy of Ms. Rooks?
No, I did not.
And you did not, I mean, you're not a forensic pathologist, I assume.
No, I'm not.
When you reviewed these materials, did you actually listen to or watch the interview with Mr. Rooks, or did you just rely on the detective's summary of the report of the interview?
No, I did not. I was not given the interview to review. I simply read the report.
So you just looked at whatever the district attorney gave you, correct?
Yes.
Okay. The folks paying the bills.
Correct.
So, and you did not have a copy of the audio or video interview, correct?
No.
Okay. So if there were any discrepancies between say the summary and what he actually said, you're just relying on the summary, correct?
That's correct.
I think you indicated the pressure wounds, they're also called bed sores, correct?
Yes.
They can happen in a hospital setting as well,
Yes, they can.
in a nursing home setting as well.
Yes.
In fact, in nursing home, there's many cases where bed sores received in nursing homes don't get treated. Isn't that correct?
What do you mean? I'm sorry, Kate.
Well, you've made a study of geriatric medicine, and I assume that includes folks in nursing homes, correct?
Yes.
And people receive bed sores in nursing homes.
They can develop a pressure ulcer in a nursing home. Yes.
Right. And sometimes they go untreated in some nursing homes, correct?
Oh, I see. Are you asking me if people can be neglected in a nursing home?
Yes.
Yes, that can happen.
Now, I want to add a little bit of information to the information you have. What if, and I'm asking hypothetically, and you're an expert, so you can answer hypothetically. What if Mrs. Rooks had refused to get medical care? What if she didn't want medical care?
I would ask you, at what point in her dementia is she saying that?
Let's say very early on, say 2013.
I have seen documents that she did get medical care in 2013.
Let's pare that down a little bit more. What if she had told her son or anyone else who was also caring for her? What if she told anyone who was caring for her that she wanted to live the rest of her life in the home in which she lived her entire adult life? Would that change any of your opinion at all?
Absolutely not.
Because
Because care can be provided in the home. In fact, that's the best way to provide care for older adults who have dementia.
And does that ever cost money?
Certainly it can, yes.
Yeah. So you've seen the pictures that were taken because they were in the report, right? Of the scene?
Yes.
Would it be fair to say that these were not people of means?
I don't know that I would say that.
Okay. Were you given Helios Rooks's income statements?
No.
Okay. Do you know what these special mattresses cost?
Yes, I mean, I know that they're quite expensive. However, I also know that insurance sometimes covers them.
And if a person isn't insured?
Then it would be very expensive.
Okay. Thank you. I don't have any further questions.
Ms. Hilton, redirect for Dr. Homemeyer.
Yes, sir. Yes, sir. How much do adult diapers cost?
I don't honestly know.
I'm sorry,
I don't.
didn't hear the question. I'm sorry.
Adult diapers? Are they cheaper than the mattress?
Absolutely.
Much cheaper than the mattress?
Absolutely.
How much do wipes cost? You know, like baby wipes or any type of wipes to clean up feces off your booty.
Didn't know she was going to be on the Price is Right.
Sorry.
Tough.
Is that inexpensive in comparison to the mattress?
Yes, of course.
Now, hypothetically, if someone may be receiving approximately $4,000 a month in pension payments, an older person, could that be enough to help in providing some in-home nursing care?
Certainly. I mean, I don't think $4,000 would pay for full-time nursing care, but it could certainly provide for some.
And in your opinion, would at least some care, given the case that you just reviewed, if she would have gotten at least some care, could that have assisted in prolonging her life?
Yes.
No further question.
On the other hand, could it have not necessarily prolonged her life?
Yes.
Okay. Is it your experience that people who wear adult diapers sometimes pull them off just because they're not comfortable to them?
Yeah, certainly.
Especially people with cognitive disabilities such as dementia?
Yes, that can happen.
Thank you. No further questions.
Jurors, do you have questions for Dr. Holmeyer? Okay. Doctor, thank you so much for your time. Have a great weekend.
Thank you.
Ms. Hilton, do you have other witnesses for today?
Could have another witness for today, who could be short, well, I don't know how far, I don't know where he is.
We've got 20 minutes and it's progress we're making in the case. We ended earlier than you thought. I'm not going to make anyone stay late, but we've got 20 minutes that folks ought to be here. And so if we could work through a witness, let's do that. That just means less work for the jurors next week.
If we can get a few minutes, he's just over in our office, our investigator, we need to get him over here, and he so much we get him some time, we should be done by 5 o'clock.
We'll tell them to run. I've got some good news. You do what you need to do. The ironically named facilities maintenance team for the county government is DREAM, and it's an acronym for something. But DREAM has fixed the leak. There was a loose valve in a sink that needed to be tightened. It's been tightened. That's half the issue, so it won't leak anymore. DREAM is sending cleaning people to get all the moisture out of there. So good news, leak fixed. Better news, they're mopping that up. I'm gonna have you stay right here rather than disperse. If someone needs, you're welcome to stand. If you really got to use the restroom, please just go one at a time. But do we know that the investigator is on his way? You guys just seem to be standing around. Excellent. A bonus witness.
All right.
Who is the witness?
This will be investigator Shay Porter.
Okay.
Ms. Hilton, do you want this? I can move it back if you.
No, sir.
If it, does it block your view? That's why you're moving it again?
Yes.
Okay. Isn't your office just across the hall?
Yeah. No, but he's no, he's in a different, he's in 141.
Okay.
Sorry. Yeah, he's in 141.
Does he have short legs?
No, he actually tall, so he's trying longer.
All right. Look forward to seeing him shortly. So the cleaning people are being slower than the plumbing people, but if it has to be someone as slow besides the DA's investigator, it might as well be cleaning. It'd be bad if they showed up before the plumber did.
I think he's briskly walking in, Your Honor.
Ms. Willingham walks briskly. He needs to learn from her. That's some speed. That DA bodyguard was bigger than you, man. When he walked in, like, uh-oh. I noticed you went across the room. Like, if he sees me standing next to him, he'll see how small I am. That's a big dude. Hello.
Oh, I'm out of breath now.
It's all right. As long as you can talk.
We swear affirm that the testimony you give will be the truth, the whole truth, and the truth forever. Yes. Go ahead and have a seat. State your swear name for the record.
You may, please.
Senior Investigator Shay, SHAE, last name Corso, CORSO.
And thank you for running over here. I probably owe you lunch. Where do you work?
Fulton County District Attorney's Office
And how long have you been with the Fulton County District Attorney's Office?
since October of 2021.
And prior to working at the Fulton County District Attorney's Office, where did you work?
The Smyrna Police Department.
And what are some of your job duties and responsibilities as a senior investigator with the Fulton County District Attorney's Office?
Investigate cases and prepare for trial.
Now, where are you currently assigned? What unit?
Anti-corruption unit,
Prior to the anti-corruption unit, what unit were you assigned?
the Special Victims Division, specifically the Domestic Violence Unit.
And while you were assigned to the Special Victims Domestic Violence Unit, were you asked by me to send a subpoena request to Georgia Tech for payroll records for Ahelius Rooks?
Yes,
And did you receive such records?
I did.
And when you sent the subpoena, did Georgia Tech give you a certificate of authenticity as to those records?
They did.
I'm showing what's already been shown to defense counsel, Stacey Division 146. If you can take a moment, open up Stacey Division 146 and tell me if you recognize Stacey Division 146.
Yes,
And how do you recognize Stacey Division 146?
these were the items that were sent back in correlation with the open records.
And was there a certificate of authenticity sent along with it?
There was.
And is this a fair and accurate depiction of what you received from Georgia Tech based upon a subpoena that you sent?
Yes.
You're on this time to state by Attorney Stacey Division 146 and evidence.
Any objection, Mr. Korn?
No objection, Your Honor.
The Georgia Tech payroll records are admitted.
Now, have you been able to review those records?
Yes.
And what was the time frame for the payroll records that you received?
The year of 2010 to 2017.
And looking through those records, approximately how much was Phileas Rooks paid?
On average, approximately $500 to $800 a pay period.
And how often was those pay periods?
Every 2 weeks. It was bi-weekly.
I have no further questions.
Mr. Korn, do you have any questions for Investigator Corso?
Could you tell from those records what kind of deductions she had?
Not necessarily.
No further questions.
Any follow-up?
No.
Any questions from the jurors? All right. Thank you for hustling out. You can walk back.
I'm gonna run back.
Go for it. Have a good weekend.
Thank you, guys.
And with that, ladies and gentlemen, I think we'll wrap for the week. Ms. Hilton, if things go as planned, which is not always the situation with trials, and we start at noon on Tuesday. I had said 11, but I worry that if we say 11, you all will be sitting around a little bit before we can get started. So if we start at noon on Tuesday, when do you think you'll be in a position to? Yeah, we'll talk. Ms. Patillo, you and I are talking 9 a.m. for you. No. How long do you think the rest of your case will go?
Your Honor, at best, is it technically your Honor, so that could take some time, but we should rest. If not on Tuesday afternoon, no later than Monday for the last one. We only have 2 witnesses for that.
Okay.
Wednesday morning, so we have 2 witnesses.
You have 2 witnesses left. They're substantive witnesses, at least one of them, from what you've shared with me and the defense. But at the latest, it would be Wednesday morning at some point that you rest.
And it all depends on who the second.
Okay, got it. So we're on schedule. That's good. Mr. Korn, well, we'll talk later about that. So noon on Tuesday, the bathroom will be very dry by then and the leak's been fixed. Please have had lunch. Don't think you'll get here at noon and like, hey, we're ready for our lunch break. So make it brunch, but have fed yourself if you're going to eat something for that noonish time meal. And we'll try to have, other than the afternoon break, a good pocket of time. It'd be great if we can go a little past 5. If the rest of your life allows you to go past 5 that day, gosh, I'll get 6 minutes from you because we're ending early today anyway. But if we can push closer to 5:30 or later that one day, because we're starting at noon, that'd be good. Although what I'm hearing from Ms. Hilton is it may be the state's resting anyway, and that's a natural break point. If the state rests late on Tuesday, we'll get you out of here, and then we'll need to take some things up outside your presence. This is a longer break than usual. It's a 3-day weekend, and it's really a 3.5-day weekend because I won't see you until noon, 11:45 for Ms. Patillo. I just want to remind you of your obligation to not have any meaningful interactions with people outside your group about what you've been doing. Someone's going to want to talk to you about where you've been and what's been going on, and tell them you can give them substantive answers later. But for now, it's just been a fun ride with the judge, and leave it at that. And nothing more. And please, no outside research. You have demonstrated that you know how to write down questions. That's the way to scratch that itch, and not by talking with others or going online or reading a book. Any logistical questions from anyone? Ms. Patillo, is your Tuesday going to be a particularly busy Tuesday, or you think you can be here on time?
You on time.
Amen. Yes, ma'am.
Sorry, this Wednesday and Thursday, anticipate full days for those.
Not necessarily. Well, if your question was, are we going to start finally at the normal time, Judge? Yes. So Wednesday, I would expect us to start at 9 a.m. Tuesday's the one funky situation, other than today it was lunchtime. So definitely Wednesday we'll start at 9. Is it a full day? I don't know. It may be that you get the case and you're deliberating and you reach whatever verdict you reach on Wednesday. Once the case is yours, the hours become yours, meaning you may say, whoo, it was draining with the closings. We want to deliberate for a couple hours and call it quits at 3 on Wednesday. And then you will come back on Thursday. If you say it is easier for everyone to be on time, if we start at 10, then maybe you decide to start at 10. I don't dictate when you start or stop once it's deliberations. I'll let you know the juror dynamic is usually, it looks like we're getting close to resolving. Could we stay a little late that day rather than come back for a half hour the next day? 100% the collective decision of the jurors. So the times that I set, noon on Tuesday, and we'll go as late as your schedules allow, past 5, not later than 6 on Tuesday. Wednesday, we will definitely start at 9 because there'll be some part of the case left, whether there's a defense presentation or not. No burden on the defense. They may present nothing. There still will be closing arguments. Then I have to give you the law that you must apply to the facts as you find them. So we'll be together on Wednesday, and that'll start at 9. Did that answer your question? All right. Any other logistical questions? Remember to leave your notepads in the jury room. We'll close it up. They'll be private, safe in there. And we'll see you all no later than noon on Tuesday. Good 4th of July. Be safe.
All right, sir.
All right, you all can be seated. Reminder, jury charges no later than when? Monday night. You go to bed Monday and you haven't sent in jury charges, don't expect to see the jury charges you want in the charge. You can get them in before then. Email them to Ms. Nelson and Ms. Niles because Ms. Niles doesn't jump on that Tuesday morning. Monica? So monica.niles. If you get them to Ms. Nelson, she'll forward them, but that's my staff attorney. She's the brains of the shop, so she'll be doing the jury charges. Ms. Hilton, do you have anything else we need to discuss before we go off record?
Nothing else on the station.
Mr. Korn?
Nothing from the defense.
Given Ms. Hilton's announcement that there are only 2 witnesses left, I would ask that you and Ms. Jenks start talking with Mr. Rooks about his thoughts about what he wants to do once the state rests. No decisions need to be made now. I'm not asking. That's actually 4 days from now. But the next time we're together, we're only 2 witnesses away before resting and any motions you have, and then your decision about evidence. Okay?
Certainly, we have been discussing that.
I'm sure you have. Just want to make sure we don't hear the state rest and then, we need 2 hours to talk with our client.
No, that won't be necessary.
Okay, great. Then we will go off the record.